Hey, you guys. Good morning. I'm sure it's not morning by some of you, so good afternoon, good evening. Um, Before we get into the hearing today, I thought it would be a good idea to do a quick recap of the filings that came down on Thursday, so yesterday, as well as a quick little briefing on what's going on with the Cop City RICO, because Joseph Bapp is also covering that. So on the screen right now is Thugger Daily's quick updates from yesterday. Really, one of the big ones was the official written order denying the disqualification of lawyers Love and Hilton. So what's funny to me is the order denying it uses the language that Steele uses. So in the header here, they just copied the title of his motion, but it means lawyer with instead of Chief Deputy District Attorney Adrian Love, or I forget what is it just Assistant District Attorney for Hilton? But I thought that was pretty funny. So her reason being, let me make this a little bigger for you guys. Her reason being here, down here at the bottom, and this is just an image, so I can't highlight it, but under Rule 3.7 of the Georgia Rules of Professional Conduct, the party moving for disqualification of a lawyer, which would be, Jeffrey Williams, Brian Steele, Keith Adams, must generally show that the lawyer is, quote, likely to be a necessary witness by demonstrating that the lawyer's testimony is relevant to disputed material questions of fact, and this is the key part right here, and that there is no other evidence available to prove those facts. So here, it's noted that the emphasis is added. So Judge Whitaker herself italicized necessary, relevant material, and no other evidence available to prove those facts. So in other words, we heard it orally, we heard this counter argument made orally, but the transcript is the best evidence we have. That's the line of argument that Judge Whitaker is following here to say it wouldn't be necessary to call Love and Hilton, and since they don't need to become witnesses necessarily, this doesn't rise to a situation where it would be necessary to disqualify them. There's also a footnote on the second page that I thought was important, and I don't think you guys are going to like it. I do not think you guys are going to like this footnote. But here we see her mention that, it is in fact the transcript. For the Kelly and Bennett text, the texts are in evidence. And the transcript for the June 10th ex parte, it's filed. Everybody was provided an official transcript. So there are other sources readily available to establish the content of all three. But this footnote here, you guys are not going to like. Because what does Judge Whitaker say? On the date, here we go. On the date that this motion was argued, July 30th, 2024, and prior to the motion being argued, it was placed on the record by the prosecution that a brief ex parte discussion between these two prosecutors and the predecessor trial judge occurred in the courtroom on June 7th, 2024, alerting the judge to the potential need to have the eventual June 10th, 2024 ex parte meeting. A rough, unofficial transcript of that June 7th discussion was immediately ordered by this court and was secured and provided to all counsel at the close of the July 30th proceedings. This court encompasses that June 7th ex parte discussion as well in its consideration of this present motion. So in this denial, she's including everything that we all just learned and the defense just learned about June 7th. So, that's why footnotes are important, you guys, because stuff like that gets added in there. And Judge Whitaker is saying, including June 7th, I don't find a reason to think that we need to call either of these prosecutors as a witness. The transcripts speak for themselves, and I'm denying your motion to disqualify them. So, hey to all of you guys. I do have Law and Crime sitting up. We can toggle over there as soon as they go live. But we're just looking at all the filings that came in yesterday to get caught up. There were also some written orders that filed through. I think some of them were actually written on Wednesday, but they came through yesterday. Just things like the actual written order denying the state's motion to restrict extrajudicial statements, the written orders denying the bond, and remember, the Diamante Kendrick's bond motion is still outstanding because Doug Weinstein had asked to defer until after his motion for mistrial is ruled on, which is still open. And then we also get if you tuned into the whole day on Wednesday, towards the end of the day, Brian Steele started arguing about inherent fatal flaws in the indictment. And Judge Whitaker seemed tuned in, but she issued an order denying it, and she cited a very recent case. She also denied the certificate for immediate review. But there's two things I want to look at in relation to that. First is Brian Steele's renewed motion itself. So she had asked him to put it in writing, so he had filed this on Wednesday, and he's just making the same thing. Like, if you look at these specific counts, they're fatally flawed because they don't discuss the intent. They don't say that these people willfully, knowingly, recklessly, intentionally thought they were joining a gang and chose to join a gang. So it's missing the mens rea component, an element that's necessary to, not just prove their case, but also for us to know that you're going to make that argument so we can defend against it. And we're going to look at the reasoning for the counter argument here, but Brian Steele attached as an exhibit the order from Glanville denying it. And he had stated in court, and I went back and double checked because I'd seen that some people weren't sure what he was talking about. But Brian Steele had said, when talking about this specific plea in bar and Jamura that he had written and submitted in November of 2023, after they had oral arguments in December, I think on December 11th, that he said the state wrote an order denying my plea in bar, which the recused judge signed off on. And so I went and looked at the exhibit because it's attached. And you can see it's stylistically the exact way we've seen the state write. The same bolding and capitalization for certain things. Unlawfully conspire. All these important things are bolded. It looks exactly like the documents we've seen filed by the state. So I thought it was interesting that Steele called that out. Steele said, Love, the state wrote this motion, wrote this order. It mirrored their oral arguments. And then Glanville adopted that as his order and just put his signature at the bottom of it. All the way back in 2023. And I'm sure it is hard to see on the screen, but I promise it's just looking at it on its face. If anyone has good eyes in the chat, you can vouch for me. Like, this is exactly how the state writes their motions. Highlighting and capitalizing just like this. We didn't see this stuff in, for example, Judge Glanville's show cause filing when he made an order to show cause. He didn't write like this. All this bolding. So I probably do think that it was the state, in fact, that wrote this motion, drafted this order for Judge Glanville. And then anything else we've got? I don't think we had much. Oh, we had proposed jury instructions yesterday. So we've got like 4 minutes. Because I still don't see the feed live for Law and Crime. So we've got like 4 minutes. Let's toggle over here. So Brian Steele, everyone was asked, like, you guys brainstorm, come up with some ideas on how you want to address this issue of what to tell the jury. Now, this isn't jury instructions for dealing with Lil Woody and Kenneth Copeland's testimony. This is just about dealing with Judge Glanville no longer being there. So I want to see real quick if you guys have any thoughts about the motions we just looked at, and then we'll read these real quick. So what we're seeing that was approved was in part the motion for a fair trial. That was approved. She also approved the defendant's request to know about any more ex parte meetings and be able to look at any sealed filings that they may not have known about before. So in part, we got some stuff approved. And then, there was no court yesterday, you guys. No court yesterday. Hey, everybody. Good morning. Good morning. And then let's see. Let's get these quick instructions because Law and Crime, I'm sure, is going to pop up in 2 minutes. So just as a proposed language, in light of the recusal of Judge Glanville, Mr. Williams respectfully requests this honorable court provide the following instructions upon the return of the juror to court for trial. Ladies and gentlemen, Judge Earl Glanville is no longer the judge presiding over this case, which you have been selected and sworn to try. Judge Glanville was removed as the presiding judge in this case. You are not to concern yourself with this change. In a trial, none of the decisions of the court and nothing any judge says is evidence. The decisions and remarks of a judge do not mean the judge favors or leans to one side or another in this case. You are to disregard any comments made by Judge Glanville that were disparaging of the defense lawyers in this case. To maintain the integrity of the jury system, I remind you that you must decide this case based only on the evidence admitted during the trial and the law I will explain to you. And then that was the only page that was attached, but I did see a citation at the bottom where he's saying I'm pulling this in part from like the rules, like the Georgia rules. So that's what he's proposing. I'm sure we'll see this argued orally. And I believe they might be talking about pleas today. And we're about right on time. Let's see if this stream is starting. I'm just going to share this tab just so we can see when it goes live and I don't miss anything. I'm going to pull my banner down. Okay, so we're starting at 9. All right, I was going by the 8:45 time with Law and Crime, so you might be right. We might have 15 minutes, which is good because then I have my sound on, so that will autoplay. Has anybody been following the Cop City RICO? Because yesterday we heard something happen that was a bit reminiscent of what we heard going on with the Fulton County RICO against Trump and his co-defendants, where really what people focused in on was that disqualification hearing with all the tea about Fonnie Willis and Nathan Wade. Let me pull this up. Oh, and Suri Shada Jimenez is part of this. Okay, cool. So that's, when I talk about Doug Weinstein, he's doing his podcast on Twitter Spaces. Shada Jimenez, Doug always calls him Suri. I guess it's his first name, and his two last names are Shada Jimenez. That's why I'm always confused. Now I understand seeing it in writing. But he's a defense counsel on this Cop City RICO case. Yesterday we find out, and I think we've heard rumblings about it, but they were arguing in court to defend. The state was trying to defend that they didn't use a filter team to make sure they weren't taking attorney-client privilege information, work product. And not only did they come into possession of it and refuse multiple requests to use a filter team, but they started disseminating that material to other parties. So Joseph Papp was covering this tweet by tweet. He was, that's how he was reporting. And so it started with Don Samuel, who represents Marlon Scott Kotz, a defendant in the Cop City RICO, talks about the raid at Teardown House on May 2023, and that he told John Fowler that he needed a filter team to ensure he didn't see attorney-client privilege information/communication. Samuel's going through most of his information already in the motion to disqualify the AG, so the Attorney General's office. Samuel said that they were never told that Google had been served a warrant by Atlanta Police Department and didn't know the extent of the documents that they had acquired, which Samuel says included attorney-client privilege. Samuel said he continuously told Fowler that they needed a filter team, while unbeknownst to them, they already had the email. There seems to be some confusion between Judge Adams and Samuel about how Samuel wants to proceed and how Adams wants to proceed. She wants to hear the argument and not hear the same thing that was in the filings. Samuel's going through 15 exhibits he plans to introduce. There seems to be some problems with the list of exhibits because Judge Adams is trying to follow along with the paper Samuel gave her, but apparently is not in the order. So they call up a witness, Detective Ronald Sluss, who was involved in the investigation. He said that he dealt with John Fowler at the AG's office. Sluss participated in the search of the home. Sluss said he talked to Fowler about 2 months before the Google search warrant was issued for the email addresses. The search warrant was made a couple months after the raid. Sluss doesn't recall having any conversation, he's saying he doesn't remember, about possibly acquiring attorney-client privilege in the search warrant. Sluss had a team of 4 analysts with the APD go through the documents they gathered from Google and that they should be looking for communication relating to defend the Atlanta Forest Movement. Sluss said that he hadn't read the reports. I would not allow anyone to delete evidence, Sluss said, about what they would do to documents that they needed to exclude, including attorney-client privilege. Sluss said the AG's office receives everything, including the raw data. Sluss said they were told to look out for some names in the report, including Attorney Samuels and Attorney Siri Shada Jimenez's name. Sluss said he never looked at the reports and just sent everything over to the AG's office. Sluss said he never read any email between a lawyer and a defendant. So just take my word for it. Next witness is an analyst with APD. She was asked to analyze certain documents. And we're still not live over at Law and Crime. The analyst said she received emails from Sluss and wanted people to go through them. Sluss told the analyst, said they were looking for anything that linked the people of interest, Savannah Patterson, to what was going on with the protests and any financial connection. The analyst said Sluss said the matter to review the emails was urgent and needed it back quickly. The analyst said they were told to disregard any emails between attorneys and defendants. The analyst said she came across emails between Savannah Patterson and several attorneys and just kept moving instead of telling anyone. She didn't communicate with any law enforcement agency other than APD. So really, there should have been a filter team before it got to this analyst. It shouldn't just be the analyst that's told to disregard something that might be between an attorney and a defendant. This should have been filtered already. And then we also get acknowledgement from this analyst that she did see communications in here between Savannah Patterson and several attorneys. So she saw it and just kept it moving. It took the analyst months to go through the emails. The analyst doesn't recall any of the communications between Patterson and the attorneys. She never communicated with anyone about any emails between Patterson and the attorneys. The next witness is also an analyst with APD. He was trained back in July 2023 and it was one of his first assignments. The analyst said Sluss told them not to include anything about attorney-client privilege and not to tell anyone. Judge Adams asked the AG's office why they didn't establish a filter team. It never crossed anybody's mind. Guys, put a 1 in the chat if you've heard of a filter team, or sometimes it's called a taint team. Put a 1 in the chat if you've heard of this and you understand the concept. Because if lay people are starting to understand the purpose of a filter team, why wouldn't it cross the Attorney General's office and their staff to create a filter team for something like this, where they're rating and obtaining documents that very likely contain work product, attorney-client privilege? Okay, still no live on the Law and Crime. Dixon claims that nobody has read the emails that contained attorney-client privilege. Dixon said she felt sick when she found out about it as a prosecutor and officer of the court. So the prosecutors were arguing orally in court yesterday, like, I didn't know and I felt sick when I found out. Dixon argues that they didn't get to the point of purposeful intrusion, that a disqualification is warranted. Dixon said they recognize that there is a basis for the motion, but as far as whether they should disqualify or dismiss the indictment, there is no basis to do so, and calling to do so would be extreme. Don Samuel, so defense, argues that the state sent all those emails to the attorneys representing the other 60 defendants. Oh, don't worry, we didn't tell anybody. We told the 2 analysts to disregard and not communicate. Oh, but we sent the emails to 60 other defendants that may be interested in building their own defense, and that defense could include something they see in our emails that they want to use against my client. Judge Adams is not ruling today on the motion to disqualify the AG's office. I'm not going to cut the state any slack, Adams telling them that it's unacceptable what happened with the emails. Adams said these are mistakes prosecutors should not be making. Adams said that what the state did, though, was negligence more than purposeful intrusion. Don Samuel said he feels it's purposeful because he told them multiple times they need a filter team. They just didn't care. So Adams reiterated that he's taking the argument under advisement. So what do you guys think of that? Here we go, we're live.
That's a legitimate charge, I'll give that. I would just say, let me remind you, as I assume presiding duties in this case, I would propose as a compromise, maybe just, so obviously I think the first thing I need to say is, my name is Judge Whitaker, which I'll do, which really has nothing to do with this particular charge, but So I think the first sentence, Judge Glanville is no longer the judge presiding over this case for which you've been selected and sworn to try. That's fine. There's no objection to that. As I understand, there's an objection to Judge Glanville was removed as the presiding judge.
Of course.
I would propose as a compromise, maybe just I will be the presiding judge in this case moving forward. Then you're not to concern yourself with the change, which is already there. And I would just preface the next proposed sentence that is in a trial, none of the decisions of the court, nothing the judge says is evidence. I mean, that's true. And that's a legitimate charge. I'll give that. I would just say, let me remind you, as I assume presiding duties in this case, that in a trial, none of the decisions the court makes, et cetera, et cetera. And then with regard to disregarding any comments made by Judge Glanville that were disparaging of the defense lawyers, I would propose, because I am not supposed to be commenting on the evidence either, you are to disregard any comments made by Judge Glanville that may have been disparaging of any of the lawyers in this case.
Your Honor, would the court consider not instructing the jury as to anything?
If you want to think of some different language, I'll consider it, but that's what I'm thinking right now. I mean, he did make comments disparaging of lawyers. That's not evidence. It's nothing. There's nothing wrong with me saying disregard that. So that's where I am right now. If you want to propose something else, then propose it.
Orally or in writing? Does the court mind orally?
Sure. Go ahead.
You are to disregard any commentary, any comments that you deem commentary on counsel for either.
Either counsel.
So instead of disparaging.
Yes, I don't. That's assuming that there were disparaging.
Well, that's why I'm saying that may have been. So that may have been commentary. Well, I mean, right. He shouldn't, it's irrelevant whether he said you are doing a fantastic job today either. So, all right, maybe craft it a little bit more. And I understand what you're saying.
She could have
So
prepared
if you
this.
want to come up with a word that kind of encapsulates disparaging or complimentary, let me know. Anything from the defense, or y'all just want to wait and see what she comes up with and then talk about that?
I don't have an objection to the part that you said about what you said.
All right.
I do not see the need to add also complimentary.
No, I don't think we should either. I wasn't suggesting that. I'm saying if we don't say disparaging, then let's come up with a word that would encapsulate any kind of commentary whatsoever, whether it's flattering or non-flattering.
But it should be disparaging. That's my point.
Maybe it might stay like that, but
And I think that I heard what you said, but I would continue to ask if you think it's appropriate to reconsider about the Judge Glanville has been removed.
okay.
Other than that, I don't have any other objections.
All right. Okay, so we'll leave that for now. And if you, Ms. Love, want to propose another word or phrase, let me know. Otherwise, it'll read as I read it.
So far,
right, thank you.
defense is a bit ahead.
Okay.
Excuse me.
Yes.
May I bring up a brief issue? Before,
Absolutely.
You continue. You mentioned this morning about that the court had several rulings that you put out yesterday.
Yeah.
I have not received any of those rulings on Odyssey. I haven't received any of the submissions from Mr. Steele that came through Odyssey. I know I've talked to several other counsel, but I have polled everybody.
Okay.
So I don't know what the issue is, but I'm not.
The issue is Odyssey.
Okay, yeah. So given I can't investigate that today.
And I can't do anything about that. I mean, Odyssey. So
anybody can email the rulings out.
sure. And I mean, usually, at least the lawyers seem to get things fairly contemporaneously. I know the court doesn't always get things contemporaneously, but, and it sounds like some of the lawyers have received rulings. I know Mr. Steele received some because he filed a petition for a certificate of immediate review about 5 minutes after I filed one of the rulings as to one of his motions. So I don't know what the vagaries of Odyssey are and why sometimes it seems instant and sometimes it doesn't. But yeah, I don't have a problem with, as I file orders, emailing them out to everybody, just like I asked that y'all email me with your motions and responses. So sure, we can do that going forward.
Thank you.
Okay.
I believe what's going on, Your Honor, and just my observation is that usually when you're confident, you're just
That's, you're exactly right.
In this case, for some reason, it's like they have these separate cases.
Yeah.
For everyone.
Okay. So yeah, and I do not think that we have been filing our orders in everybody's case individually, every co-defendant's case individually. I think we've been filing them, like, for instance, if Mr. Kendrick files a motion and I'm ruling on that motion, I understand y'all have all adopted it unless, you know, you say differently. But I think we've been filing it into Mr. Kendrick's case. And so that is exactly right, Mr. Short. That's what's been going on.
Yeah, for some reason previously we were receiving.
Okay.
everything, So I don't know what's altered, but.
He's right. That's how I
maybe
see
what's
it too.
altered is that somebody on Judge Glanville's staff was individually filing it in every case, and I haven't been, and the clerk's office, I guess, hasn't known to spread it out into the other cases. So that's what's going on instead.
Thank you.
Okay, all right. Thanks for bringing that to my attention. All right, so are we ready with any portion of
Evidence?
Mr. Kendrick's
Oh,
testimony? What did I say? Copeland, yes, Kendrick. I said
Yep,
Kendrick.
here we go.
Yes. Are we ready with any portion of going back, either any kind of agreement as to what's already been testified to? And if y'all haven't been able to do that yet, then, you know, hashing through the evidence that we're going to have to face again.
So, Your Honor, there's several statements. I think what's really helpful is when we have, and we do have some of the transcripts now where we argued, so that can kind of prompt everyone's memory. And last time we had to go through all the contested segments. What we did is the state played them in court, and then we made our individual arguments. And now that we have the transcripts of regarding some of the statements, I think we're ready to do that.
Great.
And I'm just giving the court a heads up. It's going to be.
did he just
somewhat
look over at them when he said ready?
maybe disjointed at
Disjointed.
times, but we just got to plow through
Yeah.
it. And myself and Ms. Hilton did the best we could
Okay.
to try to figure out where we were previously. I don't believe, for the uncontested
Yes.
issues, I don't believe the uncontested issues have changed at all. I believe I speak for everyone on the defense that we haven't changed our view on the things that we agreed with the state. I think we just need to go over the contested issues.
Okay. That works.
Do you have the ability to play the statements in court today?
Yes.
Okay, good.
And
Oh, and the other thing I was gonna say, the January 11th is the first, January 10th going into the 11th is the first statement by Copeland, and logically, maybe that would be the first one we review, but I don't believe that myself or Ms. Hilton saw a transcript of our prior argument of that one.
Okay.
So I would ask if we could start with the other ones
Sure.
first.
yeah, that's fine.
Is that
Yeah, I
okay?
think there's still one day maybe that Ms. Weaver's working on. So that may be the day you're talking about. So
Okay,
yeah.
so there's
we
a
can
hold
start
because
on
of the
whatever next
transcripts,
statement was.
But the parties did their homework. Well, I guess we'll see.
And are you going to be playing these through Zoom? So do I need to get on Zoom?
Yes, Your Honor.
Okay.
You do need to get on Zoom.
And do you have transcripts of the statements that are going to be at issue?
Yes, we do have transcripts. What I wanted to know from the defense, if there were any that were litigated that are agreed upon, because if there are some that were litigated that we don't have issue with moving forward, I don't know if we need to rehash everything, and we haven't had that conversation, so I don't know.
All right. Do y'all want to take a minute and have that conversation?
Yes.
Okay,
Yeah, I can
cool.
answer that. I think anything that was litigated before needs to be litigated again.
Okay.
But redo.
And regarding the transcripts, Your Honor, June 10th, we have the same imperfect transcript, but it's generally gives guidance. For some of the other interviews, the state has a transcript. There wasn't like an official
All right. Now,
transcript.
when you say June 10th, are you talking about his June 10th statement or our transcript
I'm sorry.
from June 10th of this year?
June
You mean
10th.
his June 10th statement?
2015. The state produced a transcript of that, and, you know, it's not perfect, but it gives
Okay.
guidance, and we're working off the same transcript.
Great.
For some of the other interviews, the state made a transcript at some point. Maybe, I don't know who made it, but it wasn't disseminated to us, and we made our own
Okay.
transcript, so we have like dueling transcripts, just.
Okay, well, That's not
Why
for
don't they
June
have the
10th though, right?
transcripts now?
Okay, so maybe before we get to whichever statement has the dueling transcripts, y'all look at each other's transcript and decide which one you want to go by, or if some parts of it are better transcribed on one and some parts on another, combine them and let's get the most accurate transcript.
And that's why we were playing the statements.
Sure.
I just wanted to give.
Yeah, but
Because Judge Whitaker asked for a transcript and there wasn't complete agreement on the transcript.
Yeah. And there, it's certainly a lot easier and frankly, a lot faster with the transcript. So if there is a statement that I particularly need to see and hear the statement for the evidentiary determination I'm going to make, that's one thing. But if it takes me 5 minutes to read a transcript or 20 minutes to watch the statement, I'm going with the 5 minutes unless there's a reason I need to be watching the video instead. Okay. Because I mean, honestly, for most of these evidentiary issues, I'm not here like making a credibility determination. For the most part, that's for the jury. I'm here trying to decide.
Look at Atkins'
does this
head. He
evidence
loves
come in
this.
under XYZ exception under the law. Okay. However, right now I don't have any transcripts, so pass up whichever statement we're going to be looking at right now. If it's June 10th, 2015.
Can I email it to you? Like I don't have a.
Yeah, that's fine. In fact, we might have some transcripts of certain of the statements, so.
They should have just had these transcripts ready. But thank you so much, What, Wise, and Who, for the $10 super chat. You guys, What, Wise, and Who has chickens, loves chickens. If you could put a chicken emoji in the chat, I would love that. And then Miss Avi gives potential jury instructions. Hello, jury. Welcome back.
Ms. Weaver.
Oh, no.
Provided our chambers with several of the transcripts of the statements that y'all had given to them, I guess. So I've got the transcript of that June 10th. And I actually have videos of some of his interviews too. I think maybe all of them, but some of them play under evidence viewer that y'all gave to me and some of them don't.
So, if you received 6 interviews, if you received 6, 5 of the 6 are all evidence reviewer.
Okay.
And then the only one that's not evidence reviewer is the October 2021 interview.
All right. Okay. So I need to get on Zoom. Give me a second to do that.
And can I have the link as well, Your Honor?
Okay.
In the meantime, proposed jury instructions from Miss AB. Hello, jury. Welcome back. Thank you for your patience and sorry for wasting your time. I'm the new judge. Your service is no longer needed because this is a mistrial. Bye, everybody. With the wave. Thank you so much. Aw, look at you guys. There's so many chicken emojis. I didn't realize there were like little variations of the chiclets. Who put the drumstick? Grammy Pammy. Aw, thank you so much, you guys. Chickens are cool. I didn't realize how many different, like, variations, varieties of chickens there are. And some of them are so cool looking. And Penny G says, thank you so much for the 15. How can the mistrial motions be denied at this point? Clearly, June 7th through June 10th have to be taken as a whole, and judge planned with the state on the same team that June 10th was the execution of coercion. I mean, I agree. I think the majority of the chat agrees here. I don't see how it's not improper. I don't see how it doesn't look like coercion. And if you missed the beginning of the stream, I don't know if you were here right when we started, Penny, but she said she considered June 7th too in her denial
of Mr.
to disqualify
Copeland
the
to law
two.
enforcement, and we're all working off of the same transcript, and you're going to play the video as necessary.
Yes.
All right. Ready when you are. With regard to
This
whatever
might be
portions of
productive.
this are contested, tell me where they are, I guess, timestamp in the video, as well as what portion of the transcript, and then tell me what the dispute is, okay? Yeah, you can just come up here. Sure. And, Lon, can you shoot email? Down in there sometimes. And if not, then we'll just get.
We get let in to the.
All right, tell me.
Yes, and Your Honor, just to orient the court.
Sure.
So the state had proposed several redactions of portions of the interview that we did not want played.
Mm-hmm.
And the defense, for certain portions, wanted that portion to be played through the state.
Okay.
It's the state's position that if we don't play it, and they choose to play it, they can, unless we believe it's inadmissible.
Okay, so with regard to any of those portions that you just think they don't need to hear this, but the defense wants to play, I guess, have y'all talked about whether the defense intends to play it so that you can tell me whether you think it's inadmissible?
Yes, and so
Okay.
that's, I just wanted to
All
order
right.
the jury that that's.
All right.
Where we are. So with respect to the June 10th interview, the first section, I'll just go in chronological order, that there was an objection. The defense wanted to redact timestamp 1019 to 1011. I mean, I guess I'll let defense counsel explain why they wanted.
1019 to 1011.
101911 to 101941, which is page 61, line 22 of, beginning at page 61, line 22 through page 62, line 14.
I think this is a
Man, I
poor
need a
strategy for
go-to
the state.
page number on this.
They really do rely on these videos. Miss AB's right. The goal is always to get the video
So I have to
interviews in.
just
They don't
scroll
want
and
the
hope I get it
testimony.
right.
But the videos are so hard to pay attention to, in my opinion. Maybe it's better when you're sitting in the court, but
You repeat what you said about.
it's like Yawn Fest, Yawn City listening to those videos. Why would the
This is
jury
a segment
pick stuff
that
out on their own?
Defense counsel, you want it redacted, but we objected to it being redacted.
Okay, so this is what you, because a minute ago you said stuff you're not gonna play, but the defense wants. So now you want this, the defense doesn't.
Correct, Your Honor. So the way that we had organized it initially,
I mean, if we're just gonna walk through the whole transcript and then, that's fine. That's fine. I just need to understand what it is.
yes, so this was a portion that the
You
defense-
want, the defense doesn't.
Yes,
Okay, and that is, I know it's 101941, no, 101911 to 101941.
yes, Your Honor.
Okay, all right.
And thank you so much, Miss AB. Maybe this judge will make sure it's easier to hear, though.
1852 with evidence reviewers. Sometimes a challenge to get it right at the right timestamp, so you just bear.
All right, let me
Right.
ask. So I had just said, I don't know that we need to actually listen to the video of everything. And I mean, I can read the words on the screen, so on the transcript. So unless we also, for some reason, I need to be hearing it out of his mouth. And if I do, and there may be times I do, then we'll listen on the video. But if I don't, I can read it.
So the state's position is we wouldn't hear from the defense, but I think it's inadmissible. So that's what we were waiting for.
Okay.
Okay, so just a little context, if we're just looking at the statement as my legal assistant failed to turn on my mic. If we're just looking at this, the transcript as some context.
Well, no, let me stop you. If you, for a reason, want me to watch the video, that's fine. I don't have a problem with it. I'm just trying to be efficient with our time.
No, that.
You mean, let me tell you what's been going on beforehand. All right, sure.
So they were discussing beforehand the Lil Wayne bus shooting.
Okay.
In this discussion. And then Kenneth Copeland on line 9 of page 61 says they did it. Who is they? And they who? And he says, Shannon and them. So the first part of our objection is Kenneth Copeland giving information about the Lil Wayne bus shooting. What Your Honor needs to know from me about the Lil Wayne bus shooting is Kenneth Copeland, it's not been alleged at all that he was at Club Compound on the night of the Lil Wayne bus shooting. It's not been alleged at all that he was present, that he was there, that he had anything to do with it. So, and it is not at all clear. So it's clearly hearsay. Now we need to search for an exception, and I don't know what the source of his information is. There were, this was Dwayne Carter is Lil Wayne, and when his bus was shot, there was all sorts of internet reports on gossip blogs and everything else, and there's just no way to ferret out what his source is.
Sure.
To suggest that it falls under any hearsay exception.
Okay.
Now, I have in my notes on the transcript that page 61, lines 1 through 10, were not objectionable. That's what my notes say.
Okay, that's right.
And then
Hang on. Let's make sure that's right. That's right.
What line did you say?
62 lines 1 through 10.
So, Your Honor.
62 or 61?
Oh, well, 61 as well, both. It starts on line 11 or somewhere about there.
So
61.
you want to ensure that y'all are in agreement that 61 lines 1 through 10 are in unobjectionable?
And Your Honor, we need 2 rulings before we can answer that.
Okay.
So, initially, that was the case. However, Your Honor, based upon, we filed the notice of intrinsic acts that we would need to hear if this intrinsic act regarding the Lil Wayne bus shooting, specifically as it relates to Shannon Stillwell, if that is able to come in, then we would want to play the portions, page 61, starting at line 1. Also, Your Honor, depending on the court's ruling on co-conspirator statements, excuse me, we would.
Well, I can't just give you a blanket rule on co-conspirator statements. I have to know what the statement is.
Yes, Your Honor. So that would be my response to this question. What Mr. Shard just argued is that
He's not arguing anything right now. He's trying to make sure we're all on the same page. So
correct. And so what I'm getting ready to say is what Mr. Copeland is speaking with the detectives about, which is the Lil Wayne bus shooting.
Right.
This is information that the state believes he received from Demekion Garlington, a co-conspirator.
Okay.
And so we believe that this would fall under a co-conspirator statement as in furtherance of the gang. So because he's telling him about an act that occurred between these gang members, and to give the court a little more context, The Little Wayne bus shooting, what we call it, is one of the acts. We've already presented evidence about this act. It occurred in April of 2015 in the midst of what we believe to be an all-out gang war with YSL. Essentially, the state's allegations are that Mr. Williams was in conflict with Dwayne Carter, also known as Lil Wayne. On an evening in Atlanta, several members of YSL went to a venue in which Mr. Carter was performing, and they created some type of ruckus outside of the venue. Later on that evening, a number of YSL members followed Mr. Carter's tour bus to essentially to their hotel or en route to their hotel and shot at their tour bus. What Mr. Copeland tells police is that Demekion Garlington told him that the individuals that shot at the bus were DK, who's also known as Walter Murphy, a YSL member, and Shannon Stillwell, a YSL member. Jimmy Winfrey, another YSL member, actually ended up pleading to the case.
Okay.
And so we believe that this will be a co-conspirator statement. So that is kind of the context of that statement here, Your Honor.
All right, so what Mr. Sharp was trying to sort out is, do you have, sounds like you had previously, and by you now I mean the state, had no objection to lines 1 through 10 of page 61 coming in. Is that still your position?
No objection of it coming in. Yes, we have no objection of it being played.
Okay,
Right, that was never an issue.
okay, and it's still not. All right.
So, and I don't think we need a ruling on the intrinsic, I mean, this doesn't really further my interest, but just to be honest with the court, I don't think this is an issue of whether it's an intrinsic act, because it's pled in the indictment as an overt act.
Yeah.
Part 1, so
Okay.
I don't think that's the issue. The issue is the state is just saying, well, we think he got this information from Demekion Garlington. There's 2 issues. A, we think he got this information from Demekion Garlington. I don't know where they're getting that from. That's 1, other than speculation. 2, then it also, if they were to be able to show that he was the source and that he's a conspirator, then we would also have to, it sounds a lot like spilling the beans. So there's 2 aspects to that where the state, the burden is on the state, and I just don't see them meeting it.
So, DK, I'm sorry, y'all. It's going to take me a minute to get all the names. DK
The closed
is who
captions.
in real life?
Walter.
And Mr. Garlington goes by D, right?
There's
Who is little D?
There's 2 little Ds.
Oh. There are 2 of like lots of these people. Okay.
So one will be referenced as Little D from Mechanicsville, and that'll be Demekion Garlington,
Okay. So does he go by both D and little D?
primarily Little D.
Okay. And he's Garlington, but he'll be little D from Mechanicsville.
And he also is referred to as Scarface
Okay.
in the indictment.
All right. And then the other little D will be,
Quindarius Zachary, Quindarius.
and when they say little D,
From Cleveland.
Cleveland. All right. So we got
And they also call him Sick D.
sick D, little D, or sick D. And he'll be from Cleveland. Okay. Thank you.
And Your Honor, it's not speculation that Demekion told him this information. On page 61, line 22 through 24, Mr. Copeland says, Little D, that's how I get all my information, through Little D. Which Little D? D ain't, and they clarify, he says Mechanicsville, which is Demekion Garlington.
Okay.
I'm just not reading it that way.
All right. Let's see. So maybe we'll listen to it. See, this might be one of those times when we need to listen to it.
Your Honor, it's gonna start a little earlier. It's gonna start about 10:18:52,
Okay,
but we're gonna be listening around 10:19:12.
all right.
Baby, I like it. It was on, they say Shannon BK now. BK right here, so the last name, yeah. What's on Libby? See, that's how I get all my information to Libby. Mechanic. Yeah. See, he not gonna be able to tweet all day, Twitter and Instagram. This all he gonna do all day. I mean, he gonna be everybody. He gonna miss everybody. Everybody. I mean, talk to him. You know what I mean? So I can always say, hey, right there. I call you right now. If he don't know, he'll sit right there, tell me what's going on. So, well, I'm made a deal about this, bro. If you know you ain't gonna plan on killing me, bro, why you never told me? You know what I'm saying? Say you plan on killing Tick too. Say I'm gonna kill Tick. Nah, do it. Why don't you kill Tick?
And I can replay it, Your Honor, if you need me to.
So, Your Honor, this is my problem with this argument here. Typically, in every case I've ever dealt with a co-conspirator statement, every case I've ever read involving a co-conspirator statement, an appeal, declarant said to witness approximately 2 weeks after the murder, while at the Exxon gas station, that it was the defendant and his friend that committed the murder and that the person needs to be quiet about it, etc. There's a time, there's a place, there's what was said, it's who said it. Here, Mr. Copeland comes out with some hearsay, some vague hearsay information about the Lil Wayne shooting and who did it. They ask him, what about Lil D? And I'll concede it seems they're talking about Garlington. And Investigator Dennis is the one talking, and he's clearly asking about Demetrion Garlington, I think that's fair. And he just says, well, Lil D, that's where I get all my information. He's on Twitter a lot, he gossips a lot, essentially is what he's saying. There's, I don't take a general statement of, oh, Lil D, he's a gossiper, that's where I get all my information, as sufficiently specific to this particular piece of information to say, Demetrion Garlington told me, and I know you don't need an exact date, but Demetrion Garlington told me, about a week after the Lil Wayne, if the state wanted to bring this in, I would expect to hear, yes, Demetrion Garland told me about a week after the shooting, we were hanging out at the Exxon gas station, and he told me Shannon and DK did this, but that's not what we have here. It's just a vague statement. Oh yeah, I get all my information from Lil D. So I don't think that's sufficient to particularly say that he's the source of that particular information. And then of course, again, it's spilling the beans when it really comes down to it too, because there's no context that would lead anyone would allow Your Honor or any of us to conclude that the state has proved by preponderance of evidence that somehow a statement that we don't even know was made, where it was made, the context of what it was made, was somehow in furtherance of any sort of conspiracy. So I just don't see how you are armed with making any sort of determination that it falls under 801 D2E, and of course the burden is on the state to arm you with that information.
Okay, so Deirdre in the chat just recommended a channel called Shields of Shame because they have piles of documents that prove the Georgia Attorney General is corrupt. So it looks like they cover a variety of different topics, but I do see a ton of Georgia stuff here. So there's that channel. If you guys want to bookmark and look at that, subscribe, not bookmark,
Yes.
whatever.
While you're reviewing this, with all due respect, I want to renew my motion for mistrial based upon
Let's go.
the entirety of the record up to this point. I think it's impossible for you to parachute into this. I think this morning demonstrates why it's very difficult for the court to do that without having the background of the last 6 months of testimony. We're now replowing people issues.
All right, we're replowing because everybody agrees that, and I don't mean to interrupt you, but I, want to clarify that. Everybody agrees that everything that Mr. Copeland testified to in front of the jury after the motion to recuse was filed on June 12th has to be redone. So that's why we were replowing this.
No.
Go ahead.
Okay, but
But yes, I don't know everybody's nickname yet. That's true. But this is not in front of the jury, and evidentially, I'll either make the right ruling or I'll make the legally incorrect ruling. And that's something for potential appeal. That's true in every case. And I don't ever know the facts of a case before I start to take, it to trial. I find out in the course of the trial. Or I find out as the motion is being presented. So yes, it would certainly be easier if I had heard 6 months of testimony that came before this, but I don't think it is a basis for mistrial.
I disagree entirely. You would know the basis and the people's names and the testimony had you been the trial judge up to this point. And I get your point. Before trial, you don't necessarily know the evidence. We are way deep into trial now. You would have heard this evidence. You would understand the context, and we wouldn't have to replow the contextual basis. So I'm just renewing my motion.
All right, I appreciate it. You're not wrong about factually speaking, it is more difficult, but legally speaking, it is overruled.
Your Honor,
Steele, go Steele, go
Can I
Steele.
Mr. Steele.
could you mind, as you're making this analysis under 20 OCGA section 24-8-801 D2E,
Legally speaking.
I'd like the court to just denote that in a good case is, that I think is a good case, is Stafford, STAFFORD versus State. That is 312 Georgia, 811. It's in Division 5A as in Elisa, 865 Southeast 2D 116, 2021 case. And the reason, I'm listening intently, I don't mean to interrupt, but the state's belief of the law over the past year is that any statement made by a supposed co-conspirator to another co-conspirator who speaks with the police furthers a conspiracy. And as Mr. Sharp said, that is just spilling the beans unless it really does something to promote the conspiracy. So even what the state just said, I get my information from Mr. Garlington. My point is that doesn't help the state, because if I'm in a conspiracy with Mr. Adams to steal a pencil, and I tell Mr. Adams, I stole the pencil, or Haley, who I'd like to introduce you to, stole the pencil as part of our conspiracy, Mr. Adams, then repeating that to law enforcement, doesn't do anything to assist us. Now, if he said, cover for Haley, give her an alibi, that is different. So the point I'm trying to make to you is, I'm not so sure that there is a conspiracy. Like, I'm just telling you, I know you're working hard, and it's all appreciated, but Mr. Nichols hasn't really been mentioned in this case. He was not mentioned in opening statement. He has one little section on I can't remember the year, 2014, but I don't know the year, small drug case. Otherwise, he's not mentioned. And I'm not trying to argue for the Honorable Ms. Westmore and Mr. Harvey, but that's why he's always asking for 105 instruction. But the point I'm trying to make to you is this exercise also has to inject, if you don't mind, why the state is saying it furthers a conspiracy. Just getting information does not further a conspiracy. That's my point. Thank you.
Thank you.
And, Your Honor, if I can add some additional facts, because I don't want to. This is not the only time in this interview that Mr. Copeland talks about the Lil Wayne bus shooting. So this is the first time. He actually talks about the details of the shooting. At least 2 more times throughout the course of this interview. So this interview is 9 hours long. And so in the course of that interview, he gives more and more details about the shooting.
All right, maybe point me to the parts of that. So yes, I don't know if you were able to pull up Stafford or if you have it, if you've looked at it previously, but
Yes,
what
this is
it
live.
says is the same thing that Mr. Sharp's been arguing for a while about co-conspirator statements. And that is essentially that even where there is a conspiracy that has been established by a preponderance. No, I lost my place. Hang on. Where is it? Here it is. Hearsay statements that implicate a co-conspirator but do not advance any object of the conspiracy, such as statements that merely spill the beans about the conspiracy, are not admissible. So if you can point me to how this advanced the conspiracy, and I understand your argument is, hey, the conspiracy is they're all members of an ongoing gang. They need to know what's going on in the gang so they can react like appropriate gang members and be prepared if somebody's coming after them. And that's a reasonable position to take. So tell me how it is that this is advancing an object of the conspiracy and not theoretically where your evidence is going to show that.
Yes, Your Honor. So during 2015, there were just a number of different events and actions that took place beginning in January of 2015, all the way through about October of 2015, Your Honor. This particular shooting of Lil Wayne's tour bus was a part of two events. So Lil Wayne, I'm trying to simplify how Mr. Carter is a part of this. So starting in 2014, Your Honor, Mr. Williams had began a musical relationship with a person by the name of Brian Williams, also known as Birdman. Lil Wayne was one of Birdman's artists at the time, back in 2014 and prior to that. Evidence has come in that members of YSL, specifically, have made threats against individuals who we believe supported Lil Wayne during this ongoing dispute that they were having.
Is Birdman alleged to be in a rival gang, or he's just a rival record producer in the industry?
He wasn't a rival to Mr. Williams, so he was friendly with Mr. Williams. Lil Wayne, we believe, became a rival, and we're talking about back in 2014 and 2015, of Mr. Williams at some point. At some point, there was some friction between the two of them in which Mr. Williams made subtle threats to Lil Wayne via social media. That evidence has been entered before this jury. And we believe that the gang, when Mr. Carter came to Atlanta, there again, like I said earlier, members of YSL like just converged on the compound. They left their different, I think they were at a music studio. They all came there in an effort to intimidate or threaten Mr. Carter.
Okay.
So informing another gang member of those activities is keeping him abreast of those activities. I believe that Mr. Copeland, we're going to confirm, was incarcerated at the time of the Lil Wayne bus shooting. And I want to make sure I confirm that for the record. So we believe that he was being kept abreast of what was happening while he was incarcerated. And then once he was released, he was provided this information in order to, whatever the next steps were, whether it would be to further intimidate Mr. Carter, but he was made aware of everything that occurred while he was in custody.
So do you have any evidence that then when he got out of custody, he also began to participate in this threatening of Lil Wayne and his peeps?
No, we do not have any evidence.
Okay, so then how is it furthering the conspiracy of being in the YSL gang and not just, hey, guess what happened today?
Because it fosters cohesiveness, the fact that this YSL gang could literally shoot at a bus of a famous individual. It made the news, it promoted the notoriety of YSL.
Yeah, the shooting might have, but how is telling Mr. Copeland doing anything to further it?
Because he then can claim notoriety as being a member of YSL.
That helps him? How does that help the gang?
Because it promotes their notoriety, the fact that YSL themselves had the ability to shoot at a famous person. That promotes the gang across. It made headline news. It made news.
That may be. Again, how does then apprising Mr. Copeland of it further the purposes of the gang?
Because it furthers his involvement, because he's still in the gang. He can still promote himself. He still promoted himself as YSL, as being a part of the group that shot at the Lil Wayne's tour bus.
Do you have any evidence that he does that?
Promotes himself as YSL?
As, hey, I'm part of the group that shot up the bus.
I don't have evidence of him saying I have evidence of him saying he's still part of YSL and claiming affiliation with YSL, because collectively they shot up the bus, not the specific individuals, but collectively as a group, they shot at.
Does he post or brag about YSL shooting up the bus?
No, we do not have any evidence of him posting on social media YSL shooting up the bus.
Okay. All right, so we are then looking at '61, line 22 through 62, line 14, where he says, I get all my information from Lil D. Because everybody's talking about it. He knows what's going on. And I don't think y'all have sufficiently satisfied the co-conspirator exception there. I'll keep that part out. Let's move on to the next one.
Win for the defense,
Your Honor,
especially Weinstein and
This is
Sharp.
where I'm not sure what the state's, 62, the beginning of, I'm sorry, the beginning of 62, they just talk about Lil D from Mechanicsville just being a gossip. Now,
Yeah, that's what I just excluded.
well, you excluded, in my understanding, you excluded the part where he talks about the Lil Wayne bus shooting. And then after that information he gave, there's a section, and I don't have a strong
No,
opinion.
y'all all said nobody cared if that came in, 1 through 10, nobody cared.
Yeah, 62, 1 through 10, I agree. I don't have a strong opinion. I was just trying to understand if the state had an opinion about that, if all of that was coming out or all of it was coming in. The 1 through 10 on page 62. I don't have an opinion.
No objection to it?
Yeah, no. 62, 1 through 10, the state is okay with coming in.
Okay.
Okay.
I'm just trying to clarify. So
All right.
But then starting at 11 on page 62, there's another aspect of this where it's not the same issue. It's something about Kenneth Copeland talking about potentially Jeffrey was going to have Tick, and Tick is a gentleman named Trontavious Stevens, who is also known as Slug, who is he entered a plea in this case.
Your Honor, that portion is redacted.
Okay,
62, line 15 through 22 will be redacted.
Okay.
All right. Next.
This is interesting.
I believe the defense wanted, next page 62, line 23 through page 70, line 16 out.
Tell me again, 62,
Page
line
62
23.
Yes, line 23 through page 70, line 16.
16, okay.
And then thank you so much to JL. The only thing I want to shoot is myself after Hilton and Love talk. Don't do that. Don't do that. Water guns. Water guns. And then Lord Vegeta, I had given you a recap in the chat, but you missed proposed jury instructions. Whitaker is kind of right in line with what Steele was proposing, except some debate over the word about Glanville being removed, the specific term removed. But the state didn't have a counter proposal prepared like they should have. And then we've been looking at evidentiary issues ever since. And we just got a huge win, which I think you're watching still, for the defense. Big statement on, DK. Shannon Stillwell said they're going to kill him. They're going to kill Tick. These things can't come in. That statement can't come in. And then thanks for the 2 from Garrett S. Hilton likes the word believe because she loves to lie. And it was awesome to hear the difference in the arguments without Glanville interrupting and kind of directing, and the arguments sound different when the judge isn't trying to offer an assist. Well, and the whole issue here is really what should be considered, a co-conspirator statement. When should somebody says to somebody else that person then tells to the police, when should that come in as an exception to the hearsay rule? Something YSL worked for Glanville, but it's clearly not working for Whitaker. You could tell by her questions that she was leaning towards denying it, and I held my breath because you never know. Because with this trial, everything's been kind of shocking. But her questions kind of pointed she was going to deny it. I'm glad she actually did. Look at, I think Doug just gave a smile over there. You see him over there? That's a big win for Stillwell and DK. Yeah, Glanville with the, I think what the state is trying to say. I can hear it in his voice. And I forgot, are we just looking at the next statements we want to talk about? We don't know? Thanks so much, Jana. Good to see you. Are you at the beach in your picture, by the way? The beach sounds fun. There you go, cheapo. It's actually a fair trial now. It's jarring how different the decorum of the court is without Glanville feeding the prosecution and silencing the defense every 10 seconds. And I think it'll be easier for the jury to follow if they do come back a condensed version anyway. The state should want a cleaner case. They just don't because they don't have one.
The state's misrepresenting anything, but I don't think I don't recall having a blanket objection. Now, there's certain parts in this transcript as a whole, and they're coming up not to 72, but a little bit after 72 that go back to Lil Wayne's bus shooting. And our stance is all that is covered under your last ruling. I mean, all of it's the same general situation. But regarding these pages 61 to 72, what I have is I objected to 70 page 70 lines 16 to 19, where it's just Investigator Dennis identifying, it's not Copeland talking, but Investigator Dennis says,
If Shannon is a shooter.
Shannon is meaning Jeffrey's shooter. Why would he put these?
Yeah.
I think that's inappropriate to have the investigator, just put that out there. And then after that, line 72, lines 5 through 13, again, it's Investigator Dennis, kind of giving his theory on everything in relationship between Kenneth, Jeffrey, and Shannon. And it's not needed to add context to anything. It's just kind of him giving his theory.
All right. So does anybody have an objection to pages 62, line 23 through, I thought you said 70, line 16?
That's what
Anybody have an objection to that?
Okay, I'm sorry. No.
Nobody has an objection. Speak now or forever hold your peace. All right, there's no objection to that.
And as it relates to what Mr. Shar just mentioned, page 70, lines, we have 17 through 19, we have no objection to.
To redacting that?
No.
Okay, so 17 through 19 will be redacted. Page 70, lines 17 through 19.
And also, I believe what he just said, page 72.
Lines 5 through 13.
No objection to that as well.
All right.
Oh, 72.
I don't know why I'm writing these pages down like I have the transcript
Next.
to reference, but just in case.
The next
Thank you so
portion that I had initially was page 70. The defense wanted redacted was page 72, line 14 through page 73, line 21.
All right, does the defense still have an objection to that?
73 line.
No, 72, 14 through 21.
No, 72 line 14 through 73
Oh.
line 21.
Okay.
God bless you.
No, I'm.
God bless you.
Speaking for Mr.
Okay.
Stillwell.
Anybody, any of the defendants have an objection to that portion? Sounds like a no.
Okay. Then you're on the next portion, I believe would follow under your previous ruling, which would be redacted, which would be page 73, line 22 through page 78, line 16. So
Okay.
I don't think there needs to be any further
All
discussion.
right.
Thank you so much, Mrs. R, for the $4.99. Thanks for all you do. Thank you for being in the
Look at
chat
us
and
making
supporting.
progress.
And then thank you for the 99. Let's go. I'm going to say your comment says let's go with the red light.
Having read Stafford, just address something briefly related to the case item.
Oh.
Your Honor, in regards to Stafford, it's quite distinguishable by the mere fact that it appears from reading this that this was a co-defendant's statement to the police and that co-defendant did not testify. So what they were arguing was a co-conspirator in furtherance of the conspiracy was what this individual told the police. We have Kenneth Copeland here on the stand who can be cross-examined, so it's not what he said verbatim to Detective Dennis, it's obviously what he stated to other co-defendants.
Right.
And so I just think Stafford is quite distinguishable from the facts at hand, because there could be a situation where a co-conspirator is trying to throw off the police, tells them a lot of lies, which furthers the conspiracy.
He made her
But
ruling, though.
That's not the situation we have with Mr. Copeland, who's live, can be cross-examined.
Okay. I appreciate that. And when I made that reference to Stafford, I wasn't actually dealing with the facts of Stafford are influencing me to make this ruling. I was actually reading a quote from an entirely other case that's cited in Stafford just for the legal proposition. So, but thank you.
So sit down.
Your Honor, that wouldn't, respectfully, that wouldn't be correct anyway. That would be a confrontation clause.
He already knows.
What the
Right.
attorney is talking about.
But that wasn't what I was using it for anyway. So,
Because here's-
yeah. Thank you.
Dang, the stage
All right,
just
so
got
what's our
back
next
down.
portion of this statement?
Thank you so much, Mahadi De Jesus.
Your Honor, the defense wants out is page 140, line 11 through page 143, line 16.
And Love is going in and out a lot today.
Yes.
I have 89, page 89, 3 to 25. Did you guys agree to that?
You said page 89.
Lines 3 to 25.
Yes, and I believe the full redaction that we agreed upon last time, I have it correct.
Guy's name is
It's
Christian
page
Atkins.
88,
Christian Atkins.
line 23 through page 92, line 20.
So y'all agreed that that's out.
Yes.
All right.
There's a small portion that we can play, which was page 91, lines 20 through 21.
91.
Lines 20 and 21.
This is true, CJ. At least Atkins tried to use case law, and that's all you can do, right? Sometimes you got to make the argument that
Everybody
you can
good with
find
that?
and just try.
I don't know. I mean, in reality, I don't know how. Yeah, I'm fine.
Logistically, they're going to
Yeah.
do that. Well, they can figure that out. All right. So then we're looking next at what line, I'm sorry, page 140, line 11 through, did you say 143, line 16? Or did I get that
Page
wrong?
140, line 11 through page 143, line 16. Yes.
And I'm sorry to keep doing this, but just so I'm certain, the other three before 140 is the 112:24 to 114:25. We agree on that?
Page 112, line 21 through page 114, line 25?
Yes.
Yes,
Okay.
And y'all agree on that being out?
out. Yes,
Okay.
Your Honor. And then we also agree upon page 122, line 20 through page 124, line 10. Being,
I'm in concurrence. And then 129, I have 129:20 to 130:20 approximately.
I have 129, line 18 through 131, line 25.
Is out by agreement.
Out.
Okay.
131 line 25?
Yes, sir.
Okay, great, all right. On the same page.
All right, so now I'll read 140:11 through 143:16.
And then thank you, non-bigness 1020. As Miss Love walks in with a cart of documents. Hold on, let me hide this. Look at her cart, you guys. She said, Atkins, here, find something that makes our argument for us. Time to huddle. So non-bigness said the state seems a little nervous as they roll in with this cart. Any other time they were popping off at the lips, arguing. Yeah, different judge, different vibe in the courtroom. And then FMLA Johnson says 199 with no comment. Thank you so much for the 199. This pure love of the game, as they say. The cart, you guys. Is there a cart emoji? Is there a shopping cart emoji? Drop a shopping cart emoji if they have one. Oh, thank you so much for the sticker, Bianca. I just wheeled it right in. It reminds me, back in kindergarten, our kindergarten had a cupcake day once a month. And they would wheel a cart around and you could buy cupcakes for $0.25. It was the best when we saw the cart rolling. You could smell it too. You could smell like the frosting in the cake. And then Miss B says, thanks for the $4.99. They need to just throw out the entire video. It's going to sound crazy to play any of it with all of the redactions. And, you know, I feel like, I think they can just read the statements too instead of using the video, but they want to use the video because they want to play more of it, like you were saying earlier.
Context.
All right.
So after the January 10th murder of Donovan Thomas, there were a number of retaliatory shootings.
Right.
One of those retaliatory shootings was on February 19th, 2015, in which Mr. Copeland is coming out of his home with his daughter and his child's mother. At that time, some members of the opposition gang drive by his house, shoot at him. He shoots back at them, and he's able to find safety. He goes to the police that evening, and when he goes to the police, they ask him for the gun that he uses. Initially in February, he tells them he'll get the gun. He'll give them the gun. He'll give them the gun. Of course, he never turns in the gun. Now in June, he is explaining to them why he did not turn in the gun. And so I wanted to give the court that context before
Thank
we
you.
go into argument.
Okay, and so what's our issue with this portion of the transcript?
Defense counsel, the state believes it should be played. We believe that this is intrinsic to that act from February 19, that it completes that particular story in which this is now the answer as to why that gun was never turned in. And so that's the state's position, that it is, if it does places we don't think it's character, the fact that Shannon Stillwell had this gun. I believe that was the previous argument, that the fact that Shannon is a convicted felon and has a gun is bad character. We don't believe it's bad character, and if it is character, it's incidental character. But this explanation of where the gun is intrinsic to completing the story of what happened on February 19th, 2021.
Couple things. To the extent that the shooting on February 19, 2015, where individuals shot at Kenneth Cope, the story, the full context, individuals allegedly drive up, shoot at Kenneth Copeland while he's holding his baby, and he's with the mother of his child.
Right.
He shoots back. He hits people, causes their car to crash. They're charged with this crime. Mr. Copeland's brought into the police station immediately and is questioned about things. He's never charged. Number one, if I concede that the incident itself is relevant to this case, the back and forth, that's fine. I'm willing to do that for the purposes argument. But I don't know what happened to, it's unclear to me what happened to Kenneth Copeland's gun or the gun that Kenneth Copeland fired. That is not relevant. It has no probative value to this case. My client, the fact that he is had to be in possession of a gun, he's not charged for that. It's not listed as an overt act. It does place his character at issue. It's very similar to cases that he's charged with in this indictment. I believe he's charged with 2 different counts of possession of firearm by a convicted felon. So the fact that he's charged with that exact same offense that would be implicated here increases the prejudicial value of this information. But in addition to the 401 and 403 issues involved, Your Honor, it's also based on hearsay. He's not claiming to have been there when he's saying Shannon came and got the gun. My understanding of the sequence of events, my understanding, and I'm not revealing anything my client has told me, I'm just going by what the discovery says. Shannon wasn't present. Mr. Copeland's goes to the police station. He's just been in a shootout. I don't know that he's basing any of this on firsthand knowledge. I think he's just heard this, and it's hearsay at this point. I don't think he's ever saying that I saw Shannon come in and take the gun. That's not the way I understand what he's saying. So I think there's a hearsay issue as well.
I'll hear from the state. So we've got relevance and hearsay
And 403.
and 403.
So for relevance, Sharon, I think it is relevant. Well, let me start with the hearsay first. I don't believe it's hearsay. I believe I'm going back through the transcript that Mr. Copeland explains that when the police came to the house, Mr. Shannon Stillwell was inside of the home, that he left before Mr. Copeland leaves. So I don't think
That's my reading of the transcript too. I mean, whether that's true or not, who knows? But what he seems to be saying is that when the police came by to get the gun, Shannon actually was there. And when Kenneth said, all right, let me go get the gun, by that time, Shannon had actually gone and gotten the gun himself and left the house. And so
She understands it better than the
I can't
state
get you
understands
gun
it.
right now. Give me another day or two. So that's my understanding of it. So that would not be hearsay. So the hearsay ruling, the hearsay objection is overruled. How about relevance?
So as far as relevance, Sharon, we believe that the simple fact that he gets the gun from Shannon or it's Shannon's gun that he has to shoot back at the opposition gang shows one that YSL members, they interchange guns, Your Honor. You're going to see that more evidence is going to come out that we have certain YSL members who may purchase the guns for other YSL members. So this again is a part of what the gang does as a part of their enterprise or conspiracy. They pass guns around. So we believe that it's relevant for that purpose. And then as it relates to 403, Your Honor, Mr.
403 is prejudice
Still
versus
was charged
probative
with
value.
2 murders in this indictment, both murders by handguns. So the fact that it comes in that Mr. Copeland got this gun from Shannon is not going to the prejudicial, the probative value is not substantially outweighed by its prejudicial effect, given that the jury is going to hear at least on 2 occasions that Mr. Shannon used a gun, alleged to have used the gun, both in the Donovan Thomas murder as well as the Shamel Drinks murder. Additionally, Your Honor, when Mr. Stillwell was apprehended on March 17th of 2022, is the state's allegations that he threw a gun out of the window of a vehicle to dispose of it. So, Your Honor, we don't believe that the probative value is substantially outweighed by prejudicial effect.
Mr. Sharp.
If we assume the allegations to be facts, A, we would need a trial, but B, I agree, it wouldn't be prejudicial if we assumed, oh yeah, well, Shannon was in possession of a gun as he rode down the street on January 10th, 2015.
There's no
But that's not
firsthand
what we
knowledge.
do. That's the issue before the jury. So that's exactly what makes this excessively prejudicial, is because that's the issue that they need to determine. And this story, which really adds nothing to the state's case, the idea, oh, it's evidence of passing guns around. I mean, they're going to have direct evidence of Quindarius Zachary saying he's a straw purchaser of guns at Arrowhead Pawn. So they don't need that. And gives it to, and has distributed them to people in this courtroom or in this case. But that's exactly what's so prejudicial about this, is they're bringing in propensity evidence that is going to be prejudicial to the issues at hand, which is whether Mr. Stillwell was in possession of a gun and shooting at Donovan Thomas, whether Mr. Stillwell was in possession of a gun and shooting at Shamel Drinks. I submit to you, Your Honor, if Mr. Stillwell was charged with stabbing individuals, this would be less prejudicial.
All right, so you're now making a 404B
Rule 404 is propensity, character
well,
evidence, other
it's-
crimes or wrongdoing.
It's 404B, but it dovetails into 403 as well. It's just the
Okay,
prejudice of
because
hearing.
it really can't be 404B if it's intrinsic. And you just said you agree it's intrinsic.
Well, no, I agree that the shooting itself, the shooting involving Kenneth Copeland.
All right.
It seems they've argued it's intrinsic, and I don't think that my argument one way or another really makes a difference, but there's a separate incident, which is Shannon's possession of the gun. I don't believe that that's intrinsic.
Okay. All right, thank you. I find this evidence to be relevant and its probativity not substantially outweighed by the danger
win
of
for the
unfair
state.
prejudice, so I'm going to permit that. What's our next section?
The next section that I have,
The fence wanted out was page 188, line 9 through page 189, line 9.
Thank you so much, Garrett. Yeah, we gotta set up an 8 document limit. And really, I think this cart, I saw someone else say it. What do you guys think? So Garrett had said, we need to limit these docs. Love has a limit. And then Dream had also said the cart was brought in for effect, knowing that it looks like they've done work and banking that no one's going to look through the cart of mystery. What do you guys think about that? Just bringing it in for effect. I think it had the opposite effect because we're all making shopping cart emoji jokes. And then non-Bigness 1020, thanks for the $4.99, said the chart is the oh-ish moment. She's saying, hey guys, I think we messed up. The cart, not the chart. I think we messed up. I hope y'all know this right. And exactly that, going right hand in hand here. And then thank you so much for the support, David Cox, the $1.99. And then Heart of Inspiration, good to see you. I'm curious why the state has been allowed to call witnesses, basically so they can then impeach them. Maybe you can do that in Georgia. I do believe you can do that in Georgia, and we can't do this in Florida. You're right. So good morning. This is something where the states differ. It's not allowable to call a witness for the sole purpose of impeaching them. And then through that impeachment, you're, of course, bringing in what you're impeaching them with, right? You're not supposed to do that. But in Georgia, I think it's allowable. We've seen it already, I think, in this case, hashed out before Copeland came up on the stand. So if you think it's unusual, it might be because you've watched a case in another state where that wasn't allowed. I believe that's actually in New Mexico, that's not allowed there either. It was mentioned a little bit with the Rust trial, Florida, but Georgia allows it. So thank you for the 10. And great distinctions here. You know, sometimes there's something federal, it applies everywhere, but other things are left up to the state.
And so whatever he says, he does, and the context, in the bigger, larger context is whatever Jeffrey says, Shannon does. That is a broad character statement in and of, or whatever crimes Jeffrey says Shannon commits. That's a broad character statement that would violate 404B, bad character evidence, and 403, Your Honor, as well. But then, you know, they get into how much Shannon's getting paid, and it's saying nothing. Well, guess who told me? Guess who told me that it's getting paid nothing? D. So.
Well, no, then Kenneth Copeland says no.
I'm sorry. You're right. And then they just talk about
How Kenneth Copeland can't flex because he doesn't get all this stuff.
right, and how Shannon's broke is
Yeah.
so I just don't see the relevance of this. I think it invites it's speaking in very broad terms, and it's just broad bad character evidence about Mr. Stillwell.
No, so it looks like Shannon told Copeland this, so it would be a party opponent statement, because he says,
Shannon told Copeland he doesn't get paid.
correct, for the stuff, but what, more importantly, not even to get paid or not getting paid, but that Shannon does anything Thug tells him to do.
No, the Shannon told me that is about Shannon not getting paid.
No, yes, Your Honor, let me be clear. Shannon tells Copeland that he doesn't get paid.
Right.
Yes.
Okay.
We're focused on the other portion
Yeah.
of what he says in here, which is he
Right.
does everything that Shannon tells him to do.
That
Um,
Thug tells him to do.
that Thug tells him to do. We have charged Mr. Williams with a leadership charge, which is count 56 of the indictments. And so we believe that that is relevant as it relates to Mr. Williams being the leader of the gang, and now a co-conspirator, member of the gang, is now telling law enforcement, this other co-conspirator, this other member of the gang does everything the leader tells him to do. So we believe that that portion is relevant. What is surprising to Kenneth Copeland is that he doesn't get paid to do it, that he does it for whatever reason that he does it. And so we believe that that entire section is relevant for, one, to show evidence of the leadership count, Your Honor, and that Mr. Stillwell has conversations with Mr. Copeland about his role in the gang and why in the gang.
I'm sorry, I'm not tracking, and I think I might be missing. Where are we getting that Shannon is the source of this?
Because if you watch the video, and maybe this is one of the ones where you might have to watch the video, he kind of whispers to him, and on page 189, detective says, he said Shannon. Shannon's telling him, but you have to see the video to see it in context, so we can play that portion.
Yeah, but again, that part was about the getting paid.
Yes.
And so what Mr. Shart is asking is, where's your information that Shannon is the source of Mr. Copeland's knowledge that Shannon does whatever Thug tells him?
So Shannon, so a few things. Mr. Copeland, Mr. Stillwell, and Mr. Garlington have all very close relationships.
Mhm.
They have known each other.
Yeah, that's established in the evidence.
Establishing the evidence. And so we believe that is his personal observation of what he notices between the interactions of Mr. Stillwell and Mr. Williams.
All right.
So That's what we believe that's his source of, now that's his lay opinion about what he's observing.
Anything else, Mr. Short, on this?
Shout out to Judge Glanville in the chat.
I am going to permit this over the 401 and 403 objections. And I don't believe, I mean, it's not improper character evidence. It's Mr. Copeland's firsthand knowledge, and it may be damaging to your client, but sometimes the state's evidence is damaging to the defense. All right, what's our next
So
one?
+2 for the cart.
Around the next one that we had, that the defense wanted out, was page 202, line 14 through line 20.
And we are in agreement, Ms. Hilton, 197, 14, 199, 4.
Yes.
Did I get it correct? For your notes, the exact line?
Page 197, line 14 through page 199, line 4. And that will be redacted, Your Honor.
You said 202, 5 to 19?
14 through 20.
Okay, let me ask a question that is entirely irrelevant to what we're doing right now, except for the fact that we're all sitting in this courtroom. How's the temperature for everybody? It seems a little hot for me.
I was gonna say the opposite, seems a little.
Dang. All right, well,
I agree with Ms. Hilton.
darn it. Okay, I'm just gonna have to get a fan up here. Well, it's not up here. Okay.
And Your Honor, heat does rise, so it may be hotter up on the bench.
Okay.
Your Honor, since we called it higher, we have a.
Yeah, we can have a convenience break. Sure, let's break for
Yeah,
until
convenience break.
10:30.
Shout
That's
out to the
one as
convenience
far as it'll
breaks.
go. It needs to be adjusted.
Let's see if anyone, Love's not in the room, so we probably won't get any interruptions after the court pans away, like we've gotten every other time. But just to be sure. Okay. And then for $4.99, Miss AV says, is it me or does the closed captions pop up word for word before they fully speak? So it is popping up beforehand. I think this is just like a, I don't know, like a 7-second delay that they're populating the closed captions, and we're seeing 7 seconds later the video on the screen. And then also we don't want to see the videos. I mean, it'll be way more condensed. That was it June 12th that the jury was sitting there and they just played the videos all day. They had to watch the video the whole day, and Love popped in every once in a while to ask a question, but it was just droning on and on and on. It was like the worst binge watching ever. And then Garrett says Love's new strategy is put the cart before her horse shit. And then Mahadi De Jesus says, I believe the cart is now the state's mascot. Yeah. Need t-shirts or something. I wish Law and Crime zoomed in on the cart for the break. I do also want to say thank you to Chris Gloss, who sent a $10 cash app that said, for being encouraged, keep executing on your plan. Which was really, really sweet. It actually came through last night. I wasn't streaming. I felt sick yesterday. I don't know why. I felt like I was actually getting a sore throat and not just losing my voice. So that was really, really nice to see that yesterday from Chris Gloss. And then Do What 22. I don't know if Do What 22 is watching with us now, but they just sent a $50 cash app that said, for the great YouTube channel, thank you for the hard work. So thank you so much. That is so sweet of you to send. I hope you're in the chat with us, but obviously if you're using a different name on Cash App, I don't think I've seen Do What 22 in the chat. So I don't know if I know you as another name on here. So, but thank you so much. If you have a different YouTube name, let us know. And then you guys, what do you guys think of today so far? We've got +2 for the state on certain sections of statements that can come in. that the defense largely, Shannon Stillwell, like Max Sharp was making the arguments, didn't want to come in. Some of it did seem related to Jeffrey Williams, though, because the one that she just ruled could come in, the last one, it was relating to Shannon being the source to Kenneth Copeland, that it was Young Thug, Jeffrey Williams, that controls everything. And she did call him Young Thug. So I don't know if they're going to ask for a correction, like maybe don't call Jeffrey Williams or Mr. Williams Young Thug in front of the jury. But you guys had called that out in the chat. And then we had I think a big win for the defense on those statements where Kenneth Copeland, it's what we saw them play the video clip of, where Kenneth Copeland was saying, oh, they told me they were going to kill him. And the closed caption wrote chimney instead of kill him or whatever. They got the transcription wrong. But it was those statements that he was saying, look, it's DK, it's Shannon Stillwell. They're going to kill him. They're going to kill Tick. They're going to shoot Tick. And Max Sharp won his argument. That is excluded. That cannot come in. So, and the argument, the reason the state really the court really pushed back on the state there, saying, look, where's the evidence that this is actually a co-conspirator statement? How is this in furtherance of gang activity? How is this in furtherance of YSL and to promote the reputation of YSL? Do you have any evidence? And Hilton couldn't provide it. Hilton couldn't say anything. She could just say it promotes cohesion. And the judge didn't agree. So she said, we're keeping that one out. So, oh, then thank you so much. So I was thinking for 199 says convenience versus comfort break. And then Miss AV, this trial is making us all sick. Yeah. I mean, I think you guys are calling it in the chat. Today is more productive, at least. Yeah, more productive. It is, Ramon. I see some states getting mollywopped. But yeah, it's a big difference. They've gone through all of these things. And these, so far, the two videos, the interviews, the first two videos that they tried to play, they just played incompleteness. They just played the whole thing. They played it to the jury already. And then they had a week where the jury was gone because they wanted to sort out evidentiary issues for the remaining videos. So they did that for a week. And here we are having to revisit that. We're revisiting some of those same statements that were already ruled on because the defense asked, we want to go through these again. Probably because Judge Glanville allowed all of it. And already we're seeing, to the state's dismay, Whitaker said, well, no, we can't just bring all of this in. That one's already, I'm shooting that one down. I'm going to agree with the defense here. But yeah, you guys are saying definitely more productive. Mr. Value says this judge is reasonable. Judge Glanville, the other judge that may or may not be so reasonable, is reasonable right now. Please hit the like button, you guys. And then let's show, I see Jason in here. I see Drea in here. Let's see. You guys, drop Drea's name in the chat. Drop Jason's name in the chat. They are great, great mods. And more importantly, they are great conversationalists in the chat. They're always contributing insight, good jokes and banter. I love them both so much. So show them some love too. They're out here working hard, hammering down with those wrenches. And then this is just a convenience break. Roll one up. And we're only gone until, we've got like 4 more minutes. It was a 10-minute break, so. And what do you guys think about Love coming in and out of the courtroom so much? Do you think it's, I mean, at one point she left and then she came back with the cart, but she's still gotten up and left since she brought that cart in. So do you guys think she's just got something else she's working on? She's got to step out of the courtroom for? Maybe she's got to take a phone call? Or what do you think she's up to? And then Garrett asks, thank you so much for your support all day today, Garrett. To get a mistrial, defense needs to read the judge. She's clearly protecting the bench, meaning herself and Glanville, so instead they should attack the DAs. Well, but she just said no to the motion to disqualify Love and Hilton. So I'm not sure, but I do agree 100% that the defense should read the judge. I think the judge makes it pretty clear the angle, the particular argument she's looking for. what she would consider is within her scope to make a decision on. What's a judicial discretion issue versus something that would, kick the can down the road to the appeals court. We've already heard her earlier today defer something. Hey, go take that up with the appeals court. That's not really an issue to sort out here. But I do think she gives cues. We saw it with how she did this questioning with, well, do you have evidence of this specific thing when it comes to the admissibility of the statements? Her questions are very telling as to what argument she's looking for somebody to make. And if the defense attorneys draw it back in, maybe take down some that hyperbolic arguing that Steele does typically tend to do, and I appreciate him for it, give her what she wants. Maybe you'll win a little bit more. So I think we're 50-50 with the state versus the defense today, because the defense did get that win with jury instructions with Glanville. Yeah, they might not get to use the word removed, but she seemed fine with the other stuff, and she's not exactly ruling out something that makes it clear Judge Glanville's gone for a reason. Because the state didn't counter argue. They didn't have one. And then, let's see, I saw the camera shake. So maybe people are coming back in. Or someone just hit the camera. Who knows? The sound is on, we'll know. Judge Glanville says that Love is texting him and calling him. So that's why she's going in and out of the courtroom. So, Miss Niagara, I mean, you didn't really miss all that much. There was some good moments where you saw the judge push, not really just on Hilton, but also on Max Shard. All right, so for Max Shard, for example, you're trying to argue Rule 403, which is the rule where, for admissibility, the probative value of something should outweigh the prejudicial value of something. And if that's not the case, maybe something shouldn't come in. Maybe a piece of evidence shouldn't come in. So Max Shard was trying to rely on that as one possible reason, in addition to hearsay and relevance. And then he also tacked on a little bit of 404, which is propensity, character evidence, prior bad acts. And the judge didn't really agree with any of those reasons for the specific statement they were looking at. The difficult part with how we're watching this is, since they're looking at the transcripts, they're not exactly reading the full statement out loud to tell us what it is they're talking about. We get some hints of it through the arguments. Oh, well, they were in possession of guns, so inherently, it's not really probative because we have other evidence that suggests it besides the statement itself. We already know that they had guns, right? So remove the probative argument away from that. We get some context of the statements, but as much as we celebrated not having to watch these videos, I do think if we got to play the clip, if we had to rely on that, us as the outsiders here would know exactly each statement. Every time they're arguing a new statement, we would know exactly what they were nitpicking, what they were trying to argue, the specific points they were pulling out of the statement that made it admissible or not admissible. And we're a little bit in the dark on the complete statements as they're arguing them, but overall, the judge has indicated a few times she seems to know a bit more of the context of the statements than the state seems to be able to articulate. Has anybody else felt like that the judge was able to articulate the order of events in regards to two of the statements? The tour bus shooting, and then the shooting of the house when Copeland was holding his child and had to go to the police station. She seemed to track the order of events without speculation in a much clearer way than the state could. So, kind of props to her for that. And there's a little bit of a pushback to Bruce Harvey's argument this morning where he said, I still don't think you're able to catch up, which I still agree with. But that was pretty impressive that she's doing a better job than the state, at least as far as the context of some of these statements. And then, Lottie B, good to see you. The state realizing they have to make actual legal arguments today, and then they're running with the carts. Is that the Christian Atkins emoji in the middle? I'm so glad you included Mr. Atkins. Look, so we got Love, or maybe that's Hilton first, and then Atkins, And then Love coming in with their carts of their evidence to make their case today. I love emojis. Positive masculinity, thanks so much for the 2. Judge Glanville is standing outside the door. He's texting us from in the courtroom. Judge Glanville, apply for a Rule 22. Mermsy for the 5, thank you so much. Attorney Love is going in and out because she doesn't respect the court. Remember when Whitaker stated she wanted less distractions? Yeah, and that's the thing, like, luckily we don't hear much of, I don't really hear any of the door opening and closing. I'm assuming if I don't hear it, you guys don't either. We're watching the same stream. But that doesn't mean that they can't hear it. And, you know, the judge at the bench looking out that way, she's got to see the doors moving and all the commotion. And it can be distracting. And they might be able to hear it. It might distract the people in the courtroom, even if I'm not hearing it here through the law and crime stream. I've watched other live court trials where you can hear the door slamming, and it's just like, you can understand why a judge gets frustrated by it. But yeah, it's interesting that she's going in and out. Thank you so much again for the 5. Aaliyah, so good to see you. I always appreciate seeing you. Thank you so much for the super sticker. Garrett is busy assigning weekend homework. It's Friday. Well, that's why I think it's interesting that the table behind her, the guys that usually sit there, it's usually 2 guys, but I think sometimes it's been 3 people, but usually just the 2 guys. They're not there today, which is interesting. So maybe the cart usually sits back with them off screen. I don't know. And then Garrett for the 2, sorry, I did that one. And then Dream is a new member. Thanks so much for becoming a member. You now have Mario Kart emojis, which is different than the shopping cart emoji we've been highlighting today. So make sure you use your member emojis. Race in the chat. And then Albert Edens for the 10. Thank you so much. I see Steele cross-examine Copeland and slipping in the judge being removed in one of his questions to Copeland. Guys, it's going to be a fun day. I know I said I don't really watch the testimony days because I usually go in someone else's chat for that. I love evidentiary hearings. I love motions. I love the documents. But I typically watch actual trial testimony with somebody else. I do think I might do the streams when and if Kenneth Copeland gets back on the stand for this exact reason. I want to see how they maneuver, how the defense attorneys maneuver and extract these things that they might not be able to put into jury instructions. And I also want to see, I believe Steele will, I believe there are certain moments where as a criminal defense attorney, we will see somebody make the play call. I might overstep the line and ask a question with verbiage that maybe the judge is going to call me out on. But I'm going to ask it because I know the jury's going to hear it. And I love stuff like that. So I totally think I'm going to stream, if not his whole testimony. It'd be easier to stream his testimony now that wouldn't include these long expanses of video. So I might do all of it, but I definitely want to stream cross-examination. I can't wait for it for the exact same reason you're pointing out. Like, we're going to see a lot of great trial attorney work. And then Sarah JB93 for the 499 says, has Whitaker ruled on the mistrial motion for Weinstein? Nope, that is still outstanding. And don't forget that Weinstein did add that supplement all about the June 7th, the new transcript that was disclosed on Tuesday to the defense for the first time. And then no ruling on the mistrial motion. Bruce Harvey did also try to renew his motion orally today, saying like, look, it's just still impossible. So we're coming back, you guys, but there are still outstanding mistrial motions sitting out there. And she's hot, so she tied the hair back, you guys. And then good to see you, Ghost. Hey, Nick. Snipe away. Put a water gun emoji in the chat.
I have 5. That is my opinion.
If you're amending what you did before, that's fine, but before I have for you, page 202, 14 through 20, but you're saying it's.
I have 202, 5 to 19 in my notes, but either way.
Okay.
5,
Okay.
Just a off the cuff, not referring to any specific incident of Kenneth and Shannon getting into arguments and then people coming to shoot at them. And then Kenneth saying Shannon doesn't stand for people shooting at him, is my interpretation. And then where does Shannon keep his guns at? Kenneth Copeland says, shoot on him. And that man got a gun every day. He gonna run though. And we're not talking about a specific incident. We're not talking about an overt act. We're just talking about character. Shannon keeps a gun on him. Get into arguments with people and they shoot at us. Again, not talking about a specific act, just generally, and Shannon ain't going for it when people shoot at us. I mean, all of this is just.
All right, so
very
let's
prejudicial and harmful.
kind of take it piece by piece. So there's kind of like the 5 through 13, and then the kind of 14 through 19.
Yes, Your Honor. So first with 5 through 13, Mr. Copeland talks within this interview specifically about another retaliatory shooting that occurred in January of 2015. Again, after Donovan Thomas's murder, there's an incident in which Mr. Copeland, Mr. Garlington, and Mr. Stillwell, I believe they're all in the car together when and they're driving on the highway somewhere near University Avenue and I-75, and the opposition gang shoots at their vehicle. Either before this portion or after, Mr. Copeland tells the detectives that Shannon was upset with him because he didn't want to shoot back at the other car. So I think when you think about that part of the transcript in context with this, what he's saying in lines 5 through 8, but when I'm saying me and Shannon get in an argument plenty of times because these N-words done came, shot at us, or did something. And what I believe you hear him say, I never did shoot back at him. And so he's talking about that particular
And
incident.
Shannon didn't like that. Yeah, I saw that in other interviews. Okay. And
Yes.
so
we believe that that's relevant, that furthers what he just said earlier in this interview about Shannon not liking the fact that he was not retaliating back against the individuals shooting at them. Now, when you go down to 14 through 19, Your Honor, we do not believe that this is bad character, incidental character, Your Honor. We have a case that I would like to cite for the court, which is Lyons v. State, 309 Georgia 15, which is a 2020 case, Your Honor. And this case specifically talks about the defendant in this case thought that the trial court abuses discretion in admitting a photograph showing the defendant in possession of a gun because it improperly placed his character in issue and was highly prejudicial. And the Supreme Court disagreed, and I'll just go to what they cited.
309 Georgia
15.
yeah, I mean, is it basically just for the proposition that owning guns and having guns isn't character evidence?
Correct, Your Honor. And what we've also, and it won't, owning or frequently carrying a pistol does not impute to him generally bad character, Your Honor.
Okay.
And so the fact that his friend knows that he keeps the gun on him would be relevant, especially in this overall conspiracy and gang indictment that we have before the court, Your Honor.
Anything else, Mr. Sharp?
I'm trying to look at Lyons
Sure.
real quick because I have a suspicion.
If you have a,
Lyons a convicted felon?
Your Honor, I don't know if Lyons was a convicted felon, and I have not found a case in which yet in which the court distinguishes if a individual is a convicted felon, that imputes more bad character than not. And I don't know if that's the argument that Mr. Shard is about to present to the court.
Well, okay. So I'm reading Lyons very quickly, but it seems that in Lyons, there was an argument that the gun in the picture could have been the weapon used in the crime. I mean, that's not what we're dealing with here.
Okay, but is it standing for the, well, whether it stands for it or not, there is a general proposition in the law in Georgia that owning and frequently carrying guns isn't bad character evidence.
Unless you're a convicted felon.
Do you have evidence? I mean, not evidence, do you have case law on that?
I don't, but
Maybe let's put that issue on pause then, and y'all do some research and get back to me on it, because that is maybe potentially a different issue than just in general. So we'll have y'all take a look into that.
But I'll also point out in Lyons, Your Honor, it says the photograph was relevant to show that Lyons at some point possessed the type of gun used in the crimes at issue. The probative value of this evidence was not substantially outweighed by its prejudice. So we don't have the same probative value here either.
All right, well, how about we come back to the 14 through 19 portion of this page with the gun.
And I never argued about the first part, 5 to 13. I don't believe I did.
Go ahead.
But it's, again, we've got an intrinsic act of them being shot at that's come out in trial. Mr. Copeland and Mr. Stillwell being shot at.
Right.
I don't know why. I don't understand the relevance other than propensity to show that Mr. Stillwell's a quote unquote hothead. I don't know what the relevance of him being upset that we didn't fire back or retaliate or do something. I'm not following how that's relevant.
Okay.
Your Honor, it's not relevant to show he's a hothead. It's irrelevant to show that he wants to retaliate against the opposing gang in the middle of a gang war between these two rival gangs. And so that evidence that while one YSL member didn't want to retaliate, this one wanted to retaliate in this ongoing war between YSL and YFN. And he's also charged in another retaliatory shooting later on in 2022 as still part of this ongoing war between these two rival gangs. So from 2015 to 2022, this war is going on, and Shannon is one of the members who wants to retaliate. And I think that this is evidence of that.
All right. Well, I mean, it also shows the relationship between the two of them, which I would think is relevant to sorting out his basis for. Okay. I am going to permit the 5 through 13 portion in over the objections and don't find it substantially more prejudicial than probative under 403. And y'all can get back to me with any law you can find on 14 through 19. So we'll remember to revisit that.
You want a case, Your Honor?
Yeah, if you've got one now, that'd be great.
So Hall, Hall versus State. It's old. It's 180 Georgia Appeal 210.
I'm sorry, say the first three, 280?
No.
What did you say?
180.
180, an oldie.
We're going back.
180 Georgia.
Appeal
Oh, app. Okay.
210.
Okay.
And it's 348 Southeast 2D 736. It's 1986.
Okay.
And Your Honor, what it says is the defendant stated on direct that he knew what was in the bag. At worst, he admitted only one of the elements of the crime of possession of a firearm by a convicted felon. The simple rule announced by the Phillips court clearly states that character is not an issue until a defendant admits any prior criminal conduct. However, no criminal conduct could be shown until after is italicized, the prior conviction was admitted into evidence over the objection of defense counsel, because possession of a gun is presumptively lawful. Allowing the prior conviction into evidence in order to place the defendant's character in issue demands circular logic and defies even the broader parameters of the simple rule in Phillips. Here, I'm telling the court that there's an exhibit, I don't know the number, that Mr. Stillwell is a convicted felon.
And additionally, he's charged with possession of a firearm by a convicted felon several times in this indictment. So that increases the prejudicial value because it goes right to a substantive charge.
And
I
to
would
say
think-
that he runs around, I'm sorry, did I interrupt?
Go ahead.
To say that he runs around, he being Mr. Stillwell, runs around with a gun at all times, his conviction is back, it's in this case. Somebody, please help me, but I'm going to tell you it is before the supposed conspiracy even started. The conviction's back to like 2012, I think, but I'm not sure on that. I don't want to make that representation.
The trial, Judge Glanville allowed the state over my objection to actually admit, I think, 5 prior convictions of Mr. Stillwell to establish he was a convicted felon.
Okay. All right, I'll take a look at it over the lunch break and give the state a chance to come up with their own
Okay, so pin that, because that's going to be.
case law on that. And so, I
See
mean,
what she
are y'all
rules.
kind of arguing that this is, and by y'all, I mean the defense, are you arguing, I mean, I know you're arguing, so this makes it really prejudicial because it makes it more, well, I don't know, I don't want to rephrase, but are you saying, well, this evidence makes it more likely that they will find him guilty of possessing a firearm as a convicted felon as charged?
Right, he's charged with, I think, 2 counts. Maybe
Okay.
3. And essentially, Mr. Copeland saying, hey, he always illegally carries a gun as a possession,
Okay.
as a convicted felon. And of course, that is, in our estimation, very prejudicial and shows propensity, which should not be considered by the jury when they consider these specific
All right.
charges.
So on the propensity issue, though, are you saying this is like 404B evidence?
Well, they haven't given 404B notice.
Right, because all of this is intrinsic. And so I'm thinking if it's going to be out on the basis of its, illegal propensity evidence, it would have to not already be in as intrinsic evidence.
Well, my understanding, and I know Your Honor has a long background in appellate law, so I could be wrong. My understanding is intrinsic evidence we're dealing with specific acts. This isn't dealing with a specific act. This is just a gentleman saying, oh,
This man is known to carry
this man
guns.
always carries guns. He always has one on him. So, I mean, it would be like if someone's charged with murder and then like someone just says in a tape, oh, well, this guy's everyone knows he's the biggest killer of all time, and it's just like, well, that's a problem in front of the jury.
Well, okay. So, I mean, this is essentially, to my knowledge, by me, I mean, at this point, Copeland saying, hey, as far as I know him, and I know him, he carries a gun on him all of the time, which obviously y'all would not like to come in because it does make it more likely that he had a gun on the instances in which he's charged in the indictment with having a gun. But why does that get excluded? So y'all find some law and then we'll take it up after you've presented whatever you have and after lunch.
I do think Shard got a little
'Cause
too emotional there.
I'm not sure that
What's the reasoning?
being able to say, I know, from my own personal knowledge of him, that he typically carries a gun is excludable simply because it makes it more likely that some of the charges against him might be true. That makes it relevant. So I don't know, y'all come up with something, hand it to me later. Let's move on to the next thing. We'll circle back on that one.
are we in agreement on 21320 to 21416?
Yes.
You agree, we're in agreement.
That it's out. Okay. All right.
And I just want to confirm, we're in agreement 22011 to 21?
I have 22012 through 15.
Well, 11 just says overlapping conversation.
You said to 15?
Yeah, 12 to half of 15, so we stop after,
Either?
yes.
Okay, all right, we're in agreement. And then 22217 to 223.6, is that what you have as next?
Yes, 222. Yes, 222 last time, 223 last.
All right, let me get to that. Sorry, I was reading the wrong page.
What do we want to?
All right.
Your Honor, I'm just going by the transcript I have and the number of, the amount of writing I have on it. I don't know if the transcript, this might be one that we need to hear the
Okay.
audio.
Do you want to tell me what your objection is or objections are?
Well, from my notes, I believe that Mr. Copeland is claiming that the game was, something involving the game was shot up
Mm-hmm.
and that Jeffrey supposedly told Shannon to do it. Now, this doesn't go to admissibility. I don't know of anything involving the game being shot up, first of all. So I think this is just a big lie. But that being said, the game had nothing. I mean, this is an overt act. The game is a gentleman named, I think his name is Jason. He is not, to my knowledge, we've heard no evidence that he's affiliated with Lil Wayne or anything else. This is just like a completely separate incident that's uncharged in count 1 and uncharged in any other count as well.
So, Your Honor, as I mentioned earlier, during the period of time when there was the conflict between Mr. Williams and Mr. Dwayne Carter,
Mm-hmm.
a number of other artists took sides And we believe that the game took the side of Mr. Carter. And during that portion of time, we actually have entered into a video in which Shannon Stillwell and Quindarius Zachary are in a video threatening the game. That, you know, if he comes here, he gonna have to come see me, and he's threatening him.
All right.
Now, what they're discussing in this portion, my understanding, but we'll play it, is Detective Dennis asks, well, how is the beef with Game and them?
Mm-hmm,
And Kenneth says the Game was fixing to get his ass shot,
mm-hmm.
shot up, and Thug, and would have, if Thug would, and Thug would have and told Shannon to do it. Shannon told me out
It
of
probably
his,
says if Thug would have told Shannon to
To
do
do-
it, because then it says Thug told him no.
right, and he says Shannon told me out of his mouth he was up.
Where does it say Shannon told me?
When you
out of
hear
his-
it, so when you hear where it's indiscernible, so I think
Okay.
the last time we heard this portion, there was a lot of dispute in the courtroom as to what it
Okay.
said, so we need to play it,
All right.
and
I also,
we'll believe that's the context that's right.
Okay, but so this is essentially somebody not doing something. Maybe y'all want this in. Well, you wouldn't, but
Right.
Mr. Williams might.
But
So why is it relevant? Because
so it shows that Shannon's ready to do anything on behalf of YSL is
All right.
why we believe it's right.
all right.
that's exactly why it's problematic.
Okay, it's problematic. Why is it evidentially inadmissible?
Well, because it's showing what type of, I'm not asserting this, but the state's asserting is showing what type of person Shannon is. Not that he did this or did that, it's just, as far as the charged acts, it's just showing, oh, he's a hothead that's ready for action. And
Okay.
that's what-
Why is that evidentially inadmissible?
Because it's propensity.
To say this is somebody who stands ready to act.
Well, yes. Well, not only stands ready to act, but wanted to act. On, you know, it's just like,
All right.
it's bad character, and it's, he's not charged with these events, and they're just essentially Mr. Copeland saying he's the type of guy that would do these events. And I just don't think that he's the type of guy argument. I think that just gets to bad character, and I think that's the essence of bad character and propensity. I respect it.
Okay, well, maybe you want to come up with some law that shows me that it's inadmissible, evidentially, character evidence to establish in a gang RICO case or something similar that somebody who's essentially charged with doing tasks for the alleged leader is ready to do such tasks or anything that the alleged leader sets.
And Your Honor, also, I'm going to defer to the tape when we hear it, and I've been notorious for mishearing some things on tapes, but I'm hearing was shot up, and if that's what's being said, I would ask that the state provide us with
Okay.
some reports about something happening to the game at some point. Because I don't know anything about that.
John, can I add
Yeah,
flavor when you get a chance?
I'm listening.
Okay, thank you. I also think it's important for the court to be aware that the state did not call Mr. Carter, Mr. Dwayne Carter. He's on their witness list. They said that they were going to call him. They did not call Mr. Brian Williams. He's on
Okay.
their witness list. They stated at one point they were going to call him because we have a short list. And evidence came out that, and I don't know how familiar the court is, but when people are in the entertainment business, They advertise themselves, promote themselves, drum up interest by doing things that are, I'm promoting an event for young children, or come to my concert, I'm going to kill somebody. It floods the internet, and it's a marketing tool. So you're being told like it's proven. It's not proven that there was this feud and Mr. Stillwell was going to do this. There's zero evidence. I've interviewed these people that the game, it's a band. It's a musical band. Game is GAME. That they were shot at, that they were bothered, that there was any issue. This is all the theory of the state. It's also, their real theory is that there's this gang war. I'm just repeating a term, between a alleged gang of YSL and alleged gang of IF. These other people have nothing to do with that. I heard you ask earlier, so this was involved in the, there's nothing. This is just what we've been dealing with in this case. It's just everything has come in on a state's theory without the evidence backing it up.
Yeah.
And then the gang experts, quote unquote, come in and they say, well, this is what we said, and we found out. And I ask, well, who'd you find out from? And they say, I don't know. I don't have a file. I can't give you a report. And that's what we've been dealing with. Ms. Hilton said earlier, oh, and Mr. Winfrey pled guilty to this. That's a subject of a motion that I don't think you touched on yet, but I did an attorney proffer. I sent it to you once you were announced as the Honorable Court taking over. I sent you 8 attachments. And what happened in that is Mr. Winfrey did plead guilty. He was charged in another county, Cobb County, before the Honorable Judge Staley. And he pled guilty. He was charged with a RICO violation, gang act. It was a long indictment. He was indicted alone with the shooting on April 26th of 2015. You've been referred to it today as Little Wayne bus shooting.
Okay.
What the state did, though, was rather shocking. They had Detective Racy on the stand. Over objection, they played a recording from jail of 2 people who are not testifying in the case, saying that when Mr. Winfrey gets out of jail in Cobb County, there's $250,000, $250,000, and a Porsche waiting for him, a Porsche vehicle waiting for him. The state took that with Detective Racy, it was under the directive of Ms. Hilton, and said, well, that's his reward for not folding and giving testimony against the gang. And then Ms. Hilton asks Detective Racy, and within a month, Mr. Winfrey pled guilty. So I asked to approach the bench. There's a case. It's Winfrey versus State in the Georgia Supreme Court. I could get to the site. That vacated that guilty plea. That guilty plea was found to be coerced by the Honorable Judge Staley, and it's void and cannot be used. I raised that with Judge Glanville to say, well, how did that happen just now? Judge Glanville would not let me ask Detective Racy about the fact that Judge Staley coerced the plea. It was not a plea. The state comes back after that conference, say, and then within the next year, was there just, for whatever reason, another guilty plea entered by Mr. Winfrey? That wasn't true. It was 5 years later. And Mr. Winfrey entered an Alfred plea, specifically said, I do not admit guilt. This is on the record.
Yeah.
And he had the Honorable Steve Sadow, which is S-A-D-O-W, representing him. And he specifically said, I'm going to trial, except I've been in jail for 5 years and I have a time served sentence. The point I'm trying to make to you, and thank you for allowing me to speak a long time. I didn't expect to go into all this, but it is, you need the lawyers to tell you what went on because you're catching up and accurately. And just to say that this is intrinsic, this is extrinsic evidence. This is not dealing with the gang war. This is dealing with an issue that arguably it's up to the jury. I understand that. Arguably is all advertising or puffing. And to act like this is reality without giving you the other side is just wrong. So that's what I want.
All right, thank you. I understand that a lot of this
portions of this case, the state's theory is, hey, they may be saying this in the context of promoting or of singing even, but they're talking about real life and we can use it as evidence. I know that the defense position is, and I assume you're going to argue to the jury if we get to that, is y'all, this is a music industry kind of, this is how the business works. And that's all it is. And that's not up to me to decide. That's up to the jury to decide whether, you know, which theory they think is the convincing one and whether the state has proven its case beyond a reasonable doubt or not. So I appreciate the background and I understand that. With regard to the guilty plea that at the time, I mean, he did enter a guilty plea. My understanding is, and I read what you had filed, I didn't know that there was anything still pending in terms of anything for me to decide because that's already happened in this case. And even if his later plea was an Alford, we all know that an Alford plea is this, I mean, he may not be admitting guilt, but it can be used. He's saying, I'm pleading guilty because I think it's in my best interest. Man, I've already basically done the time. I might as well plead guilty and have this done and in my past, but it still can be used as evidence against him. So, you know, I may have, I don't know what I would have done with regard to whether I let you probe that issue or not with this witness. But that already happened. So is there anything still pending that I need to rule on with regard to that?
Yes, and this has happened a lot. So Mr. Winfrey, to my belief, is not going to testify either. He's charged in this case.
Okay.
He's in the Fulton County Jail, as, I'm going to say has counsel, but now I'm not 100% sure. I believe he has counsel, but I'm not sure. But there's a case, so he's not here. We can't cross-examine him. The tendering of an Alford plea or a guilty plea or a NOLO plea. NOLO plea can't be used. So
Well,
ignore that.
right.
A guilty plea or an Alford plea. The person, Mr. Williams, has the right, that's a confrontation clause. That's a statement made in court for purpose of prosecution. That triggers a confrontation clause.
Mm-hmm.
And that's under Overstreet, Overstreet versus State. It's 312 Georgia, 565. Your Honor, it's in footnote 8, 864 Southeast 2D 14, 2021. And in that footnote, it argued a case called State versus Jefferson, like the third president. And what it says is a co-defendant, co-indictee's guilty plea, when they're not testifying, is a confrontation clause violation to be used against, in this case, Mr. Williams.
All right.
So
Let me ask you something. So what he is indicted for in this case, this,
RICO.
right, this, you know, this instant case, that's not what he pled guilty to before Judge Staley and then entered a Galford plea to later, is it?
He did, because it's also an overt act.
All right, he pled guilty to something that's alleged as an overt act as part of RICO.
That's true.
Okay.
He being, I'm not.
He Winfrey.
Yes, that's exactly
Okay.
right. But, you know, when saying, yeah, but he pled guilty and it came in, none of it, in my opinion, this is my argument, should have come in because you need the person, in this case, Mr. Winfrey, so he can be asked, why did you plead guilty? The jurors have no clue. And the state did not put in his guilty plea. So it's all oral over objection. So I want you to understand this. When the state is telling you, and I went backwards, I guess, but you know, the man already took responsibility, pled guilty, we proved all that. They really didn't prove it. They got hearsay evidence, which I objected to, and therefore it's an objection. Judge Glanville disagreed, but it shouldn't have come in. Judge Glanville let it in for a statement against a co-conspirator, a statement against his interests. He's not here. That doesn't apply either. That man's not on trial.
Okay, so I'm asking what's pending for me
What's
to
pending
decide.
for you is going to repeat. The state constantly is putting on guilty pleas of people who are not here, who are not going to testify, and then they use it as a weapon against Mr. Williams. So that's one thing. And then the second thing that you're really why I stood up, I just want you to understand, it is not like this has been proven. You know, the game and that they were shot at, it's just a theory. And I understand you're saying, yes, then they have to prove it and it's up to a jury. I agree with that. But I don't want you to just buy into like, oh, this is so important because it's already in evidence and the state needs to, you know,
Okay.
evidence is prejudicial.
All right, thank you.
Okay, so I'm not even sure where we were
I
with
think we were
regard
gonna
to this.
play it. because
Yes.
we're just-
Exactly. Okay.
Your Honor, we'll start just slightly before at 12/16/45. And this will probably be somewhere around page 222, maybe around line 1.
Well, him, he not taking no shit. He not taking no shit from nobody. Well, this, nobody else care about nobody else. You know what I'm saying? Thug ain't taking shit from nobody.
Well, how did the beef with Game in?
The game he did, shut up, he told Shan to do it. Shan told me his mother, he was up there winning.
Just give me the word.
Yep. And Doug told him no. Say some the GD, I can't Nipsey Hussey, something like that. He ended the beef. You know what I'm saying? He stopped. I mean, I ain't here to play. You know what I mean? I just don't want to go to jail. I mean,
And we're gonna stop it at 12/17.
All right, if y'all want me to figure out what got said, then I'm gonna have to have that tape. I'm gonna have to slow it down. I have no idea what he said. I mean, I know a lot of it, but the little part that y'all don't know either.
Look at him
I'd have to
laughing.
Listen to it a couple of times. So I don't know.
You want to play it back?
Yeah.
Something else?
Yeah. Not the whole thing, just that part that is kind of hard to, like line 19, the game fixing to get their ass shot up, as I think. But after that is what the.
Yeah, sorry for my long
Before you
comfort
hit
break.
play, is the sound coming out of that little white speaker? Is there?
I
any
had a
way could
client
get
call. They
any
have
kind of
a-
speaker closer to me.
They had an issue with their email sending because they never set up their DNS records that show that
I
they
mean, is that
own
where
their
that's coming from?
their domain. So all their emails were flagged as spam. So I had to fix that.
Something like that. He ended the beef.
It may not move far. In which case,
I think that's about as far.
it's not gonna do much. So just put it back where it was. Thanks, though.
And then thank you, Emmanuel McRae, for the 20. Who directed the state to go after YSL? The competition? The cabal? Who?
Girl, I don't know if we can play it slower in evidence review, but I can
Well,
play it
just-
multiple times as evidence
just-
reviewer.
Who trying to do that? Well, him, he not taking no shit. He not taking no shit from nobody. Well, this, nobody else care about nobody else. You know what I'm saying? Thug ain't taking shit from nobody.
Well, how did the beef with Game in?
The game he did, shut up, his dog with told Shan to do it. Shan told me his mother, he was up there winning.
What I hear them saying is the game fixing to get his ass shot up if Thug had told Shannon to do it.
And I think it's
If.
Okay.
That's the most discernible.
Just give me the word.
Yep. And Doug told him no. Say, turn on and do it. The game he did, shut up, his dog with told Shan to do it. Shan told me his mother, he was up there winning.
Just give me the word.
Yep.
Shannon, nobody's something
The
like,
game begins, shut up and do it.
if Doug would have told Shannon to do it.
Well, how does the beef with game in?
The game begins, shut up and do it. We told Shannon do it. Shannon told me tomorrow you saw that win.
Just give me the word.
Yep.
I hear.
A theory?
They told me out of his mouth.
Okay, well, I assume that matters. So
Doesn't matter.
I will listen to that in my chambers where I can actually hear it a little better. So we'll have to revisit that as well, but go ahead.
I'm not trying to beat a dead horse here. I think that when it comes down to it, my objection is that, first of all, anything involving the gang is not charged, is not in the indictment at all. So it is extrinsic in my estimation. I don't know how this fits into the story or is needed to complete the story. In addition, it is bad character evidence about my client. It's a prior, if it's extrinsic, it's a prior bad act as alleged. And also, I'm not hearing the told me out my own mouth. So there's speculation involved as well, or, I don't know what the source of his knowledge is, but he's not saying that he was with Shannon waiting on the game. So there's that issue as well.
Okay, so with regard to that issue, they probably are not doing police questioning, thinking I need to establish exactly who everybody. It may be that through this, we don't know. And if it comes in, you may just have to ask and maybe establish, or maybe beforehand, what was the source of your knowledge when we have Mr. Copeland and not the jury, and we can find out, is it total rank hearsay or is it not? I don't know.
As long as we're allowed to do it outside the presence
Yeah.
of the jury.
Okay, and then with there being a prior bad act, there is no act here, so it can't be a prior bad act.
Well, the act is
Being willing to do what
Well,
Doug
Mr.
says.
Mr. Stillwell is, according to Mr. Copeland, is waiting, I don't know where, waiting somewhere to shoot another individual. That's an act.
I'm not sure it's a crime to be willing to do it if you don't do it
No,
unless.
I'm saying waiting, not, I heard waiting, like he was in, I don't know, I'm just making this up. I'm speculating, but an alleyway or something. I hear he was waiting.
Okay, I don't think that's what it said, but I'll re-listen to it. Okay, let's move on to the next one.
The next one. We agree with, based on, of course, prior ruling, cover deck, page 231, line 5 through 233, line 24.
I think it should start at 230, line 20.
Yeah, 230, line 24.
Well,
And then shout out to
230,
Garrett,
line 20
too.
says, this is Mr. Copeland speaking. That car that they're saying shot the tour bus. That seems pretty clear to be hearsay.
That's fine, Ryder. Page 230, line 20.
And where did you say it ended?
I feel like Atkins would be so much better at doing this. But Garrett's completely right. Judge Whitaker already said she wants 30 weeks when the jury comes back. We're not going to keep dragging this case out. If Copeland is willing to sit for what he expected to be a 2-year trial, he might be willing to sit for 30 weeks. If Whitaker would want to hold him in contempt that long. So, what do you guys think?
Okay.
All right,
We're in agreement with that.
all right.
And then the immunity order,
I have that we agree upon page 243, line 9, and page 256, line 7.
I have 241, line 3. Before we get there, to 242, line 21.
the immunity order, I want to see the request, the motion for the immunity order, to see the reasons given why we need one. I don't know if the defense can take issue with that or how, because it's really Fonnie Willis that signed off on it.
One of Pee Wee Longway's people shooting up a club named La Cura, which is on Metropolitan, and Kenneth Copeland was initially blamed for it, but it's just talk about that shooting, and then there's talk about Tick, who's Trontavious Stevens, robbing Bentley, who's known as OG Bentley, who is Kelvin Treadwell. It's just a bunch of, I presume rumors, because I don't think Mr. Copeland was there, about completely unrelated things that he's heard.
Okay, so 241, line 1 through 242, line 14.
I have 242 line. Yeah, that's fine.
All right, so y'all agree that's out? Yes, no?
Oh,
Okay.
yes, I'm sorry. And then this hill, the next one I have is 243 line. I'm going to say 1 because I don't have a line. 243 all the way to 248 line 11.
All right, so I'm glad we're doing this. What I want y'all to do is get together beforehand, and everything that is agreed to, y'all agree that it's agreed to, so that we spend the court time talking about the stuff that's not agreed to, okay?
Yes, Sean.
And I know y'all are doing the
Atkins.
best you can, but try to do better.
So the next one that's not agreed to, I can move on to, that I think is page 321, line 21 through 23.
All right, let me get there.
So
Okay.
Is the objection speculation?
yes,
So,
like personal knowledge.
so here here, Your Honor, he's repeating, this is a part of co-conspirator, this is the night of the shooting.
Mhm.
Murder Donovan Thomas.
Okay.
And he's repeating what Demetrian told him regarding what happened with the murder. And specifically that line where he says, I guess that's where Thug went.
Mhm.
When you listen to Kenneth Copeland, it's not speculation, because this is what.
This is just the way he talks.
But even when you look at line 24.
I
he
guess
says,
sounds like
"And then
speculation to
Thug
me."
at Bentley spot, which was more of an affirmative. This happened based upon what Demetrian told him. So this is all, in relation to what we argued the other day regarding co-conspirator.
Where is the state getting that he got this particular information from Mr. Garland?
Because throughout here, he talks about, this is what Demetrian told him when he got into the car with him and explained the murder to him once they got to the car.
I thought when they got in the car, all they had time to say was they shot nut. And then like some other little tiny bit after somebody else got out of the car again.
And then that's when they drove up to, Mr.
Sky
Williams'
House or wherever.
And Nard got out the car, and it's our understanding that's when more detail came in. That
Okay, and maybe you're understanding, where is the evidence that all of that got said in the car? You might need some time to come up with that.
I'll look again, but what we do know is that he says in this interview that Demetrian told him everything that happened that night. Now, whether
All right,
that was
well,
in the car or not,
I mean, if you show me the part where he says, D told me, what's his name? What's his little D from Mechanicsville, told me everything that went down that night, then we're in a different situation.
So, visiting.
20. All right, so I see if we go up a page on 320, around line 9 through 13, or really 17, 18. That he's at least saying, D told me this is all the people that were involved, and he personally knew it because he was with them.
if we go to page 318, Your Honor.
Okay.
Lines 10.
Right.
And he says, this is what little D broke the story down. He said, and then he goes into what Demetrian said, which is all the way in the Sky House, and said they rode past and met outside, they went somewhere to change cars, and that was it.
Mm-hmm.
That's the changing cars.
He continues to elaborate.
Right, so that's all what happened beforehand.
Right.
And I think,
That's why I didn't object, no.
Right.
I'm objecting
So,
to co-conspiracy.
I understand. So where's the part where we have any kind of foundation that, and I mean, maybe it's just in context, it's clear he told him the whole thing from start to finish. Maybe, but y'all show me where that is.
They should know.
And I guess Lil D
They've
broke the
argued this
story
before.
down, maybe.
So, our understanding from this interview is that the breaking down happened in the car.
What doesn't matter where it happened, as long as it did happen, as long as you have some evidence that shows he told him all of it.
This, yes, from
Okay.
everything he says to, the detective in this interview, everything about that murder that night is what.
This is, okay, this is him saying, here's what he told me. Okay. All right, I'll take a look at it more in context over the lunch break. But that seems to be a pretty good basis for arguing that.
And he says it earlier, so this is the second time he's telling the story, so for the purpose of this interview, Your Honor.
Okay.
He tells the story initially early on in the morning to Detective Gaither, Detective Dennis,
Yep.
the gang detectives. And then later they bring in Detective Thorpe, who's the homicide, the lead detective on the Thomas case, and he reiterates the story again with a little bit more detail in front of Detective
Okay.
Thorpe. So he's telling them all.
All right, and he's already said, I got it all from Lil Dig. Okay, all right, I mean, I think
The
that
captions.
is satisfactory, as, yeah, he had a source for this.
Okay, so seems like that argument is an L for the defense.
The next.
I have 341 to 341, I think 19 to 350, 17.
Is that the whole BB?
Correct.
Yeah, that's not an issue.
Okay.
So that is out by agreement? Okay,
And then 356, 9 to 19 was the same issue, I think.
Yes, I think it's, I have the full redaction, 341 line 19 through 350 line 13.
What about 356?
And Miss AB, you're right. They argued some of this stuff in court already in those weeks of June where the jury was gone.
Yes.
But the defense wanted to revisit some stuff because they think some extra stuff that wasn't excluded should be excluded.
And Ms. Hilton, the next one I have is 361, line 1 to 362, 10. I don't know if we had agreed to that or not.
What I have as the final is that we were going to take out 361, part of line 16, so line 17, where it says Shannon shot up that tour bus.
Say the lines one more time.
Half of line 16 and a portion of line 17, the sentence reads Shannon shot up that tour bus.
That's exactly why, Miss Hawkins. Because they're not revisiting things that were before he was recused. She's only revisiting this because it happened after that June 12th recusal motion was filed and then subsequently granted. Just bring Woody in today.
all right, so that's out by agreement. There may be another part we need to take up, right?
Right, well, part of that, Detective Thorpe says, listen, this is 362 lines 7 to 10, which was included in my objection. I guess the state doesn't agree with that. Detective Thorpe, listen, but you said a key piece of stuff we've been asking you. You said without a hesitation, without a doubt, Shannon the one who shot the gun. And then
Adele?
Kenneth says, y'all keep thinking I'm doing stuff. And I'm not 100% certain on the context as I sit here now, but it's right after discussing the Lil Wayne.
Well, what I believe is happening in this portion, Your Honor, if you go back to 361, Kenneth is elaborating that he's not the problem, it's Shannon. And so he goes on and he's saying Shannon is doing everything. Specifically, he says Shannon killed Nut, Shannon shot that tour bus. Based upon prior ruling, we know that should come out. Then he continues to go on. And he's saying, I ain't retaliate one time, now I'm on 362. And then Detective Thorpe, I guess, is trying to clarify, I said, because you just said a key piece of stuff we've asking you, you said without a hesitation, without a doubt, share no one who shot the gun. Because, and this will be speculation on my part, but I think because he's the investigator of the Donovan Thomas murder, that is what he is focused on. And then Kenneth Copeland doesn't even respond. He just says, y'all keep thinking I'm doing shit. I'm not doing nothing. I'm telling you, I'm fixing to go back to jail. I'm not trying to hurt anybody. So he doesn't even respond to
Right.
Detective Thorpe.
So maybe we could just take that part out then?
It seems right.
The Detective Thorpe part?
Well, without a hesitation.
Yeah, okay, so why don't we just take out 7 through 11? So 362, 7 through 11. Or 10 or whatever. 10, I guess. Okay,
Yes.
all right, next one that we have dispute about.
The next one we have this.
Yes, because y'all can spend your lunch break talking about the ones you agree on. And then you can come back and put it all on the record. I guess if you don't know, then we have to talk about it now.
Look at 365, line 6 through 8.
$365. Yes, that's in this. That's in dispute.
Okay, so, Your Honor, on 365, 6 through 8, the context of this is, Quindarius Zachary, also known as the other little dude, from Cleveland, he allegedly would buy, he's not a convicted felon, he'd allegedly buy guns. At some point, he bought a gun for Kenneth Copeland. Kenneth Copeland, allegedly, Kenneth Copeland ends up getting arrested. Then he wants to get the gun back, but then wants to get rid of the gun. And it's a gun that's later, my understanding is later, Kenneth is arrested for because he's carrying it to the Dunbar Rec Center and leaves it in the bleachers. Kenneth is saying that Jeffrey told Quindarius to buy the gun back from Kenneth. However, Kenneth was incarcerated throughout that period, is my understanding. So I don't believe he's speaking on firsthand knowledge. He's just speculating or passing on hearsay that Jeffrey instructed Quindarius to buy the gun back from Kenneth. I don't believe he has any firsthand knowledge.
So I have a different analysis. I believe that they are talking about initially buying the gun from the pawn shop. So if we go, but they're talking about the fact that Quindarius buys the gun, specifically most of the guns from Arrowhead Pawn Shop. And for the reason that Mr. Shard stated, the state believes because he was not a convicted felon, he would purchase a number of the guns on behalf of YSL members. And what the detectives are saying to Copeland is, you told him to buy the gun.
Right.
And he said, no, Thug told him to buy the gun initially. And then later on, there is some conversation about Mr. Copeland was arrested and he was going to try to sell the gun, which when he got out, and that's how he ended up.
Yeah, this looks like the buying it to begin with, not the buying it back afterwards.
Well, either way, Your Honor, it's, I don't see any indication that it's anything but hearsay. And here's the other thing. Quindarius Zachary's apparently going to be called. So Quindarius Zachary would certainly have firsthand knowledge of who told him to buy a gun.
The better argument.
Right now, we have Kenneth Copeland on an out-of-court statement, possibly speculating or passing on hearsay. And it seems to me that we would have a live person on the stand that could answer that question pretty clearly.
What my position would be is, one, if this statement comes in, it'll be contingent upon us asking some foundational questions on the stand first. And then depending on what his response is,
Okay,
this would probably be a prior inconsistent statement, depending on what his answer is. I don't know what it will be, but we can lay more foundation as to
Okay.
when, how did this come about? How does he know Doug told him to buy the gun or not?
all right.
This is why they need to identify the witnesses
Outside the presence of the jury. Yeah, absolutely.
and statements they want to make
Outside
and bring
jury.
in.
I just wrote that down. Okay, so we'll need some foundational questions on that. Assuming you can lay the right foundation that he actually knows it, then he ought to be able to say it, but we don't know that yet. All right. Hang on just a second. Ms. Winfrey. Portion.
I believe there was a portion of, so page 375, line 17 to page 376, line 9. The state only had an objection to page 375, line 17 to 19. Defense counsel wanted that line out. That Mr. Copeland says Doug is connected to a lot of people. We wanted that portion in. But that was.
I don't have a problem with that. And then 375.
All right, so hang on. So all of 375-17 through 376-9, there's no objection to, is that right? Is that right?
Yes.
Coming out, right?
Okay. Wait, coming out or staying in? Y'all seem to be
Agreeing that it
saying,
comes out. We're agreeing that it comes out.
Wait, hold on. 375 lines 1 through, you said 1 through 9, Your Honor?
no, I'm saying what you said.
Oh, I'm sorry. Yeah. I thought I
You
heard
said
one.
375, line 17 through 376, line 9. Are you agreeing that all of that is in or all of that is out?
I think everything from 375-20 to 370, excuse me, everything from 375-20 to 376-9 is out.
Out, okay.
And I agree.
All right. All right, what's next?
I have 378, 1 through 8.
You said 378, 1 through 8?
Right.
Yes, that is.
Agreed, out.
No, that's in this.
Oh, Okay. All right. Tell me why that's in. Oh, I see. That's not the detective saying 7 through 14. That's Mr. Copeland.
Yes.
So then, Mr. Sharp, tell me why that's out.
Well, two reasons. First of all, it's speculation about what other people will say. And also it's a comment on individuals' right to remain silent. I mean, they're asking, if we call people in here, who's gonna tell, who's gonna give it up, and then he just speculates. And I don't think that's relevant. I don't think that's appropriate. So I don't know why it would be admitted.
What's the state say?
Your Honor, so this is a portion, if you look at right before, on page 377, the detectives are asking Copeland, specifically talking about the murder, who do you think we can call in, who will speak to us about the murder? And what Kenneth Copeland's response, beginning on page 378, line 1, put it this way: Thug and them already knew those four right there, they're not going to tell. He's talking about Yak, Nard, Shannon, and one other, and it's slipping my mind who's the fourth person. And he says, I don't know about doo-wop, but them niggas not going to tell. That's why they not saying it. You feel what I'm saying? I understand why everybody doing this stuff, but I at least want to make a way to be like, well, Woody's told us, you feel what I'm saying? This is a YSL member who knows the individuals in which he is around. He knows who will come and talk to the police and who will not. And so who will protect the enterprise. And that's what we believe he is telling them. Like, these people are not going to talk about our activity. So there's no use in you trying to speak with them because they're just not going to talk. And Thug knows that they're not going to talk as well. As it relates to commenting on pre-arrest silence, Your Honor, I'm looking at an 11th Circuit case, United States v. Reeves, REEVES 742, Fed 3rd 487, which is a 2014 case. And
Sorry, just tell me that whole site again.
Sorry, and if I went too fast, I apologize. United States v. Reeves 742, Fed 3rd 487.
Okay.
So this is about
And
other possible
the key one that we
co-indictees
have is
not
the
coming to
government
speak to
may comment,
police.
And it's really on a defendant's silence if it occurred before the defendant was in custody and given Miranda warnings. In this case, at this time, none of the defendants were in custody at all. They were still investigating the homicide. At this point, no arrest warrants were even taken out. During this interview in June of 2015, warrants were not taken out until October of 2015 for the murder of Donovan Thomas. So this would not be commenting on any pre-arrest silence, Your Honor.
Okay. So aside from the pre-arrest silence objection, what other objections do you have?
Well, it's speculation, and it's also, I guess, relevance. Like, why is Kenneth Copeland
Self-serving too.
giving why would the jury hear an out-of-court statement by Kenneth Copeland about whether my client will give a statement to the police or not?
All right, so y'all had pointed me as the objectionable portion to 379 lines 1 through 12.
No, 378. I'm sorry.
Okay. That makes a lot more sense. Okay.
But it could be self-serving for someone like Kenneth Copeland to say, don't even bother asking these other people. They're not going to talk to you. Because what if those people would talk and say something bad about either Kenneth Copeland or someone Kenneth Copeland doesn't want to see snitched on?
All right,
It
I
could
don't
be
find it to be
self-serving.
any kind of a pre-arrest silence kind of potential violation. And this is his opinion as to how strong they're going to be with backing up and keeping silent about what the gang is or is not doing. I think that that's permissible for him to say. I don't think, I mean, it's only speculation to the extent that anybody's opinion about anybody else is speculation, but it's valid to come in. So I'm going to permit that in.
I don't like that ruling personally. So that's a win for the
What's
state.
next?
The next portion that I have as in conflict is page 386, line 20 through page 387, line 12. And
Is that in dispute?
yes, yes, Your Honor.
Okay.
I don't I don't have the dispute quite as broad. I just have the dispute over 387 lines 6 through 13. And it's just simply hearsay.
So, Your Honor, the state would say that this is not hearsay. We're not offering lines, page 387, lines 6 through 12 for the truth of the matter asserted. When you go back to page 386, Mr. Copeland, I think it's around here, he starts to explain that he never had an issue with Donovan Thomas, like that they've had conversations with each other. And some of the subject of that conversation was Mr. Copeland's relationship with Mr. Thomas's brother, Kelvin Watts. So when you get to page 387, lines 6 through 12, he's telling them about a conversation that he had with Mr. Thomas prior to his death. Now, whether or not Mr. Thomas said, I'm going to go holler at them, or whether or not Mr. Thomas did go holler at Kelvin is not what we're offering it for. It's solely being offered for the fact that they engaged in conversation that was amicable prior to his death. And so we're not offering it for the truth of the matter asserted.
All right, so it's on 386 where he's talking about actually having the conversation with Mr. Thomas, right?
Yes.
Okay, and that's fine. That's not objectionable to the defense. So the part that they're objecting to is the part where, I guess, who is it that's walking up and saying this? Shannon, right?
No, so when we go to 6 through 8,
Yeah.
he's saying that Shannon was right there in the presence when the
Right.
conversation was happening.
And it's Shannon who says, if I'm understanding it right, man, what's up with you and Kel, right?
No, it's Donovan Thomas.
Oh, and he was like,
And he's referring to is Donovan Thomas. So
And I agree with her.
okay, all right. Okay, and so you're not offering it for the truth, you're offering it for the fact that Kenneth Copeland and Donovan Thomas are cool with each other.
yes.
All right.
Well, I mean, that already comes out in 386 that they had a conversation. My objection is when Kenneth says what Donovan Thomas said, allegedly said, which is, man, I'm gonna holler at N-word and I'll let you know what's up. Because it's giving the impression that, and it is coming in for the truth of the matter asserted, that Mr. Thomas was playing the role of peacemaker.
All right.
And
So I'm sorry, I don't mean to interrupt, just for purposes of keeping the record clean. So now what we're really talking about is just lines 10 through 12 of 387, right? Okay. So in that, they're saying, hey, man, you got to be offering that for the truth.
Come on, Hilton.
I mean,
Argue it.
the point that they're claiming to be trying to make is made without that last part.
Nut isn't a defendant. That's Donovan Thomas.
But I think that gives context when you continue to.
He was the one that
go
was shot.
Further down that page. And when he says, that's what Nut said. And then Kenneth says, yeah, so when me and Kel seen each other, I believe he says, when me and Kel seen each other at the skating ring, Kel was like, well, he wanted to see what Thug got to say. So I called Kel on FaceTime.
Okay.
But give us some more history. In the week leading up to Donovan Thomas's murder, there are a couple of events that
Yeah,
occurred.
I actually am already familiar
Yes,
with the
so-
skating rink event.
So it appears that on that Sunday, Kenneth believes, based upon his interactions with Donovan, that him and Kel are cool. And matter of fact, they actually do talk and have a conversation. And then the next day is when Kenneth Copeland gets beat up at the skating rink. So all this is in context of what is happening or developing those days leading up to Donovan Thomas's death. So I think it puts the second part of this page in context.
But the only way it provides context
Is if it's being offered for the truth, right? I was about to say, so now you're conceding it is being offered for the truth.
Not whether or not he hollered at him, but the fact that they just had this conversation, whether or not, because we don't know if he hollered at him or not. We just know that something may have occurred, then they saw each other the next day. Donovan might not have ever talked to his brother that day before. We don't know. We're not saying. He definitely went and spoke to Mr. Kelvin Watts once he left that meeting. We don't know. We're not offering to say he did talk to him. We don't know. What we know is the results, whatever that conversation was, there was an amicable meeting between Kelvin and Mr. Thomas that Sunday
Even to the
before.
extent of the discussions about his own brother, it was amicable.
Correct,
And
whatever.
it-
Whatever.
Okay. But not for the truth of whether he's actually going to holler at him.
Right.
All right, well, that seems like it's then not offered for the truth. So, all right, that can come in. All right, let's take a lunch break. I know the lunch is here for the defendant.
time.
So let's be back. Will it be enough time, you think, to get everybody fed come back at 12:20? Not 12:20. No, that will not be enough time. 1:20? 1:20, will that be enough time? I'm asking the deputies. Yep. 1:20.
All right, so we got an hour and 20. I do want to check if we have, and we'll keep the screen up. But I do want to check if maybe any filings slipped through, so I'm going to pull that up right now. What are you guys eating for lunch or dinner, wherever time zone you're in? And today's the 2nd. Okay, I do see some stuff filed on the 2nd under Williams, so let's look at these. Okay, this was actually out yesterday. It was denying the certificate of immediate review in relation to the denial of the renewed plea in bar and general demur. Okay, yeah, so this is just stuff that came in yesterday that Thugger Daily had posted as images, but now it's actually posted. And we saw this in full. This was the motion for the jury instruction. There's only an extra page. We're just asking to talk about this at the hearing. We looked at the order to deny the disqualification of Hilton and Love. And then the order denying the renewed plea and bar. So these filings are just getting posted finally. They're not new. We've looked at them already. So nothing new. Keep this up here because who knows? And then what are you guys thinking? So we do have, I think we had two wins for the state that things aren't coming in, but most of the other stuff can come in. And to be fair, it's stuff that some of it was already talked about. So if the jury doesn't just necessarily forget everything, if they remember it, even though they're supposed to forget it existed, some of the questions that Woody was asked related to some of these things that would later be played in these statements anyway. What are you guys thinking? And I do think it's worth revisiting this. I had read, so Missa B sent this super chat earlier. I actually thought that they were already instructed to do this by the prior judge. Tell me I'm incorrect. Meaning for the defense and the state to get together and stipulate or not stipulate, you know, what do we agree across the board? No objections can come in. Stipulate that we both agree. We don't need to discuss that at an evidentiary hearing. But then anything you disagree with, we can slim down our evidentiary hearings to punch those issues out. Judge Glanville did ask for that. And we did have those days of hearings back in June when the jury wasn't present, where they were starting to go through these things. It was much less efficient than what Whitaker is doing now. But what's interesting is it's only efficient because Whitaker is making it that way. It's not efficient because the state has already had to do this and they should be prepared to do it again. I do think it's a little bit cleaner. I shouldn't say it hasn't changed at all. It's a little bit cleaner. But they've still several times stumbled over each other and been like, oh, wait, no, we don't dispute this one. Actually, this one is fine staying out or it's fine coming in. So, but you're absolutely right, Miss AB, that they already tried to do this halfway with Judge Glanville. And then, let's see. Yeah, and so Janelle Berry Tucker says, notice how the judge has repeatedly stated to the prosecutors that these statements are not offered for the truth then? Question mark. And this is what I mean when I say it's very telling the certain questions that Judge Whitaker is asking. She wants to see certain arguments or not see certain arguments. And if you can give her that argument, and I do think Shard, he has a lot on his shoulders. He has to handle a lot of these statements because the majority of them most strongly relate to his client, Shannon Stillwell. So that's why you're seeing him speak so much. But I do think it's two different times I've noticed, based on the questions from Whitaker, she wanted a specific argument and didn't exactly get it. I think one of those was, those four aren't going to come talk to you. Copeland telling the police, those four, it was, I wrote them down. Yak, Nard, Shannon Stillwell, and Hilton said the one other person, I can't remember, but that basically Copeland told the police, those are the people that Thug knows is not going to tell. So basically, it could have been a self-serving statement for Copeland. Maybe those four people had something bad on him, and he's trying to steer them away from going to question those four people. And then he mentioned, I don't know about Doo-Wop. And that could have been steering towards going to question Doo-Wop first. So, but Max Shart didn't really make the argument that it's hearsay and it's self-serving, and that if you were to exclude that, it wouldn't create any gap in understanding for the jury. So there's no reason to make a hearsay exception for that type of self-serving statement. And the judge might not have agreed with that argument, but Max Shart didn't raise it. He missed that one. I didn't hear that raised, and I think he should have made that argument. Because she was hinting that she already wasn't going for the pre-arrest statements argument. And that also, she didn't really think it was ruled out just by calling it speculation, because it could have just been an opinion. So I don't know. I think that was one part where Max Shart missed the ball there, and maybe someone could have levied an assist for him and nobody did. No, I don't know who Thugger Daily is. I just know that their Cash App is Ben Jesus, which is obviously a fake name, but that's why I always say he. And honestly, because they use Young Thug's picture, even though I know that's a celebrity and they're using that picture as a picture and it's not themselves, my brain associates them as being a he because it's the Young Thug's picture that I see. So I don't know. I don't really know either way. I do think in an interview, I do think they gave an interview and they were a he in that interview. So I think I'm just gonna, Thugger Daily's a he from now on. I'll correct it if I find out otherwise. But I don't know. I really don't know otherwise. Oh, so wait. Is the recused Judge Glanville in Canada now? Thank you so much for the Canadian 5, Judge Glanville. Recused Judge Glanville says, Kat, here's a whopper for Max. I have all the APD reports he's looking for in chambers, but Jack is guarding them. Thank you so much. Yeah, all those reports that Max Shart is always looking for. And I think I tried to point it out without speaking over the stream earlier, but one of the issues here, and it's why I wanted the judge to lean a little bit more in the defense's favor particularly, is part of this issue here. Max Shart suggested, look, you guys plan to call Quandarius Zachary as a witness. Quandarius Zachary is one of the 3 names that we finally squeezed out of the state on Wednesday, the second day of these hearings. We spent like 4 hours on Wednesday with the judge saying, state, can you please just identify witnesses that you're going to call and say they have co-conspirator statements to bring in? And can you identify some of those statements? It was like pulling teeth. We got 3 people named and a general statement that some social media posts. So Max Shart now is like, look, they're going to call Quandarius Zachary, who would have actual better knowledge, firsthand knowledge of the same thing that they're trying to accomplish by introducing these double hearsay layered statements through Kenneth Copeland and these interview videos. So rather than hash this out, why not just bring it in one time through the witness that would have more likely to have actual knowledge of something? And I thought that was a great argument. I really thought that one was a great argument. I think we should see hopefully a few more instances where some of these hearsay things we reiterate, hey, another witness that has actual knowledge is going to be here to talk about it. I thought that was a great argument. And it's right up Judge Whitaker's alley because she doesn't want all this cumulative testimony. She wants to be out of here in 30 weeks. So why continue to try to hash out an issue with something that we have someone else that can come in and actually testify to it without saying he said, he said, he said. So, no, the last ruling, right? The last ruling, was that about the statements about, oh, they're not going to tell. Those 4 people are not going to tell. She said that those could come in and as an opinion, just like anybody else would have. And then there were some more lines that they talked about, lines 10 through 12, about Kellen Donovan Thomas, about the role of the peacemaker. And it sounds like that's also going to be able to come in. But what I don't get is if you could talk about Donovan Thomas, this is the guy that was shot and killed in 2015. If you can talk about his role as the peacemaker, then why wouldn't the defense be allowed to talk about 404B evidence, character evidence, propensity evidence? If the state can argue that he was a peacemaker by bringing in this statement, the defense should also be allowed to say, no, maybe he wasn't. Or maybe that peacemaking was strategic between the Englewood family blood gang. Sorry, I'm getting the acronym mixed up. But the Englewood gang. The peacemaking may have been taking place, but just for the sake of this one gang. But he had all this other history, he had other beef that he may need to worry about. And thus, when he was standing outside that day, it could have been someone else with a similar type of weapon because that's characteristically what people use, that actually shot Donovan Thomas. But the state has been fighting like tooth and nail, because it's important to their case, to keep out character evidence about Donovan Thomas. Because if they can keep it out, it's more difficult for the defense to make the argument to the jury. It could have been anybody else that had a motive to go after Donovan Thomas, rather than these 6 people sitting in this room right here. So, but yeah. And we wonder if Woody's watching. And that's the thing too, imagine like you being able to prep for what you're going to talk about when you know exactly what statements they're going to use. Okay, and Nick's going to raid. Nick's going to pile on in here. We're going to get the Viking raid, you guys. Sabata says, what are your thoughts on how things will go when Woody testifies and contradicts his statements that Whitaker let in today? I think we might end up in a situation where we have to let the jury back out. I think it's just a matter of time of how long will Copeland get to testify for before something happens where they have to excuse the jury to hash something else out. I don't think we'll get through Copeland's testimony without seeing the jury excused. I just can't picture it. And probably not just one time either. So I don't know. I really think that we can get right back in here. You guys are saying Thugger Daly's Deputy Brown. When does the jury come back? Were they looking? Did they say Monday the August 19th was when she was looking to bring them back? That target of next week can't be possible because it's Friday right now. So I don't imagine they can come back next week. But I swear I heard her say something about August 19th, which would be 3 Mondays from now. 3 Mondays away. And then recuse Judge Glanville. I'm with Woody getting chucks for Miss Weaver. What color? They gotta be red. Get one red and get like a pair of red and a pair of green, and then like wear the left for slime and then the right for the Bloods, and make Christina Weaver a co-conspirator, an unindicted co-conspirator. And then Coco thinks that the Whitaker is playing in our face. I think you mean Whitaker, right? You say, Kat, I think she's playing in our face. She capped us down. Yeah, probably Whitaker. Yeah, I think she could. She could be. And we have a ton more of these statements because this is all from that June, what? The June 10th video from 2015. The June 10th interview. This is all still one. So she wants the jury to come back Wednesday? This Wednesday coming up? That makes sense because Hilton's supposed to be gone. I heard them say something about August 19th. I don't know what that was. Maybe that's the date that Hilton's going to be gone until. There we go. Maybe Hilton's going on like a 2-week vacation. And then Wednesday the 4th. I remember she said the 8th. I'm sure we'll get clarification. So I'm going to stop guessing. So if you're listening, disregard. This is my jury instruction, my curative instruction to you guys, the jurors in the chat. Disregard anything I've said about the date the jury's coming back. I'm sure we'll get clarification at the end of the day today, as we do, that wrap up at the end of the day. She'll probably lay out what's for next week. And then, okay, and then B's saying that that's the week Glanville gave them off. Oh, so, okay, that makes sense. That makes sense. And then Taybiz TV, good to see you. You've been missing in action today, busy day, but want to show love. I appreciate that. So you're not covering this today? Taybiz TV is laying down this content here. So that's Taybiz's channel that I just dropped a link to in the chat. But I don't see. Let me know if you're doing anything today. You guys, at 6 p.m. Eastern. I'm not good with time zone conversion, so I just got to say Eastern. But Nick Starro is doing a panel show with a fully loaded guest panel. I'll be hopping in right at 6. assuming court is over. I don't know why we'd go later than that, though. She's been getting out of there by like 4:35. So 6 p.m. ET, Nick Starro panel. There's 2 links for you there. But that'll be good. He's running out of room for guests in that panel. So right now he has Seti Nash himself, Infamous Sylvia, Rachel, who is a practicing criminal defense attorney in the Fulton County Courthouse. She's been on with Phil Holloway on Inside the Law and Kayla Bumpus's channel, me and Kayla Bumpus, and I think he's invited other people too. So, and yes, that is what is being said. So Crazy K says, wait, I'm so lost. Officer Brown told about the ex parte meeting. It seems like he's the one that disclosed that it was happening to Brian Steele. Maybe inadvertently, maybe not like, here's all the details. But he at least was the one that pinged and confirmed to Brian Steele. I'm sure Brian Steele already had the suspicion about that June 10th meeting. So, and then yeah, so Nick Starro does a spin the wheel thing. Where I only participated once, but like it spins and it could land on like hot sauce and you got to take a shot of whatever it lands on. So it's got like regular alcohol, but then it has hot sauce and then spoons of mayonnaise is one of the options. So we're not going to talk about that one. I act like they don't exist. They're stricken from my memory. But yeah. And then let's see. Okay, so Tavis says not streaming today. And hey, Flesh of the Gods, did you do a video on the June 7th transcript? Did you animate one of those yet? If you guys are watching today but haven't watched the rest of this week, it's probably worth reiterating that on Tuesday, the defense was disclosed for the first time. It was disclosed to the defense that there was another ex parte meeting relating to Copeland's willingness to testify on Friday, June 7th, after the courtroom emptied out. They went into Chambers, Hilton and Love, and Glanville, and had an ex parte meeting again. And I think that one looks a lot worse than the one on Monday, and it makes the one on Monday look even worse. So let's see. Just gonna drop Flesh of the Gods channel link here. Because I'm assuming, I'm gonna look in the chat and see. Have we done? I don't know if he's answered. But I'm sure there is an animation coming for June 7th at some point on Flesh of the Gods channel. Oh, you like my hat? It's the Diane Fossey Foundation, you guys. So it's one of my favorite, like, charitable causes. Because my mom is one of the, like, my mom buys all these cool gadgets. Like, she has everything that she could possibly need. And I thought the coolest thing, I didn't know what to get her for Christmas 2 years ago now. It wasn't this Christmas, but the one that passed. So, you know, every once in a while I buy like a hat from the organization, throw in a coin, but I adopted her a gorilla because I didn't know what else to get her. And she's, you know, I have an older brother. We've both been out of the house for a while. All my cousins are getting older, so she spent a lot of time helping my aunts raise, she has 2 younger sisters. She's helped raise their kids. And those kids are getting older and, you know, they don't need as much aunt nannying. So I'm like, all right, get her something to care about. So when you adopt a gorilla through the Diane Fossey Gorilla Foundation, they send you photos and newsletters and updates all the time about all of the gorillas that they track and what the organization is doing. But they also send you updates on what you adopted and that gorilla's family, their lineage. So it gives my mom, like, it's an awesome cause, right? But it gives my mom, let me take a little meat sack off while I'm talking about this. But it gives my mom something I feel like to follow. Like, look at the picture of this baby gorilla growing up. So really, really cool. Totally love them. if you're ever stuck on looking for a cool vacation idea, they do have like Rwanda tours where you go and you stay on their reserve and you can do a tour and look at some of the gorillas. Really, really cool stuff. I love them so much. So that's the hat I'm wearing today and often wear. And then let me get back over here because you never know when someone's going to pop up with the way this case has been going. The Inglewood Fani gang. See, I can't put that in my memory because I'll try to recall it and I'll blurt that out and I'll be like, that's not actually what it is. And then yeah, and then going back to the jury instructions, Brian Steele's fighting that it should be about disparaging comments, and Love wants it to just be, well, Steele wanted it to be disparaging comments to the defense counsel, which I think the judge is going to open it to be just disparaging comments in general and not make that specification. But Love wants it to be commentary in general to both sides, not just disparaging comments. And the judge was looking at her like, I don't really think that's a good argument. Like, come up with a better argument for that. We'll revisit it. Oh, wait, we have the owl. Well, my Twitter's a mess, so let me see if I see it really quickly. Okay, guys, we're going to look at this. So let me drop your link. So this is Flesh of the Gods on Twitter. Guys, we're going to look at the owl animation. Okay.
Of the Georgia Code. Mr. Owl, how many violations of the Georgia Code of Judicial Conduct does it take to get a mistrial with prejudice?
Let's find out. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11.
Keep going.
12, 13.
Objection, that's intent.
I'm overruled the objection. Could you repeat the question for me?
Mr. Owl.
What a great clip of her body language. Let's watch Love again. So that is so great, Flesh of the Gods. I love this. Look at how happy Love is when Glanville agrees.
Objection, that's intent.
I'm overruled the objection. Could you repeat the question for me?
Mr. Owl.
You know, I'm going to tag Doug Weinstein. Wait, what's his Twitter name? All right, I won't put you through this on stream. We'll figure that out. I'll make sure Doug Weinstein. So guys, if you missed it, that's a reference to in Doug Weinstein's supplement that he filed for a motion for a mistrial. He asked the question, how many violations of the Judicial Code of Conduct does it take for a court to get a mistrial, a defendant to get a mistrial with prejudice? So Flesh of the Gods went and actually added that to the Tootsie Roll animation. I love that so much. I will tag Weinstein in it. And then thank you so much. So thank you to Big Baby Jane for the super sticker. That was so nice of you. Pumpkin Belly, also a member. Good to see you. Choose your Mario Kart emoji. You have special member emojis now. Tabiz TV says, when Love stood up in court and suggested professionalism yesterday, after Mad Max clowned the state, I almost died. How dare you of all people? And that was it. She didn't have a counter to his argument. She just said, thanks, Judge, for, you know, making sure we're all professional, all of us. When she was the one that got warned about her duty of candor to the court. Oh, and then I saved this. So, factual lie. I saw this in the chat while we were talking about the Diane Fossey Foundation. You adopted a donkey in Spain and a giraffe in the UK. See, that's just cool. It's just good stuff. And I see Jar here, or Yar with Nick's accent. So, Nick Raid, hello to everyone coming in from Nick's channel. If you want to pop up, Nick, you know, drop the link. I know you're going to be like, it's lunch and I need to nap before the 6 o'clock panel stream. But there's a link for you, Nick, if you want some lunchtime thoughts. So Woody's gossiping like a Yenta. Heck yeah. And then there you go. That was, again, that was awesome, Flesh of the Gods. That was an awesome animation. I don't know. Sometimes I also like to check. Let me see. I also like to check Thugger Daily throughout the day. Because Thugger Daily's so good with clips sometimes. It'll just be like, hey, this thing they're talking about right now, here's when they argued it previously. I don't really see anything. Let's see. He did clip when Jeffrey Williams was smiling in the court. Thank you so much, Iron Rabbit. 5 memberships. You guys know if you got one, say thank you. If you didn't get one, drop a rabbit emoji in the chat. Thank you so much, Iron Rabbit. And then... Okay, so we do have a flashback reference here. Here we go. So Judge Whitaker is excluding... And before I go on and forget, I know if you guys are on X, you're already following Thugger Daily. But if for some reason you're not, that is the link to follow. But Judge Whitaker is excluding a lot of evidence, falling in line with Max Shard's argument regarding double hearsay and Woody. This is pretty much the first defense motion Judge Whitaker has granted so far. So Shannon Stillwell, aka SB, has also filed a motion. This is looking back at July 23rd. So has also filed a motion asking the new judge to reconsider one of Glanville's more controversial rulings regarding Woody. So this is about the hearsay statements coming in under co-conspirator statements relating to Donovan Thomas. So we had looked at that motion. Thugger Daily's flashing back to it. And then the argument here was in his June 10th, 2015 interview. All of these statements that we're looking at today are all from that June 10th, 2015 interview. Mr. Copeland told law enforcement that he picked up Demiki and Garlington at a McDonald's restaurant on Cleveland Avenue on the evening of January 10th, 2015. Copeland reported that Garlington walked to Copeland's car, and while the two men were briefly alone, Garlington told Copeland that they killed Nutt. And we know Whitaker's familiar with this because she's called out. Didn't they only speak briefly? Is it reasonable to think, preponderance of the evidence standard here for admissibility issues, is it reasonable to think that they would have had enough time for Garlington to say all of these things to Copeland that Copeland is now telling police that he said? So Whitaker was tuned into this. Copeland told law enforcement that Garlington then pointed to a group of people who were pulling into the McDonald's. Copeland told law enforcement that he interpreted Garlington's words and actions to mean that Stillwell, Kendricks, Justin Cobb, and Demise McMullen were all present for and all participated in a drive-by shooting of Donovan Thomas. Per Copeland, Demise McMullen entered his car shortly after Garlington, and all communications about the event ceased. So, I wonder if Demise may be that person that Hilton couldn't remember. So, and we know Glanville allowed those. And then if Whitaker applies the same argument, logic, and ruling to Woody's statements regarding the Nutt murder, the state's case will be severely weakened. So be on the lookout for our rulings today. So we had 2 portions I think she said aren't coming in. 1 I think she said she wanted to look at more. And I think 4 times now she's let portions come in. She's ruled with the state. She's favored the state. And there we go. We're going to toggle back over here. Yep, and you guys, and this is a common thing too, and Miss AB had pointed this out earlier, if we get to it, we should do a counter if this trial continues. If I was Whitaker, I would be thinking I'd be probably the biggest task, you know, when you don't know what you want to do yet, when you don't know what's going to happen. The biggest thing that I'd want to marinate on is when Copeland gets back on the stand, what do I need to be prepared for? Because there's a good likelihood it'd be reasonable for me to expect that Copeland could not want to testify, could maybe not show up one of the days and we have to go get the deputies to bring him in or whatever, could get on the stand and do the same things that caused the jury to need to go out of the room while we figured stuff out. And she's got to know that, what if the state asks her for an ex parte? Like, the state has to know that she's not going to go for that without disclosing to the defense or inviting them to be part of the meeting. But I feel like the state's going to ask anyway if necessary. Necessary by their terms. So what do you guys think about this if the trial continues? Whitaker has to know that that if involves Woody taking the stand again. How do you deal with that? Because surely it's not going to go smoothly. Oh, so a Tootsie Roll commercial. So when I still lived in New York, I used to love the Museum of Television and Film, I think is the name. It's a museum for television and film. I don't know the proper title. My grandfather used to take me a lot, and you could just go in and they would just have reels playing. They had a theater. And you could just go and watch all the old commercials. Oh my God, I love them. Like the Where's the Beef? All these different classic old commercials. Totally loved it. And I just like the animation styles of all of those old commercials. I would need to look and see a specific one. I mean, is that stuff copyright protected? Maybe I can just YouTube it. But I love old commercials. I see one with a whale, where the Tootsie Roll is a whale. If I play it and it gets copyright stricken though, it'll make the chat replay go away. So, I don't know. Let me not do that. I feel like it's fair use, but maybe it's not. Yep. And that's again, rolling up. It's a whole case of hearsay. The only proof they have is someone who they considered a co-conspirator, but then they're not charging. Makes no sense. Yeah, oh my God, shout out to New York. So, I've been all over New York. I was in Queens a lot. When I speak of my grandparents, that was Queens. In high school, I moved a little bit upstate. I called it upstate at that point, but didn't realize that wasn't really upstate. It was like right outside. It was a commuter town. And then ended up like crawling my way further and further upstate all the way to like Rochester, and I lived in Buffalo for a little bit too. So when I say New York, it's kind of all over. New York's big. New York is pretty big, but I love it. I do miss the season sometimes. Yeah, so Jars from Manhattan. I don't know if I could do Manhattan. I certainly wouldn't drive if I lived in Manhattan. I would give up driving. I'm in Space Coast in Florida. Ugh, I don't want to be an attorney. I get nervous and stumble over my words. And I cry when I get mad. I would cry in court if I was so mad that I felt like my client was getting an unfair trial. I would literally cry in the courtroom and they'd kick me out. Oh, there you go. I know Troy. Yeah, you're on the road sign. So Troy's always on the road signs when I'm going up. Oh God, I should know my routes. Is it 94? I forget if it's 94. One of the interstates. When they have like the major exits, it always says Troy/Albany. I went to Albany once we had a field trip, and we went to this giant building that was shaped like an egg to see a production of James and the Giant Peach. It was not good. It was not good. But it was this giant building that was shaped like an egg. And then we found out afterwards that there were 3 of these buildings built around the world. And the Albany one was the only one that was in use because the others were deemed unsafe, like structurally defect. They put us in this egg building in Albany. that the other two versions fell apart. Yeah, shout out 585. And you do trucking, that's what's up. So, with Rochester, so I used to work a lot with DJ Fire Kid, and I know he does trucking now, so maybe you guys know each other. He's kind of like jack of all trades. In addition to the DJing, he does electrician work, he flips houses, has investment properties, but he also has his CDL, and I see him, like, he'll still Snapchat, he's doing his routes. So maybe you guys know each other. There you go, I know Fairport. I know Fairport. And you guys, see, okay, so Paris, I totally understand. Oswego, Buffalo, now Atlanta. Right before I came down here, I was in Atlanta for a little bit. Not long enough to, like, vote or anything, you know, I was only there for a few months. I came down here because a company down here acquisitioned a call center that we had. We used to call and set appointments for real estate agents. They weren't okay with me working remotely, so I ended up moving down here. And then COVID hit, and they're like, okay, go work from home. So I was like, great, I moved down here, and then you don't need me here in person. So now I work for myself anyway, but that's how I ended up down here. I was trying to stay in Atlanta, though. I had a great time in Atlanta. I love the restaurants. There's so many. Listen, only if food is involved. Only if food is involved. And then, you know what? I should just update my video description to have an email address. Let me do that. I'm going to update the video description to have an email address. I'll try to be better about putting it in there moving forward. Okay, so right at the bottom of this video description, and I'm using a different email than I normally give out because I'm getting too many emails in, too many mixed emails in one inbox now. So use this one, takeontrending@gmail. It's also in the video description, you guys, if you need to send me something. I'm not very quick with emails, just to warn you, because I'm trying to make sure if a client emails me something, I'm taking that as a priority. But like when I have free time, I go through like a block of YouTube stuff and try to get through it all and get back to everybody. And then let's see. Yeah, see, it's all about the food and the restaurants. I mean, I don't feel like I was in Atlanta long enough to go to the restaurants I wanted to try. And we were big, so my brother lives out there. I mean, you guys have heard me mention before, my brother does like esports broadcast production. So he's like the tech guy that codes like the overlays and helps run all the different screens because they flip all the screens to the different players. Like, you guys see me struggling with StreamYard. I don't know how he does it. I'll be like, this error happened today, and I don't even need to explain it. He already knows what went wrong. But he does that, and I was in the studio. Like, the studio that they use, they bring, like, they rent it out sometimes. If you guys, like, pay attention to, what's Kai Sanat's group called? His, like, group, his brand group. Like, they rent the studio out sometimes, so you guys have probably seen some content that's made in the studio that he works for. But, oh god, he's like such a genius with this stuff, and I don't understand any of it at all. But while I was there, they were bringing in like catered lunches. They were ordering lunches from all these different restaurants, like lunches, guys, not even dinner restaurants. And the food is just so much better than what I have available around me here. Like, I'm so jealous. Here, I can't even find a good Chinese or pizza spot. And then Zion here, I think I'm pronouncing it. Is it Zion? So Zion 42 says, with Woody still a sworn-in witness, do you think it out of court public comments be an issue that could be brought into the court or that court would have to deal with? Well, so what's interesting is they were winding back to really June 12th is where they're winding back to. So we have to see what these curative instructions and what they want to do for the logistics of bringing Woody back on the stand are going to be like. But I don't know if they're going to agree to strike all the way to the back of his testimony, the very start of it, and tell the jury to act like it didn't happen. But in any case, if he's saying certain things in public records, if a defense attorney, or honestly, if the state, right? I don't really see many situations thinking about what Woody's talked about online where the state would want to bring something up. But, you know, I can see the defense maybe wanting to bring certain things up. He had a few stories on his Instagram that were talking about, it seemed like what the state was trying to do to him, how they were trying to threaten him, keep him from his family. You see what they try to do to me and other people. I can imagine the defense trying to argue that they should be allowed to ask Woody about those things. And I don't think Glanville would have allowed it, but I don't know. Of course, the defense needs to make the argument for it to come in. And no, court's not over. They're on the lunch break until 1:20, so we've got just shy of 40 minutes here. That's why we're talking about things like, you know, food spots in different cities. And yeah, that too. So that I would absolutely want to bring in. Woody said on a podcast that Thug is a good person. And hold on, wait, there's a lot of... Sometimes when I look up restaurants, Miramar comes up as, you know, I find a good restaurant suggestion and then it says it's in Miramar. I've never been there though. Okay, you guys. So if you guys are in the Atlanta area, you might all appreciate this tip from Dante Bagnasco. He says, I found the most amazing New York pizza here just north of Atlanta. Romeo's, maybe Romeo's, New York pizza. The owner owned a pizza place in Brooklyn, then moved to Atlanta. Oh, that sounds good. Is it like, my geography is bad. Is that like near Stone Mountain more then? I don't know my directions. I used a GPS when I was in Atlanta. I wasn't there long enough to learn where anything was. Heck yeah, Memphis barbecue. See, that's the thing. You go to a place like Memphis, and then you have too many options of good places to go to. It's a different predicament. Like, you just got to know, and you got to go to someone that's there. So Cash Money Cash with the plug. But here it's like you got to sort through things and figure out where it actually has good food to make a determination of where you're going to go that you're not going to regret going to. There's a lot of places down here that are, you know, nice because they're by the water, they're by the beach, they have a good view. We also have, because I'm near Cape Canaveral, Port Canaveral, so there are some restaurants there that I don't really love the food, but you can go and you can see the ships come in, the big cruise ships. Sometimes you can see like dolphins going by in the water right through the canal. So I don't know, that's cool. It's cool for the visuals, but the food, not so good. Food is not so good. But yeah, I'm all about the food. Miami, of course, has great Cuban food. You're not biased. No, it's true. Oh, Candace, great point. So, but she was doing okay with some parts too, especially that crappy audio from the police interviews. But Candace says, I think it will be interesting when the judge actually meets Woody in person. She struggled with what he said in his video. Yeah, because she had to keep asking. I still couldn't hear what he said. Which is why, you know, having the transcript is helpful. But sometimes one of the parts today, they were really just looking back at the video clip to make sure the transcript was right, because I don't think it was. I don't think it was. And I don't know, I hate moving. I hate moving, you guys. When I tell you, the two people that started the business together with the call center, they had a moving truck and they let me put a few pieces of furniture on them. I just packed my car and drove otherwise. I didn't care. I didn't want to move anything. And I would do the same thing if I had to move 2.5 hours to Miami. I'm just like not dealing with it. We're going minimalist. Now, what I'll do is as soon as the court starts, I've got a little kind bar here. I'll just turn my video off and I'll turn my mic off too. And I'll just be sitting here snacking for the first 5 minutes when something's going on. That way you guys aren't bored. Hell yeah. So, okay, Texas people. Texas people. What's a good spot in Texas? And speaking of Texas people, Kayla, if you want to come up, are you in court? You can come up if you want, Kayla. And so so Whitaker didn't Whitaker already have a case with Kenneth Copeland where he was the actual defendant? That's right. Yeah, I'm close to Cocoa Beach. Cocoa Beach, guys, is like right south of Canaveral, the port. You good to come up, Kayla? Give me a thumbs up. Okay. Hey, Kayla.
Hey, guys.
Oh no, we're losing you already. She said, never mind.
You know, of course, my phone rings as soon as I come up.
You're busy.
Okay, can y'all hear me? No, I'm not. I just left court to get something to eat.
So what's going on inside?
Nothing, boring.
I saw the empty bench behind the state. You didn't try to sit there?
No, I thought about it. It's a lot of things I thought about today in court. I'm dressed like a lawyer today, though. But wait, Kat, you know, Judge Whitaker has sentenced Woody before. She know him.
I forgot. I realized after you said it. So that's a great reminder, you guys. She already knows him. And then, what do you think of the cart of documents that Love wheeled in?
Well, she wheels them in every day.
Never seen it pulled up that far.
Oh, yeah, she packs that thing up and takes it in and out every day, her and Simone.
Is it usually with the table behind them? Are they the ones usually stuck with the filing cabinet? Is that why we don't see it in the camera view?
No, I think it's just on the side close to where the jurors are.
There we go, you guys. So the cart is always there.
It's
Shout
always
out to
there.
the shopping cart.
Let me tell you, I waited for her to pack the cart the other day, like the let out of the courtroom. I said, I'm gonna wait for her to pack because I'm gonna make her walk past me.
Well, Hilton's been the busy one. It's really just been Love going in and out today. Hasn't been Hilton.
I noticed a lot of the attorneys are going in and out. Some of the attorneys were leaving when people have like multiple counsel. A lot of people are I saw people standing in the hallway making phone calls. I heard a few attorneys say that they were leaving because they had to actually go work.
Yeah, I mean, we had some of those scheduling conversations today with Whitaker. She's like, I understand you guys have other cases. And everyone's like, yes, we do. Please help us. Please let us help our other clients.
I'm sorry, y'all. I'm trying to make it back on time, but no matter what county I go to in Metro Atlanta, there is a case that can't move because their attorney. So it's not just Fulton County with a backlog. I'm in Cobb, I'm in DeKalb, anywhere I'm at, they're like, oh, YSL trial. So people are literally sitting in jail because their attorneys cannot come take a plea, can't come do a bond hearing, can't come do anything. They're literally sitting in jail.
And it sucks because if these are the attorneys that you want, you can't just pick another attorney because then you don't know what you get.
Yep. And a lot of these people have relationships with these attorneys.
Yeah, you have to restart from the beginning too, like your whole case.
But today, I mean, I know they was going kind of hard on Woody, saying a lot of his testimony. I think it's really interesting. I don't know what's up with Brian, y'all. He just can't get it right. First, he can't get my name right. Now he's saying the game. Now he's saying the game is a musical group.
Instead of a person.
He's still doing a great job. That was everything he said, and that were great points, though.
Yeah, no, I agree. I think Shard's doing a great job too. I think he just missed making one argument. I wanted him to make an argument about, possibly Copeland's statements being self-serving, that these other 4 people wouldn't want to speak to the police. Well, it could be because it could benefit him or the 5th person, Doo-Wop. So maybe he wanted to protect certain storylines from being available to the police by directing them away from those 4 people. And that might not be the truth or of why he said that, but you got to offer it as an argument because it's only a preponderance standard when it comes to admissibility arguments. So
yeah, and
he's done pretty well otherwise.
Yeah, he's done really good otherwise. I'm really interested to see what state law that the state comes with. But
How many times have they been told, get your case law?
I mean, also, I think that Brian brought up a good case about, what was the case he brought up? I know it's from 1986. I said yes when he said 1986. I said, at least that's newer than 1978.
973 or whatever. And that wasn't relating to like something that would be canceled out by a new statutory code. So him
Right.
going back to an earlier case
Right.
could just be because that's what everybody's relied on since. There hasn't been a new adjudication that changed
Statute
anything
or
since.
case. Right.
Mhm.
Right. I mean, I think
So
today is definitely a learning day. That's why I'm sitting in there. I mean, it's just a learning day.
I think it's cleaner than when they tried to go through these interviews in June with Glanville. They're getting through more. As they should, because this is the second time that they're going through this stuff. But for this call, at least, I don't think they got through all of the calls in June. They stopped the hearings, but they had gone through a lot of the June 15th stuff. June 10th, 2015.
Yeah, June 10th, 2015. And then I think it's really interesting too about Shannon and how all his convictions are prior to the RICO starting.
Yeah, back in 2012.
Yeah, back in 2012. And they're trying to use that. I don't know. I don't know how I feel about that.
I think that just comes down to possession issues where it's not that they're trying to bring in the conviction, it's just that they will be able to say he shouldn't have been in possession of a firearm, because even if we presume that the firearm could have been licensed, he shouldn't have had it if his felon status would bar him from having it. So
Yep. But I like what
there's a
Max
gray
said
area
about
there.
why do all 5 felony convictions have to come in?
Yeah, yep, exactly.
That's
Because
so
that's the
prejudicial.
prejudicial part.
Yeah, that's so prejudicial. Okay,
And I
Kat,
think it's prejudicial to all. Enjoy the rest of your last
I'm
bites.
about
Get
to eat
back
my
in
lunch,
there.
and then I'll see you at 6 o'clock with Nick.
Okay. Yeah,
Okay.
I'll see you then. I'm going to drop your link too.
Thank
Bye.
you. Bye-bye.
Oh, thank you, Ghost. So Ghost in the chat also just dropped Kayla's channel. She has it back now. She's eating. She's on the go. Let me get this screen back up here because, you know, if I don't put it up here, I'll think it's playing and you guys won't hear it and you'll be like, the screen's not sharing. So here we are. Yeah, Kayla can get away with eating on camera. I could never do that. I'd be a mess. And hit that like button, you guys. It's free 99. And let's see. Dennis says, I can't believe this case is moving forward. You know how it goes. Justice Matters, good to see you. Yeah, because Glanville would spend time doing his own arguing, practicing from the bench. And then, you know, I do think technically more yes that can come in favor of the state has happened today. But I think some of the bigger statements were kept out. That drive-by, all the stuff about the drive-by shooting. The family's house, not of Donovan Thomas, but the shooting of the family's house. You know, Shard had made the argument that my client, we don't know what's the evidence that my client was even present? If he wasn't present, then these statements about him being there, you know, why do they get to come in? So that was a pretty big, good exclusion for the defense, especially for Shard. But there were other statements that some weren't really that consequential that they're like, all right, it can come in and it's opinion. The jury gets to decide if they think it's credible or not. So. And Julie, good to see you. MVP in the chat of like what days certain things were happening in the courtroom. And then, okay, and then Justice says that comment wasn't as it relates to him taking longer to hash these things out. Yeah, we'd be here forever. We would be here forever. So I know the lead attorney does a course, but that's really on streaming. So are you speaking about, you know, there are people that do teach courses, and I wish I could think of them offhand, on how to run a faceless YouTube channel and make money. Oh, do I have any? Not do I know any? No. I kind of have some like random coaching content here and there where I've helped like real estate agents. And with real estate agents, guys, that's usually they're working with a local market. You know, a lot of real estate agents just work in one market, one location, and their marketing should be very heavily curated and keyworded towards that area, being an expert of your local market. So even the stuff I've coached on might not be applicable if you're trying to do something with a national audience that's topic based. So, and no, I don't think I'm moving to Miami. It's expensive there. It's expensive. You know, I like to visit there. I like to go down there sometimes. You know, honestly, sometimes I've got Orlando pretty close. And then we have Melbourne, which is kind of big, but it's still, people don't really think of it as a city. It's not that big. And then really going further down towards like West Palm and then Miami and Fort Lauderdale. That's where like the bigger, I don't know, more stuff seems to go on down there. So I do go down there a lot. I like Art Week. One of my favorite DJs from Rochester, DJ Ease, he's always down for Art Basel Week in Miami. I like to go down to Fort Lauderdale when he comes out. I just like to hear good music. And some of the DJs, you go somewhere, I was spoiled. There's nothing like the quality of DJs, both in New York City, in Queens, in Brooklyn, in Buffalo, in Rochester. They all have top tier DJs. If you go to a club because you want to go to the club, it's probably because you're going, the DJ that's playing, the DJ that's going to be there. The DJ brings the whole vibe. Here, you go to a bar that has drink specials and you're stuck with whatever DJ's there. And that's not really how I like to approach going out. But I do love like West Palm, Miami, Fort Lauderdale for things like that. I don't think I'd move there though. Do not think I'd move there. No way, you're from Orlando? So you don't live there anymore though? Because if you're in Orlando, we definitely have to chop it up sometime. We can go get some food. Because you're one of my favorite people that's like been in the chat since, you know, the Jonathan Majors trial, of course. So I feel like we're like internet friends. Yeah, and Club Live is always popping, but that can be pretty, I don't know. They do different themes, different times of the night, different appearances. Sometimes it's too much going on there. Tampa's a good time. You know, I like Ybor City. I like Ybor. Ybor is a good time. I first came down to, I was not 21. They didn't seem to, I think Prana used to let like 18 plus in. And Prana had this cool, the rooftop bar. They had a rooftop outside. And they're playing like, I don't know, it was like everything, a whole mix of West Indian music. They're playing like chutney, like calypso, like a whole bunch of different stuff. I had a great, great time at Prana and Ybor. And then I think some of the other stuff I know in Ybor isn't open anymore. Like a lot of the clubs have closed down because that would have been, I'm old, you guys. That would have been like 10 years ago, more than 10 years ago. And then, yeah, so Miss Hawkins, the Jonathan Majors case is kind of, I already had 2 videos on my channel just because I needed to upload videos to share something on X about Depp v. Heard exhibits. But I already had the channel created and I was like, oh, this Jonathan Majors case, there's like some interesting stuff here. So that's really what got me doing video coverage of cases. So that's kind of what rolled the ball here. And super major case, a lot of people ended up covering it. I met a lot of great people through covering it. But that was a hard one, you guys, because there's no transparency in those New York courts. It was a pain in the butt to cover that stuff. And a lot of people still only know the information, the very slim information that was published by certain media outlets. And they left a lot out. They published with omission. They left a lot of stuff out. And then you read the transcripts and it's like, boom, dang. Yeah, Drea, it's a good time. If Prana is still open, I don't know, it's probably not because it's just old. That 5th floor, they had different themes on every floor. But that top floor was awesome. And it was all different age groups up there. Like, I think I remember, you know, you had like aunties, they knew all the music, they knew all the music artists. So you could be like, well, who was the artist that's doing this song? And then I remember these 2 guys that were, I don't know if they're from Canada or from like upstate New York or something. They were like hockey players and they were like drinking like cranberry vodkas and they're like, cool, what is this? It was great. It was just like a melting pot up there. It was a super good time. And then G Lander for $4.99 says, what is your background? You seem to have a unique commentary style that is very succinct and has a flair of uncluttered clarity that I appreciate. Oh, I don't know. I've done a ton of stuff. I'd say maybe wanting to look for stuff really comes out of hobbies. I don't really have a work background that relates to, I don't know, anything in law or legal. I've done some data research, procurement of public records for companies. One of the real estate companies specialized in probate. So, they would go to all these different counties and try to be able to pull the records. And then we'd train real estate agents to not just call these people and be like, are you trying to sell a house that you inherited? No, there's problems with probate and inheritance where Medicaid could put a lien on your house. Parents could have had a reverse mortgage and the kids don't know how to deal with that. There could be squatters in a house. If the parents lived there, the children already moved out and they live in another state, they inherit a house that has squatters sitting in it. Well, how do you get these resources so agents all around the country can know the rules, the statutes, the codes on how to deal with a squatter sitting in someone's house or stealing pipes and now there's like water leaking everywhere in this person's house that they inherited. So I did a little bit of data procurement, making requests to clerks around the country to try to procure these records, but it really wasn't that much in the court space. As far as being succinct, I don't know. I think I hate when it's difficult to find information that I feel like should be accessible. And over the last 10, 15 years for issues that I've been interested in, I have a deep appreciation for people. If I could go and search for something on Reddit and someone in Reddit shares a link to an article that is not easy to find through a Google search. I've just had an appreciation for crowdsourcing. And I know crowdsourcing, you can get misinformation kind of piling up too, right? There's pros and cons to this. But with crowdsourcing, when people take an interest in an issue, it's easier if someone does a little bit of work here, someone else does a little bit of work here. You can kind of bring together a fuller picture, more complete information than you would get if you just tried to start from scratch on your own. So I've always had an appreciation for crowdsourcing, being on the YouTube side of it, being the one on the screen, being able to bring that information forward is just kind of like coming full circle. I'm doing it anyway. I want to make it more digestible for other people. And then to be at a place now, I'm so grateful that I could have 1,000 people in the chat that are all like, hold on, wait, did she just say that? Or don't forget, we learned a few months ago about this piece of context. And to be able to just sit here and go like this and bring up information and say, cool, this is the full picture of everything. I think it's a really powerful thing for all topics too, not just for law and crime, true crime. I think it's a powerful thing for, news, for politics. I'm not really too into politics. You'll hear me say every once and then, I feel like I got burned in 2016. I'm not a fan of what happened with the primaries in 2016. And I've been kind of scorned when it comes to politics ever since. But I do still like to go and get some information here and there. And I like certain YouTube communities better than just reading a headline really quick somewhere. Topics like entertainment, topics like sports. I love the way that you can go on X and see a whole debate about player stats play out with sports. See a whole prediction, a whole conversation about trade predictions. I just think the community, what we have on the internet is just really cool. That's really it. That's my summation. As far as succinctness, I don't like to waste people's time. And yeah, Drea, that's why I remember you that day I panicked and needed a mod. I was like, I know I can trust Drea. I've known her longer. She's been around. And then let's see. I see Plain Mary Jane. Hey Americans. It just scrolled away. Hey Americans from the rest of us. Right. I saw, guys, this was my favorite coverage of the debate. So, the debate, everyone was flying everywhere. YouTube was flying off. X was popping off. It was trending. Everybody was talking about it. I saw a tweet on X after the debate, and it had me in the first half, and it got me in the second half. It was like, wow, guys, I know that everybody's saying that we should give either side a chance, but can't we find anybody older who's willing to run? And like making the humorous suggestion that we need someone older than these two guys. These two guys aren't old enough. And that was my favorite. That should give you some insight into my political stance. We need someone older than these two guys that we've currently got in front of us as a joke. And I think that's funny. That's there's your insight onto my view on current politics. Do I think a mistrial? Hold on, wait. Jimmy Carter's only 99, but he's lucid. No, let him keep doing. Isn't he like raising a ton of money for Habitat for Humanity and stuff? I think that's more of like an active cause, you know? And guys, I'm open to people's political opinions. You know, I don't care what people think. I think it's important to listen to other people. I don't like the idea of people saying we shouldn't talk to people that we disagree with. That's really my whole stance on politics. I don't have a conviction one way or the other. And then, do you think a mistrial is on the way? I don't know. Should we do a vote? Let's do different numbers because I always say one. Let's do a Y in the chat if you think yes mistrial, and an N if in the chat if you think no mistrial. Do an M for maybe. So what's your vote on mistrial still being on the table? All right, so we got some Ys. Okay, I'm going to try to get them up because it goes fast when this happens. So we've got a bunch of Ys right away. We've got a yes. Then we've got a no, based on what you think the judge will do. A maybe. Then the no's, the maybes are flooding in. N, a yes, a no, maybe, yes. This is split, you guys. There's a block of yeses. We've got a bunch of yeses. We're leaning a little bit more yes. No, maybe. No, unfortunately. Maybe. Yeah, I could do a poll. You guys want to do a poll? We'll do a poll. We've got some time. We'll let this poll run for the 10 minutes till we come back. There we go. Poll away, you guys. Oh, I should have done a with prejudice or without prejudice option. L for later. Mahadi De Jesus, thank you for the 10. Carter is for Habitat for Humanity. Just donating appliances and furniture. Who's winning on motions? So shout out to you for, you know, donating some appliances and furniture. Huge stuff. That stuff's expensive. When you try to move somewhere, and a lot of people, I see a lot of people, I've never rented a place that didn't come with a furniture or stove. But I've seen places that look cheap and then it's like you got to bring your own appliances, and that just seems like a nightmare. So shout out to you for doing that. I see a lot. I love reading Reddit posts on cheap and budget eating, budget meals. And a lot of the time it's like people are like, I don't have appliances. Like I'm living on like $20 a week. So that's an awesome thing that you're doing. And then as far as motions and like these rulings, these stipulations, I do think we got most of the statements that we've decided on today were Hilton and Shard realizing like, all right, we agreed to this incumbent, it's fine. Most of it were like, oh, oops, we already agreed to that. Or, oh, oops, we already agreed to that. And then I would say the state has gotten more that they were arguing that they wanted to come in and the defense was saying we don't want them to come in. I would say the state has won more rulings in their favor on those statements. But the defense did get a big one kept out. Yeah, that's a clarification too. If what we think will actually happen, not what we want. And what do you guys think? What if the jury comes in and there's like, look, I moved over this 2-month period. I'm not here anymore. They heard that the one juror got out because they moved. They all start doing the same thing. They all move. I would move. Would you guys move? I hate moving, but I would. Look, I feel like as a juror, I would be sitting there, and even though I'm not supposed to see all this stuff, and I don't think I'd be online. If I had to sit for, I don't know, probably about like 9 to 4 every day, I'd be so busy when I went home because I run my own business. I have clients. I wouldn't necessarily lose my job just because I'm doing jury duty. I would try to fit my workload, and I might have to lose clients or give clients up. But I would still try to fit my workload into that time frame of when I get home. So I don't know if I'd have time to accidentally look at this case, and I would try to listen and follow the rules if I was a juror. But I still think, that being said, I would have picked up that something wasn't gravy. I don't know. It's hard to say because I watched a lot of the pretrial stuff. But I don't know. I guess if I try to consider if I didn't watch that stuff, I still think I would have been sitting there and thought stuff was funky. And I don't know. Veronica says I would definitely move. Yeah, what if the jury comes in? If I was renting, I would move. Jim says, what if the jury comes in and says, I heard Glanville got fired? Then what? Because it seems to be, and think about that. If the judge thinks it's an issue for something like that to be hinted at in the curative instructions, well, is it a problem if the jury ends up finding this stuff out? Is it a problem if a sworn witness has been talking about this case in social media this whole time? There was almost an issue with the Ashley Benefield case that was down here in Florida, where the victim's daughter, she testified, and she was supposed to come back as a rebuttal witness, which means she might need to testify again. So she was instructed not to speak about her testimony. But then if we find out that someone sees her speaking to a court reporter, and they have to get her back up on the stand, and she has to say that she wasn't talking about her case, but she was also making TikToks and whatever else. So the judge didn't make an issue of it because she testified that she wasn't talking about the case, and just that was it. So no evidence that she was talking about the case. But it was a big enough deal that they had to call her. They had to stop for about an hour and a half of the proceedings to hear from the defense and then the state for them to argue why it's an issue, why it's not an issue. Okay, we need to call her. And I would imagine there's some stuff on YouTube, Instagram Live, TikTok, where Kenneth Copeland said a lot more than whatever Ava Benefield said to this reporter. But let's see if we actually see a judge make a big deal about it or not. And it's like, yeah, Miss Hawkins, you're exactly right. So it's human nature. They've been out for almost 2 months. Surely they wondered why and looked it up. Drea. The jurors are at the club and the DJ announces the Glanville recusal. Heck yeah. Although, what time was that announced? Because that would have to be like, day drinking. What do I like about this judge the most? Part of me wants to say that she is looking for actual legal argument. But really, I think what I like is the punctuality. She's not trying to play around with the time. She's not trying to let someone willy-nilly and steamroll an argument through. If you can't make your argument, I'm going to rule the other way, or I'm going to give you time and say you have homework and come back with it, right? If it's a serious issue, then I'm going to give you the time to go and look up the case law, but come back with case law. These other issues, she's not letting these long rambling rants go on and on. If we're not prepared, we're moving on to another issue. She wants this 30 weeks to stick. I don't think it'll be 30 weeks unless we're able to exclude, like, if, for example, we exclude something major, like one of these police interview videos or something. I don't think we'll be on target for 30 weeks for this trial to finish. But I do feel optimistic that within the best of her ability, she will be pretty close to that. And she'll keep reminding people, don't just play with my time. So that's definitely it. the punctuality and the optimism about the timeline and the effort to get there. And then what is Glanville saying in the chat here? Oh, and GGT, thank you so much. GG says, no, because the judge is making too many concessions. So this is no for the mistrial poll. And I think there are a lot of things that she's, there's been some blows to the defense. A lot of these motions that they filed over the last week and a half have been shut down, denied. So that is a very good point. And then recused Judge Glanville says, put a 1 for how beautiful my boo love looks today. Put a 1 in the chat for shopping cart love. There we go. We got movement, you guys. Let me end this poll. Get your votes in quick. You got 30 seconds. Yeah. 30 weeks, she might realize, nope, not happening after 30 days. But guys, 8 months is a lot shorter than like 2 years, a year and a half. All right, I'm going to end the poll. So those are the results. The final results. So we've got 56 think yes, mistrial, 23% think no, and 19% think maybe. So not that unsplit if you kind of group the no's and the maybes together. I do think, since I didn't clarify, that a lot of those yeses are wants rather than predictions. Yeah, like that's like, please, please. And then Garrett S., thank you so much again. So Garrett S. says, no mistrial yet, but Woody takes a 5th. It won't matter. Yeah, we're going to be right here. I really think that's going to be what happens. And not for nothing, but Woody could come back up there with a whole different demeanor. Like, he's been out here in the public, even the people that are like, he has a past, he's probably done some things. There are still people that are like, all of that aside, what they tried to do with him in the ex parte meeting wasn't right. He could be back up on that stand with a whole lot of oomph behind him. He just short-circuited the trial, and he'll do it again. He just comes up there with a whole different story. Yeah, I don't know, John. How will the jury be able to remember testimony from the start of the trial with it going so long? I don't know, especially since it wasn't well presented. Oh, if this goes to mistrial, would be the next step for this channel. I mean, I still do like to look at, so Courtney Clenny trial is on my radar because I think it's interesting that it seems like they're going to argue mutually toxic relationship rather than a pure dynamic where one person always has the power, the coercive control. Is this muted? I don't have it muted. I don't think they turned the sound back on. Okay, there we go.
All right.
There we go.
So over the lunch break, I did not get a chance to do any of the things that I told y'all I was going to do. However, one thing I did do was work on the further revision of the jury instruction. I saw that the state had sent over a couple of different proposals.
A couple?
And
narrow it down to one.
Part of those were good. And I'm just going to tell y'all, I'm just going to read out what I've come up with, which is a little bit from here and a little bit from there. Ladies and gentlemen, my name is Judge Whitaker. Judge Glanville is no longer the judge presiding over this case for which you have been selected and sworn to try. I will be the presiding judge in this case moving forward. You are not to concern yourself with this change. And I propose to say,
And to calm any concerns, Judge Glanville is fine. Because if I don't say something like that, they're gonna be like, oh my God, did he have a heart attack? Or, so that way nobody's searching on the internet. Okay, then let me remind you, as I assume presiding duties in this case, that none of my decisions and nothing I say during the trial is evidence, just like none of Judge Glanville's decisions and nothing Judge Glanville said during the trial is evidence. The decisions and remarks of a judge do not mean that the judge favors or leans to one side or another in the case. I am only interested in seeing that this case is tried fairly based on the laws and the Constitution of the state of Georgia and the Constitution of the United States. You are to disregard any comments that may have been made by Judge Glanville about any of the lawyers in this case. To maintain the dignity of the jury system, I remind you that you must decide this case based only on the evidence admitted during the trial and the laws I will explain to you. Thoughts, objections?
Anything inconsistent with what Mr. Williams filed yesterday, which I know was part of the file, we would object to. I think that it's important not to say that, don't worry about it, Judge Glanville is fine.
Okay, well, I just mean, if you want to come up with another way to say that, that's fine. Do you not want to say anything at all? Just.
I'd like to say what I wrote. He's been removed from the case. That's it. It's not disparaging. It should be disparaging, but it's not. It just says he's been removed.
Well, he is no longer the judge presiding over the case. I think pretty much says that. All right.
Can I also ask just a procedural question?
Mm-hmm.
You were very kind in emailing us transcripts like June 7th. Is that, can I ask you, do you know if that's in the record?
It is not yet because it was the rough. Are you talking about of the ex parte?
Yes.
No, when Ms. Weaver sent it to me on request, she said at the time, this is still rough. So as soon as it's ready in final form, I can ask her to file it, but it's not yet.
Okay, thank you. It's just that we've been referring to it.
Sure.
In the appellate court thing.
Now, it will get in the record.
Thank you, Your Honor.
All right.
Your Honor, with respect to the instruction that you are to disregard comments that were made regarding any of the lawyers, the only concern I have is that, of course, the judge ruled on objections, and in the ruling, I don't know if anyone could perceive any of that as comments. I know it's kind of silly, but it's plausible. And I would ask that the court, with respect to the pattern or the altered pattern instruction, instead read the decisions and remarks of a judge do not mean that the judge favors or leans to one side or another in the case.
Mm-hmm.
The court is only interested in seeing that this case is tried fairly based on the laws and the Constitution of the state of Georgia and the Constitution of the United States, rather than.
I am.
Right.
Is that the change you're talking about? Instead of saying I am, say the judge is?
Correct. That, and instead of saying disregard the comments that the judge has made, instead read the decisions and remarks of a judge do not mean that the judge favors or leans to one side or another.
So you're saying just say that, don't say disregard.
Right.
Okay. I'm overruling that.
Okay.
So neither side's happy, so that probably means I did a good job.
Well, the court, is the court considering, instead of saying I am, saying the court is? I didn't know.
That's fine.
Okay.
I don't think that's a particularly substantive change. All right. So that takes care of that. And we were on I think we had finished the 387 lines 10 through 12, and we hadn't moved on to the next thing yet. So let me know what the next portion is.
Yes, Your Honor. We will actually have to go back a
Okay.
little. Mr. Shard and I had the ability to meet
Okay.
during the lunch break, and we did discuss those redactions that we agreed with. And there were a few early on that we realized we still disagree with. So
Okay.
the first, Your Honor, is page 266, lines 14 through 24.
Thanks, Garrett. I think that might be stricken. Well, maybe it's short.
Okay.
Copyright strike, not stricken from the record.
My stance, my belief is that this goes back to the issue of hearsay about what he believes, quote unquote, Doug, Mr. Williams, said to other people. And so really the key part of this is, the last section. So Doug was like,
Yeah,
that gun, you know what I mean? And it just.
it looks,
We need to know if he has.
yeah, that's definitely nothing but hearsay at this point, and we have no idea. So that we need a foundation. And that also outside the jury. Agreed. All right.
Your Honor, page 270, line 4 through 18.
You know, I stand by my objection to this, but in candid to the court, I actually can't say the page number, but you previously stated that, Mr. Copeland's statement said Shannon was in possession of the gun, would be admissible over my objection.
Mm-hmm.
I think this falls under the same.
Okay. So you're just making the objection to this part as well. All right. Thank you.
So the next, Your Honor, I think we're back on track, and we're
Okay.
at page 389, lines 1 through 17.
So,
Let me read it. Give me just a second. Okay.
okay, so if you go to just the last line of 388, just back it up,
Yeah.
it says, they're asking who's talking about the Donovan Thomas case. And he says, I never heard Shannon talk about it.
Mm-hmm.
He says, I heard Nard talk and laugh about it. Know what I mean? And he doesn't say what Nard says. So
Right.
there's no statement. The fact that I've heard Nard laugh about it, we don't know the context of it, but that may be admissible against Nard, his name is Demise McMullen. He's on the indictment, but he's not sitting here with the rest of these gentlemen here today.
Mm-hmm.
So we think it's inappropriate to talk about how Nard has reacted or Demise McMullen has reacted to this.
Can I ask, so it's either in evidence or going to be in evidence, all of the people that the state alleges committed this particular alleged crime, right? I mean, the jury's gonna know they think Nard did it, that they, the state, think Nard did it.
Well, I would say the state thinks, Nard did it. The state in their opening statement has stated as much. I'm standing by my objections about Kenneth Copeland's testifying about what Mr. Darlington said. But that's their stance, that Nard was there and involved in the car. But, so yes, I would agree that that's their theory. I don't know what the evidence is going to show or how strong the evidence is going to be, but again, his reaction to this and laughing about it is prejudicial to our clients and irrelevant because he's not sitting here with us.
All right, I'll hear from the state.
Your Honor, we do allege that the person he's referring to as McMullen is a member of YSL and one of the individuals who shot and killed Mr. Thomas back on January 10, 2015. And so what precedes this conversation or this portion of Mr. Copeland's, what he tells police is that they ultimately brag about the fact that they killed Nutt, either by laughing or Mr. Williams' sister. We believe that that's a person by the name of Max. We believe that she is an unindicted co-conspirator in the YSL gang enterprise. We have put in evidence already phone records of Miss White, specifically with the Little Wayne bus shooting, that she was in the vehicle following that bus, so actively being part of the enterprise. We believe there'll be a jail call that's going to come in regarding some comments that she made specifically about the murder of Donovan Thomas. Basically claiming that they were the ones responsible for killing Donovan Thomas. And so these statements corroborate that ability for this gang to be cohesive regarding a crime that they have committed, and talking about it freely amongst themselves, we believe would show cohesiveness with the gang, would show, and that would be in furtherance of this gang cohesiveness.
Okay.
So now I understand that the statements, the argument for admission is A1B2E. I don't understand how states arguing that Nard, according to Mr. Copeland, saying, laughing and saying, man, F that B, furthers conspiracy in any way. We don't know any of the circumstances around when he supposedly said this, who was around, or how that would be speaking for anyone other than Mr. McMullen himself. And then when we get to Max, who she allegedly said something about, and I guess this was afterwards, according to Mr. Copeland, I don't know. You better not play with my brother. We're really reaching the conclusion that these are statements in furtherance of a conspiracy. These seem to be individual statements, just what they think about things. I don't know, maybe Max doesn't like Mr. Thomas, maybe Max doesn't like Mr. Thomas, was mad. But Max is not, it's not a statement by a co-conspirator, it's not furthering anything. Max and Nard do not speak for Mr. Stillwell. Mr. McMullen laughing is not an indication of how Mr. Stillwell feels about anything. And neither of these two individuals, Max or Mr. McMullen, are seated here today. So I don't know why it would be admissible against them.
Okay, so, well, because it's alleged to be a gang and it's alleged to be RICO. And I mean, it's, you know, kind of good in contrast that your client never laughed or said a thing about it. And these people are, you know, it's not true. And you can point at somebody not here if you want to or not. But I think under the state's theory, and given that you're telling me evidence that these people are going to be shown to, at least by a preponderance, be part of this gang or associated with this gang, and this is kind of bragging on the gang.
Well, Your Honor, regarding the association with the alleged gang, I just want to make sure I'm clear. Max is not indicted.
Right.
She's not charged.
No.
Really, this is the first time I'm
Hearing that she's an unindicted co-conspirator?
Yes, I've heard her on help calls, talking with people. But I don't believe I've ever heard that she's an unindicted co-conspirator.
Now you know.
And I believe you did during the entire Little Wayne bus shooting.
Mr. Steele corrected me and said that they have.
Okay, all right. So, yeah, I'm gonna let that in.
Part A, we're complete. I know Part B is probably gonna be handled by Mr. Adams, I think. So we have.
Part A and Part B. I don't know where you are now.
So Mr. Shar handled some of these redactions previously, and then Mr. Adams handled
Okay.
the rest of those.
All right, take it away, Mr. Adams. So give us the next portion we're going to be contemplating.
Question and go from page 413
Okay.
to the end of the transcript.
Ooh, that's a lot.
That's good news. And I believe that I'm really just going to be reciting to you what we've already argued, discussed,
Okay.
and agreed to.
All right.
I don't, and Ms. Hilton will correct me if I'm wrong, I don't believe there's going to be any disagreement about what I'm about to go over. But if I can have about 30 seconds just to check one.
Sure. All right, so you're just going to put on the record the stuff that's agreed to?
Yes.
Okay. Sounds good. Pages of lines. Might I ask if it's already in writing anyway, and y'all can sort out that you do agree to it, if you might just file it instead of reading it out for the next 20 minutes?
I could. What you're actually seeing me flip through our email exchanges between
Okay.
Ms. Hilton and I.
Okay. Well, you don't have to file the emails, but maybe that might be a better use of our time and easier for you.
I'm happy to do that if
All
that's
right.
the court's preference.
Let's do that. Okay,
One
so
moment,
y'all,
if I
okay.
can, though. Let me just make sure we agree on one point.
It's interesting that they're turning the sound off for this. The Law and Crime stream, I mean. So it's sort of blocked by Love's head, but normally there's like a camera sitting, I don't know, it doesn't show my mouse on the screen, but kind of right where Love's head is, this monitor, not the laptop screens, but this monitor screen. There's usually a camera, sometimes a camera, sitting right on top of this screen that, you know, kind of shows the prosecution's faces for the Zoom broadcast. And certain days it's not there. Certain times of the day it's suddenly not there. So this would be the area right where Love's head is blocking right now, where you would look on other days. Yes, this is still Woody stuff. It's still, unless I missed it, you know, I was snacking on my little Kind bar over here. This is still all from the June 10th, 2015 interview video. There's nothing, it's the court sound is off. The courtroom is muted. Right, make me part of the courtroom up here. Oh, so Eric Rose says, did you see the Slimso and Woody videos where he's on a rampage throughout ATL, where he's driving around in the Hellcat? I watched that. He was like, you ready? And the other guy did not look ready.
And speak, and I will follow the court's instruction.
Thank you.
I think we can very well go ahead and I can put an email together that outlines what we have agreed to in terms of the redactions. There is one portion that we may or may not have agreed on.
Okay.
And between checking the transcript of that and also just talking, we can go ahead and resolve that. We don't have to do that right now.
That sounds good. All right, so, and you can just file, I mean, it doesn't have to be in email form. You can just print out, here's what we've agreed to and file that.
I'll do that.
All right, so what's our next statement we're moving to? Apparently. Mr. Adams got the easy part. Wow.
So we have the statement on the 21st,
January 21st?
February 21st, 2015.
Okay, right. We've got January 11th, January 28th, February 20th, February 21st, and June 10th, right?
Right.
So this is February 21st.
Yes.
All right, let me get that transcript and y'all can switch to that video to the extent
We're
we
moving
might
on
need
to another
ever
interview.
watch a portion of that video.
February 21st. My best.
Okay.
Come on, Shard.
Your Honor, and I apologize.
Okay. All right, so for the February 21st statement, what's our first portion we need to look at?
For February 21st, first thing I have is page 13, line 19, through page 14, line 3.
Okay.
Do you have timestamps for when you said page numbers?
So this has 3:59:50 to 4:20, 4 o'clock and 20 seconds.
Okay.
All right, what's our issue?
Ms. Hilton, I'm sorry, Ms. Hilton, could you say now that I have the time, I wanted to make sure we were talking about the same thing. What, page 13, line
19 through page 14, line 3.
we've got different transcripts.
So is this with Detective Gaither starting, you have it in your mind, we can't do nothing about it?
Yes.
Is that a different transcript? I can email you what I got whatever I got from Miss Weaver.
Please, Your Honor.
Okay, Laura, can you?
Yeah, different transcripts, I'm just.
Yeah, no, that'll be crazy if we're not working off the same transcript.
And Doug has seen the Tootsie Pop animation that Flesh of the Gods made. He said it's pretty funny.
And Your Honor, what I'm going to try to do to keep this moving a little bit, I have a transcript provided yesterday by the court
Okay.
regarding my prior arguments about some of these issues, and I'm just going to try to keep up with the transcript and reiterate what I've argued in the past. So it should be the same.
Okay.
And you have the transcript?
I do. So let me pull that up. Can you tell me what date?
February 21st.
No, I'm sorry. The date of the transcript for this trial where the February 21st statement by Copeland is argued.
It is June 21st.
Okay.
2020.
All right. I have that up as well.
Okay, so if I seem to be arguing something that's not consistent with the transcript, please just let me know and it's not intentional. It's just I got too many transcripts going on. But my understanding of what we're talking about here is Investigator Gaither is prodding Mr. Copeland for information about who shot at him. And in this context, it is the February, I believe it's February 19th or 20th shooting that they're prodding information about and asking Mr. Copeland to tell them who shot at him and his child and his mother's child. And Investigator Gaither goes through an extended, I'm not going to say monologue because it is broken up, but she is attempting to extract information from Mr. Copeland, and she's talking about the need to protect the community, to keep babies safe, and just essentially makes an argument in that interview that would draw an objection, at least for me, if the state were to make the argument in closing arguments. So I don't believe, I think, the focus, if we're admitting these statements in part, if they are admitted, they would be because they're inconsistent statements by Mr. Copeland. And I don't know how that somehow opens the door to Investigator Gaither to give basically her, thesis on why her job is important and gangs are bad and the community needs to be kept safe by her and her coworkers. So that's our objection, 403, 401. And it doesn't fall under prior inconsistent statements.
Come on, state, what's your counter?
Okay. I'll hear from the state.
So previously, Your Honor, when Mr. Copeland was here in court, his testimony in court was essentially, and I'm going to paraphrase, I didn't care about snitching. I didn't care about telling on police. I didn't care about telling the police who did the crime back in 2015. And so this portion of the interview was in contradiction to what he was saying on the stand, because in these 2015 interviews, especially early on, January and February, he would not tell the police who shot at him and his child. And so this portion of the transcript, he's explaining, if I tell you, you can't protect me, you can't do anything. And so Detective Gaither is having a conversation with him about some of his concerns, because this interview, Your Honor, is immediately the day after his first interview regarding this shooting. So he's interviewed on February 20th. And then either in the morning hours or late at night, he's arrested on a probation violation. And then he's brought back in
Conveniently
again to further, they're trying to find out who shot at him and his children. And he has extreme concern about telling the police who shot him, actually admitting to that. And when we were in court, his testimony in contradiction to that was, one, that the individual that he eventually says shot him didn't shoot him. He says that in court. And then he also says that he wasn't concerned about snitching.
Meaning I didn't have any problem with that. I was happy to tell them what happened.
Yes,
Okay.
and so.
So if he testifies consistently to that, or if y'all decide that you're going to stipulate to any part of the testimony, then this would become relevant as a prior inconsistent statement.
Yes, Your Honor.
Okay. All right. But that wasn't the objection from Mr. Sharp.
Sure
So
wasn't.
even in going to I give that context because their conversation here is the effect on him, what she's trying to tell him in order to get him to actually tell her who's the person who shot him.
Right.
So we're not really worried about her. We're not offering her commentary for the truth of the matter asserted,
Right.
but we're offering it for her, what she's saying, the effect that it has on him in order for him to come forward and finally tell who shot at him.
Mr. Sharp, I'll give you the last word.
Well, I mean, I understand the state's argument, but I don't think necessarily the need to provide context opens up the door to investigators just going in long diatribes.
Okay, well, I mean, it may be that there are other portions of this that we're going to take up. Right now, I'm looking at 13 line 19 through 22, and then basically 14 lines 1 through 3, where she's saying essentially, hey, buddy, you got to tell us what's going on, which is pretty much the beginning of any conversation, interview, interrogation between the police and anybody. And it shows that Mr. Copeland is very hesitant to do that. And so if he ends up testifying, man, I don't have any problem with that, then this, I would think, can appropriately come in as a prior inconsistent statement. I don't see any real other kind of like 403 or anything issues with it. So this is in, assuming obviously the foundation for getting it in as a prior inconsistent statement is laid.
So the next portion, Your Honor, is page 25, line 15 through page 26, line 3.
Okay.
Timestamp 40840 to 40940.
And Your Honor, last time we discussed these, this one, the one we just discussed, the one we're just about to discuss now, and the next one, we discussed all together because they're the same issue.
Okay, well, I'll look.
And you, I think you'll see, I hope you'll see that that Gaither says more and more, investigator says more and more. They're all the same issue.
Oh, all right.
I'm confused on the scope of what she said. If there's foundation laid, so it's kind of a win for the state, but only if foundation's laid. It's just a statement where it could show a hesitancy on Copeland's part to speak to the police. But he testifies that he buys time at first to think of something to say.
So y'all said 26
So is that inconsistent?
line 3?
So they might struggle with foundation.
25, line
Right,
15.
line 15 through 26, line 3?
Yeah, it's probably more like line 7.
Yeah, okay. That's what I thought.
They might struggle to lay foundation for that when the time comes.
This one looks okay also to me. I'm going to let this in. I mean, she doesn't seem to be saying we're the heroes. She seems to just be saying, gotta tell me something if you want it investigated. All right, what's the next one?
Page 28, line 7 through 14.
Okay.
I'm sorry, the time is 4:10:55 to 4:11:05.
Any additional argument, Mr. Shard, on this?
I mean, it's the same thing, it's just, we care about, you know, the life of children and those sort of things. And we're trying to put an end to all this. We find that prejudicial.
All right. Any response from the state?
Yeah, I think it's the same thing. She's just trying to get him to tell her who is the person who shot at you. And
All right, now, if she ends up standing up in closing and starts saying, look at how great the police are, they love this guy's baby, then we'll have a different issue. But just as a part of the interrogation technique going through statement, I'm gonna overrule that objection.
the next, Your Honor, is page 29, line 9 through, I think I might have I have page 48, line 11, but I think that's a course indulgence. Because I didn't do this. So. Okay, I think it's page 29, line 9 through page 30, line 18.
All right, and what's our issue with this? Is this the same concept, or is this moving on to some other evidentiary issue?
Yes. And I believe that Mr. Shar wanted it out initially.
Yeah, this would be easier if we could hear them like read the statement that they were looking at, but they're not reading it out loud.
This is more side conversation that is, at this point, I don't believe, well, I know our stance is that just because if the state is successful, lays the foundation for specific prior inconsistent statements. Our stance, my stance, I believe I stand for everyone, I speak for everyone here, is that if prior inconsistent statements are included on a tape, that does not necessarily mean that the state just gets to play the tape. What they play still has to be linked to prior inconsistent statements.
Okay.
And here, we're just kind of going and talking about things that are not subject to these prior inconsistent statements. Of course, I don't know what a prior inconsistent statement is right now.
Right.
But I think that there's a lot of fluff in between.
Right. Okay. And is the state proposing to, I've got a prior inconsistent statement somewhere in this 30-minute interview. I'm gonna play the whole interview, or are y'all happy?
So the state's position, again, depending on what we do with Mr. Copeland's testimony, he denies, and I think that's what we talked about yesterday. What he says is, I spoke to the police, everything I said, but it was all a lie. I finessed it all. we're at a position that I don't know if we have to go line by line because his general statement here in court is, I may have said everything that you said, I said, but I was only saying everything that I said because I was trying to get out of going to jail, because I was trying to get out of getting in trouble. I was trying to get out of trouble. And so a part of it is we believe that we don't have to now go line by line, looking at the Scudder case, going, I think it's Scudder, I'm citing the wrong case, going line by line. But specifically as it relates to this portion, we asked him about being a snitch, and this is her trying to explain to him, you need to tell us. It doesn't matter if you're a snitch or not. You need to come forward. When in court, he says something opposite. He says something inconsistent with what he said in his interview.
Okay, so if he ends up saying, I don't know what I said before, but everything I said was a lie, then you can't necessarily just play everything he said. But if he saw everything I said was a lie and I just said it to get out of jail, and then you say, aha, this shows right here, you were willing to go to jail and keep quiet, then that's a prior inconsistent statement to what, if
That'd
we
be
assume
interesting
he
across.
says that on the statement.
What are you interesting to go to jail for?
But no, you do not. I mean, it still has to be, and it may not be, it has to be like every line, but you can't play an hour-long video unless at least most of that video
They already
in some
did.
way is inconsistent to what he's saying on the stand. So I don't know if I can, I mean, this is pretty theoretical right now, but.
I think we just need to see what he says while well, because a lot of people believe two things, not that it's just a prior inconsistent statement, but he's also contradicting what he says. So he'll testify, at least previously, that he'll testify, they were trying to force me to only talk about Thug. They were trying to force me to do these things, and that's incomplete.
That would be,
so
this would show that's not true. Okay, so yes, potentially then, I mean, obviously for all of this, we have to, but I guess what I'm asking is, Mr. Sharp wants to make sure that y'all don't operate under a theory that something in this, and I'm just making it up, I don't know how long the video is, but 30-minute video is an inconsistent statement. We can get the whole video in. Y'all know that, I mean, is that
Tell
your
him you know.
position?
I think it depends on when he testifies.
Okay, so.
So you're trying to get it all in.
Yeah. Okay, so then assuming that, I guess we don't have an answer to that right now, but I would
Of course we
not
don't.
think the entirety of something can come in just because one sentence in it is inconsistent. So for y'all's edification, that would probably be my position. However, assuming that all of this is going to get used as prior and consistent statement because of whatever he says, we have to assume it for now, like that's why we're going through this. Then what other evidentiary objection do you have to it?
Well, I mean, I just keep going back to the same question, which is if the purpose. My problem is all the talking that's, Mr. Copeland isn't really saying anything. It's all investigator gate, and I just don't really understand how we're just giving investigator, and I know Copeland said something, so I'm not trying to mislead the court about the transcript. You have the transcript, but I don't know how we're giving basically Detective Gaither the mic when the purpose is to be impeaching Mr. Copeland with his prior words.
Okay. Well, I mean, I think we got to have the context of what questions he's answering or relating.
To the extent that other people's words may give context.
So, I mean, I would think that in terms of evidentiary issues, then assuming, which we're doing for the sake of this entire exercise, that it comes in as a prior inconsistency, then there aren't other evidentiary issues that would keep this particular part out, 29-9 through 30-18. All right. So what's our next stop?
She's optimistic, thinking these interview videos are 30 minutes long.
Oh, sorry. The next section is page 47, line 9 through page 48.
Well, so everything we just heard, you guys, the state was going pretty much line by line with the beginning of one call. And she's like, I don't see a problem with this. It's just kind of setting the stage of how an interview starts. So she's like, okay, I'll let that in, I'll let that in. But then she's like, wait, are you guys trying to let this whole video in? You're not going to do that. So this was a line by line, yes, we'll let that in, about sort of irrelevant things. But then she said, state, I see what you're doing here, and that's not what we're going to do. So after lunch so far, not really a win either way, in my opinion.
Okay.
And I think it,
She just said she's fine with it being out.
right, I'm not sure. You said it begins at 47:9 on your transcript?
So I'm taking a note that I got some.
He on his Twitter arguing with Shannon.
Okay, you're right, 47:9, okay, I got you.
Okay. Next.
So the next is page 65. Line 1 through 5.
And then positive masculinity, thank you for the 5. This is like so true. The jury has already heard hours of these videos. And they're going to be instructed to disregard certain things. But some of this footage, it sounds like they're going to see twice. Especially the first video that they had played for the jury. So that seems prejudicial to have them repeat a video unless they're asking, unless they're requesting to see it again. How do you reconcile that?
Okay.
It's going to come down to foundation when Woody's back on the stand, you guys. She's not saying, a lot of the time she specified with proper foundation. And now she explicitly stated to the state, you're not going to just play the whole video for one prior inconsistent statement. So the foundation has to be laid that there is an inconsistent statement
why this was objectionable.
for a part to come in.
I think it may have been the programs that were used that was confusing. I'm looking at the transcript.
Yes, on the screen right now, Biliano's bringing a Thugger Daily tweet that Judge Whitaker's basically giving Woody an instruction manual on how to testify to make sure his interviews are inadmissible. He technically shouldn't be watching the proceedings, but...
Y'all. Anybody know?
Oh, okay, I know what it is.
All right.
This was my objection, because it was, okay. It was, I think it's likely to confuse the jurors. This is a very poor transcript, but essentially, and you can't really tell from reading the transcript, my understanding is, Investigator Gaither is asking, when's the last time that Shannon and Demekian were hanging out together? And when it comes down to it, the answer is, his answer, it comes down on page 65, line 5. It says, since they shot at their car. And when I hear that, in that context, it seems that he's referring to
They as in Shannon and.
Shannon as shooting at a car. I believe what Mr. Copeland meant by that is it was an incident where they were all shot at. But I just have a problem with this being played and putting that perception in the jurors' mind.
Okay. All right, and is there a redaction that could be made? So what is it that you potentially want this for?
If it comes and it gives a lot of context, so Mr. Copeland, in this interview, this is now his third interview that he's had with APD, his second with Detective Gaither. So, and excuse me, this is his fourth interview, and I'm saying this in context. In the January 28th interview, he talked to Detective Gaither about the shooting in the car with Demekian and Shannon with him. So when he's discussing right now in February that the only people he hangs out with is Little D and Shannon, and that the last time that he's really seen them is since they shot at the car, that's going back to what he's already talked to Detective Gaither.
All right, in this particular interview, have he and Detective Gaither just been talking about that particular shooting where the three of them were the ones who got shot at?
He's talking about collectively everything that's been happening since January 10th.
So no then? Like if you're the jury listening to it, you might be confused when it says they shot at their car.
But this is the only car incident that when you look at all the interviews.
All right, hang on. So y'all have alleged, I don't know how many different acts in furtherance of a conspiracy, and you've got 8 or 9 different incidents, I'm sure some of them involving cars, where people are getting shot. So it is entirely possible if they hear this, that they, the jury, will be confused into thinking, here's Mr. Copeland saying Shannon and Mr. Garlington are out shooting at a car. And that would not be fair to the defense. So is there a way that maybe we can redact out that little part about they shot at the car? Since nobody knows who the theys are if you don't listen to the whole 4 interviews in their entirety to know the context of it so that we don't confuse the jury. Yes, there is a way to do that, is your answer.
Yeah.
Later on in his answer, he's saying, I don't leave the house anymore, I
Yeah.
stay away, so I don't think that confusing sentence really
Adds anything to it.
Yes, there's a way we can redact this, Your Honor.
So y'all can just redact out that part.
Yes.
All right. So that is 65 line, is that 65? Yeah, 65 line 5, the part that says since they shot at the car. So The rest of it's fine, right? Is the rest of it's fine, Mr. Sharp, essentially?
Yes.
Okay, next.
The next part we have, Your Honor, is page 155, line 1 through page 156, line 20.
Okay.
And then while the state is getting their life together, thank you so much. What's up, Bree, for the 1999? Bree says, hey, Kat, quiet watcher until now. I know that. I do that a lot, too. Love how you're breaking this case down. What do you think the best response for Woody to give on the stand now? Can these tapes be avoided without YSL being snitched on? I mean, the problem is as soon as cross happens, I think, if we get to cross, as soon as cross happens, I think the defense has so much ammo to work with. You know, did you meet with them? How many times did you meet with someone from the state before your testimony in June? Did you meet with them again before you took the stand again in August? And all these questions are going to come in. Did they help you understand that you can answer, I don't recall? Did they try to nudge you or encourage you that you should answer certain questions that we ask you? Did they give you an alternative to what could happen if you don't answer certain questions a certain way? Because what that will show is the state trying to strategize on how to force foundation being laid, even if that foundation being laid isn't Woody testifying truthfully. You see in the June 10th ex parte transcripts, Hilton specifically discuss impeachment. So it's already in her mind, prior inconsistent statements and impeachment by contradiction. She's already looking for her two avenues the whole time she's speaking in these ex parte meetings.
Argument.
Of course the state's not ready, though. That's okay. It gives me time to chat with Bree. But I think Woody going up there could be the same thing. I don't recall. I was just buying time at the very beginning of the interview. I would try to feel them out, figure something out, tell them a little bit of a truth. That way they'd believe the next thing I would tell them. And as soon as I figured out what I could say that I could get out of there if I tell them this thing, tell them what they want to hear. I figure out what they want to know, and then I say that.
The issue, Your Honor, is...
It's not a contradiction. It's consistent, if you ask me.
There's a shooting at a gambling house where by this time, Mr. Copeland has determined that an individual by the name of Kelvin Watts, as well as some of his friends, I guess, were responsible. And I think Mr. Copeland was allegedly shot out. I think Mr. Williams was allegedly shot at or present in the gambling house. Maybe some other individuals as well. Mr. Copeland tells a story, and it's tough to really grasp from the transcript, but no one knew who did, according to Mr. Copeland, no one knew who did this shooting. It was supposedly, and everyone thought it was another group called NBC who had jumped Demekion Garlington on that same day at a club somewhere. So the thought was NBC was responsible for shooting the gambling house. Now, by this time on the interview, Mr. Copeland has determined it was Kelvin Watts. How did he determine it was Kelvin Watts? What's his basis?
Okay.
Well, Kelvin Watts was apparently dating a lady named Trivia, who Mr. Sledge also dated. So the flow of information, as I understand it, is Kelvin Watts, according to Mr. Copeland, Kelvin Watts tells Trivia that he was responsible for shooting up the gambling house. Then Trivia tells Mr. Sledge, and then Mr. Sledge tells Mr. Copeland. So these are not observations based on Mr. Copeland's firsthand knowledge. It's like game of telephone at this point. And he was under the impression that it was NBC based on speculation. So, you know, if Mr. Copeland gets on the stand and starts talking about what he saw at the gambling house that night, that's one thing. My understanding he was there, but to say he did it and all the rest is just layer and layer of hearsay. And then on top of that, he's talking about Mr. Garlington being jumped at the club by NBC. And my understanding is Mr. Copeland was at the gambling house and not at the club. So I don't know what his basis of knowledge on that is either. So he's talking about two different things that he doesn't know.
Okay.
So I'm not sure what the chart said. He doesn't know about the shooting. He does know about the shooting because he was present at the shooting. So the shooting.
Right, for that, it's who's responsible for it might be hearsay on hearsay on hearsay. What do you say to that?
Well, what he says here now is that Gucci, he found out from one person, which was Gucci Red, and that is not Antrevia Smith. That's two different people. Gucci Red and Antrevia are two different people.
Okay, so where's the part where he says, here's who I knew it from?
So if you go to page 156, it says unintelligible, so you need to hear it. But it says Gucci Red. I can play that portion for you.
Please play it. I want to hear it.
Give me a line number.
Line 17.
Okay.
And if we skip to line 15, it says, goddamn, the next night we at the gambling house. They ain't putting no picture. We in there gambling. They taking pictures and shit. Then they came up and shot at us. Only reason we found out it was Kel. He had got into it with Gucci Red. And then she talked to them and she came back and told us, like, man, that was Kel and them that shot y'all. Make it seem like they did because they shot it up.
Okay.
And then they went and shot at another spot. And then Monday we got into it with NBC. And then he goes on to talk about whatever happened between them and NBC. So whether or not Gucci Red told them that Kel shot at them is irrelevant, because what this incident at the gambling house does is kind of form the basis of other events that happened after the gambling house. So some key incidents early on in this conflict between YFN and YSL is there's the gambling house shooting, and that becomes important because after the shooting, I believe it's the next week or the next day at Cascade Skating Ring, Kel, who's the person who shoots at them, and Mr. Williams have a phone call in the presence of Copeland, in which Mr. Williams wants Kel to pay for his car window. So this, whether or not Gucci Red told him doesn't matter. It's what happens afterwards, which is the impetus for this conversation about paying for the car that was shot up at the gambling house.
Well, it could just be because your window's broken. You find out that your window's broken.
Okay.
I mean, in other parts in the discovery, it's the flow of information is described as different, but either way, if it comes from Gucci Red, it's still hearsay.
Well, it is, but they're saying they're not offering it for the truth. Right?
Yes, Your Honor, it's the effect on their listeners, which everything that happens after it derives from them knowing that it was Kel who shot at.
All right, so if that's the only objection, then I'm going to overrule that objection.
State wins.
Okay.
And then thank you to Dylan Doherty. Do you think the state knows that they're losing, so they're going to drag this as much as possible?
Next, Your Honor, is page
I think they're
173,
confident.
line 7 through page 174, line 2.
I don't agree with their confidence, but it looks like they want to continue by any means necessary. They didn't even want a mistrial without prejudice to retry. And then thanks for the compliment also. And then also Kay Cooper, a new member. And Jen, you guys pick your Mario Kart racers. You guys can race each other in the chat.
Okay. All right, Mr. Sharp, you want to articulate your argument?
And, Ms. Hill, you said it ended at 174 too?
Yes, sir.
Just trying to get it. We'll withdraw that.
All right.
Yeah, next is page 181, line 8 through 12.
All right.
And
Any
we-
chance we can just get rid of that?
Yeah, we
Okay.
have an objection to that.
There we go.
Hey, where
And
are we going?
the last one we have is page 185, line 17 through page 186, line 19.
The last one for February 21st.
And you're right, we're okay with redacting.
Entirely? Just trying to get clear what you're saying there.
Yes.
Okay, so that'll be 185, line 17 through 186, line 19 will be out by agreement. Okay? What's our next portion of this transcript?
That's the
That was it.
conclusion that we have.
Oh, okay, well. Okay.
We're done. We
What's
got
our
we got
next
one call
statement
done.
We're moving to.
We can do February 20th.
Okay.
This was the day before.
Send me the same transcript that
Guys, there's still foundation that needs to be laid for a lot of this. It's just not outwardly excluded.
And is there an associated trial transcript where y'all are arguing this that might be beneficial to look at? I mean, we didn't end up using that other one very much, but.
Might need to define foundation for the state.
I mean, if you're not even using it, then that's fine.
Well, I'm trying to remember. I haven't seen the transcript. of it.
Okay.
And February 20 may have been earlier before the break.
Oh, well, hey, then, we don't need to rehash that one.
And that's, I'm trying to figure out, for January 11th and February 20th, I'm trying to figure out when we had those arguments, because we actually played those videos on the.
Okay.
Started on the 12th.
We haven't received the transcript when we discussed January 11th or February 20th, so I don't have an independent recollection of what they are.
And those who had the minimal, we agreed on most of that.
Okay.
The actions that came out, we agreed on.
And they've already been played. Y'all just aren't sure whether it was pre or post recusal motion. Is that what you're saying?
Yes, those two videos were played. Let me back up so the record's clear.
Before.
The video for January 11th and the video for February 20th were both played in front of the jury.
So
At least on the 14th and I believe on the 17th of June.
Okay, but,
I assume that the argument may have happened.
okay.
I don't know if the argument happened post the 12th.
Right.
I can't recall, or if it happened pre the 12th. That's what I
There's a logistics issue there because are you going to have them watch the same video footage twice?
Okay.
that were taken by Ms. Taylor, who, I have that the June 11th interview, excuse me, thank you, January 11th interview was played on the 17th. And the February 20th interview was played on the 17th. So those were played after the motion. I just want to make sure. What does this mean? Okay. It looks like portions of the January 11th were played before. A very small portion. It's like 30 seconds of it.
Was played before what? Okay. So would that indicate to y'all that y'all had already hashed out the evidentiary issues with regard to the January 11th?
They kind of rushed into that
prior to
because
the
they had
motion
nothing else to
recuse
do.
being filed. It would indicate that to me, but did you at least do the entirety of this January 11th statement at the same time? By which I mean, that was not at all clear. Did you handle the evidentiary issues with the January 11th transcript all at the same time?
I knew what you were asking. I don't know the answer to it, and this is why, because
Okay.
in this matches my recollection. This Hilton used January 11th was one very particular point that she played like 30 seconds
Right.
to Mr. Copeland. So I don't know if we had reviewed the whole, and she also played a 10-second clip of the January 28th interview before the motion to recuse.
All right.
And a 12-second clip of the February 20th. But I'm trying to see if there's any note about when we discussed reactions.
So I know that after the jury leaves and hasn't yet come back, y'all discussed the January 21st and the February 21st one, so y'all had not done those pre-interview. I'm not helping, am I? I'm making it more. Okay, yep, no, I don't know what that means. February 21st. I don't know. So if y'all don't know whether you dealt with all of January 11th at the same time or not.
So, Your Honor, initially, I impeached Mr. Copeland as the issue or the topic came up. Then when it turned to everything's a lie, then we went to getting in the entire statement.
The video, not statement.
Or playing the entire statement. And so when we had argument.
All right, so you spent a lot of time after the Yes, yes.
Let's hear it.
Again, I'm looking at notes for 6/17/24. We have we sent redactions regarding. We were discussing redactions, I think, on 17th regarding January 11th, January 28th, February 20th, and February 21 interviews. That leads me to believe that these were not redacted prior to the 12th.
Okay. Well, y'all said y'all are close on those anyway, so why don't we just,
So I think
if it's me revisiting and ruling differently, then maybe lucky state, maybe lucky defense, who knows? I don't know.
So I think the next video we can actually go to is January 28th, because that is where we had some more redactions.
So are y'all just then, as to January 11th and February 20th, y'all said, I think, that there isn't much y'all disagreed with about that anyway?
That's my recollection.
All right, so maybe y'all can get to huddle up together on those two, and maybe y'all can come to agreement. If not, you can either figure out, was the ruling made before the motion to recuse, or if there are two or three things and we don't know when the ruling was made, just bring them to me.
Yes, Sean.
Okay. Okay, so then we'll move on to February 28th. Is that what you said?
January 28th.
January 28th. Right, February 21st, January 28th. I am just making it that much more confusing. Sorry, y'all.
That is confusing.
Mr.
Especially that
Harvey's
they have
gonna
one on
use
June
that word
10th,
when I
like
say
June
that.
10th, 2015, and then June 10th ex parte.
I'm teasing you, Mr. Harvey, although I bet you will. Okay, January 28th.
Yes.
And that has either not been discussed or it was discussed post recusal motion.
Discussed post recusal.
Okay, and so do we need to look at a transcript, or Mr. Shart, you're just gonna?
If the state has a transcript of this motion, this interview.
February, January 28th. All right, we can, I assume we have the one that ours came, I don't know where ours came from, if they came from Ms. Weaver or from the state, but Ms. Firstfield will forward you what we have. Is everybody good? Does anybody need a break? Quick break, 10-minute break. Let's come back at 3.
And I don't think anyone's going to interrupt. They've been good with not interrupting after after they pan away. So what are you guys saying? And I think we had some panic in the chat, you guys. You guys got to remember that her rulings, like this one sentence that I'm going to allow in, I'm going to overrule the objection to it. I'm going to allow it in. It's all depending on a proper foundation at the time of. But what Judge Whitaker seemed to realize as time was going on, hold on, you're giving me line by line. So there are some things that you've agreed upon, but then the things you don't agree are every other missing line. Which means if I start ruling in, you're going to ask me to play this entire video. And the point of this isn't to let the jury sit here and just watch hours and hours of video. It's what's pertinent. What's the purpose of it? What does it show that helps the jury have a better understanding of what is happening? And that's why you kind of see here, like, all right, let's move on with this June 10th call, the June 10th call, and get on with that, because what you're not going to do is bring in the whole thing. All subject to foundation. And here's the other separate consideration. If Woody were to try to plead the fifth, and he still has this outstanding use immunity in place, and he still wants to plead, if this judge says, okay, I'm going to hold you in contempt for the duration of this trial, or until you're willing to come testify. She's already said she only wants this trial to last 30 weeks. Woody indicated, if you look at that June 10th transcript, it seemed like he would have been okay sitting through the duration of the trial, but he didn't want to commit. He wasn't willing to commit to sitting for the duration of this trial and the trial for the remaining co-defendants that are not enjoined in this case. So if he was willing to sit out a longer trial under Judge Glanville, he might be willing to do 30 weeks. Or he might get up there and just say Woody things. Who knows? I don't think he's going to suddenly get up there and either start snitching on himself, because his concern seems to be that he has done something that he doesn't want to have to be asked a question about on the stand. He doesn't even want to be asked about something. So I do feel like he's going to try to get off that stand, and will be more inclined to do so if the worst penalty is a shorter time period than what he was previously willing to sit through. So I don't know when we're going to get you might be confusing it with the motion to disqualify Lawyer Love and Lawyer Hilton, which was denied. It was denied orally, but then it was also like the written order. It posted today, but it was available yesterday. It was on the system yesterday, but nobody had a full copy of it until this morning. Wait, what? Stop it. I didn't hear that. Today felt like 30 weeks. Yeah. This is definitely slower than the other days. Yeah, it is 30 weeks in Fulton County, but I mean, oh, okay, long crime. And yeah, I mean, they gave him immunity, but you saw how he tried to maneuver even when he had the immunity at first. And then Sabata, a trial is about arguments over admissible evidence. In order to have a case, the state, of course, has to have this. The issue before was that they had loads of ridiculous stuff before. And I'm sure you're going to continue, because you probably ran out of characters. But that's really what it all comes down to. And of course, the defense is going to want to make motions to keep certain things out that look bad for their clients. And they're going to want to try to keep out things that are garbage from the state. Things that might not look good for their clients, but not because it's truthfully something that looks bad for their clients, but something that circumstantially looks bad for their clients, but might not even really be bound to the truth as far as what they know from their clients that they're sworn in with, their tasked with representing. So of course they're going to fight to keep that out. The state is fighting to keep certain things out too that the defense wants to introduce. No, there are still motions for mistrial pending, like Doug Weinstein's is still outstanding. But it's just been deferred. There hasn't been a ruling on it. We're going through all these evidentiary things today instead. Oh, and Johanna, maybe it's Johanna, All the way from Ireland. That's awesome. You've been watching from the start of this trial. You poor thing. That's so much time. Think about it. This is a long haul case. And yeah, what do you guys think about these YouTube videos? I know you guys were talking about the Hellcat video, right? So Woody, and I forgot that part when we talked about it a little bit earlier, but Woody did say at one point in the video, I'm in op territory. So I'm in this territory where people, if I was scared of somebody, I'm in their neighborhood. Like, so is he scared of people? I think the defense is going to, if they need to, argue that all this stuff going on with his cooperation to testify, all of his meetings with somebody from the state, those private meetings with Hilton, where they're talking about great things, life stuff, building rapport. The state can ask about all that. The state can ask about all of it. And the jury can determine what they want to make of it. And yeah, they can keep applying for a mistrial. I mean, we've seen how many have been tried for already in this case. Certainly not a shortage of attempts to call for a mistrial. Yeah, and this one's huge too. Seeing that Doug is a nice person. Like, and yeah, it's just so... There's a lot of things in these interviews. There's a lot of things on his text posts on his Instagram story. And it would be really interesting to watch the state fight to keep that stuff out because they've fought so hard to bring in social media posts. So just watching them make the counter argument, which is their job to counter, it's their job to argue for certain things to come in and their job to argue for certain things not to come in. But just saying, on its face, it would be interesting to see them oppose the same thing that they wanted so badly. But if that thing, those social media posts now have something in them that look bad for them, they're going to be like, no, it's just social media posts. They shouldn't come in. How is that, probative? We don't even know if it was Woody on his own account. And we're going to see all those arguments made. Wait, was this in the Hellcat video? A girl said free thug and he said for show. And not for nothing, but if the state wanted to, say Copeland was good for the defense, the state would then, I'm sure they would, say Woody was the defense's witness. The state didn't need him to lay foundation for all these videos that they want to bring in. The state would surely bring this up and want to get this statement in. Oh, but he's on social media as a sworn-in witness saying free thug. So we need to let the jury know because they could use that to weigh the credibility of what he's saying. But, the state doesn't want to argue anything that would discredit Woody because they at least need to get this footage in. Oh, it was on a live. Okay. So TikTok live. Yelling free YSL. Like, come on. Like, that's just crazy. Technically sworn in. Technically sworn in. I can't wait. She keeps kicking the can on these logistics conversations about how we're going to deal with Kenneth Copeland getting back on the stand. Like, I know we're going through the videos that are supposed to be played while he's on the stand. But as far as speaking to the jury, how much of his testimony are they supposed to forget? Like, I still feel like we're going to see Bruce Harvey get up and make arguments during those logistics conversations. As soon as we're back on topic, Harvey's going to be like, look, it's just impossible. It's noble that you're trying, but there's just no light at the end of the tunnel for this attempt. It's futile. And then shout out to Boston. And also, we did get this order, written order. We're not going to disqualify Love and Hilton. But the basis for that was we had other evidence available, possible other witnesses. We have the transcript. So I still don't think we have a decision on a proffer regarding Melnick. Because Brian Steele said, you know, I've got the subpoena and he's here. I'm sure Melnick is pretty all right with coming in and speaking his piece. And he's in the courtroom, so if they want to do this any day, I'm sure they can pull him. But I wonder when we're going to circle back to that. What do you think Steele's proffer about what Melnick has to say? Like, come on. No, they need, so Anthony, they need these videos for some of their witnesses that they plan to call after. I think the closest thing to physical evidence is corroborating evidence where they did find casings that match a type of gun that one of the co-defendants apparently had. But I'm not sure they have ballistics to say that they ran that gun and matched it, that it came, that bullet fired out of that specific gun. They only match it to a specific type of ammunition that a gun that person is known to have would use in that gun. So it's circumstantial. Unless I'm wrong, I don't believe that they did a ballistics report on the actual gun and tested it to see if that bullet came from that gun. I think they only know that that's the same type, which is very circumstantial. So I don't know. But they are using that bullet type. That bullet type is important for the preponderance of the evidence standard as far as getting in some of these hearsay statements relating to the shooting of Donovan Thomas. Right? So, okay, well, if we're trying to get in these statements that Kenneth Copeland, Lil Woody, heard from Garlington and Demise, that, you know, these were the people involved. They did this. These people shot at Donovan Thomas. And then Copeland also says that person also has this type of gun. The state, just to meet that preponderance of the evidence, can say, look, we have other evidence that corroborates these hearsay statements, which would bolster our case, our argument for them being admissible under the hearsay exception. Right? So they do have pieces of evidence that seem circumstantial. And I really could have missed it, you guys. It's just the same type of gun, which to me is kind of like, could be plenty of other people. You know, people are followers. People see that one person gets one type of gun and they go out and buy the exact same one. People see you get the one pair of headphones. Oh, I go out and get the same ones. So is it really that meaningful if we don't have a specific ballistics report? I don't know what the actual test is, but when they can tell that this bullet is scraped up and it matches the inside of a gun. I don't know if we have that. We just have the shell casings. We don't have the individual's gun recovered and tested. So, and I agree. Yeah, and there's no report. Okay, so you guys know you're correct, Kat. They didn't run ballistics and there are no reports. And then Moses Dupree says, as somebody who fires guns, you can't make a case based on casings. For example, any 9mm round can be fired from any 9mm firearm. And again, people will be followers, right? Oh, I want to know what gun I should purchase. What do you think of yours? Oh, I'm a Sig Sauer person, or, you know, I want a Glock. Like, you're going to be brand loyal because of your experience and awareness of seeing other people have the same guns. So it's not unusual that someone would have the exact same one. So how do they know for sure it was just you? If they don't have reports, if they didn't test your specific weapon, if they didn't recover it, to compare it to where these shell casings actually came from. It's nonsense. It really is nonsense. But for the sake of admissibility, it only needs to rise to the preponderance standard. So that's why, like, also, oh, they could be co-conspirators. And the things that they're saying to each other are in furtherance of, you know, gang activity because it's promoting cohesion. And we also have these shell casings. So now the judge gets to consider two reasons. It's pushing them closer to making a valid argument, even though it doesn't really prove anything for sure. And it's quiet in the court. I don't have it muted. They just didn't turn the sound back on. And then shout out also, I think I might have missed this. I'm sorry. Yes, so G Lander said, isn't Woody still technically sworn in? Yup.
Your Honor, can we have just 3 minutes? I think we might be able to get through this much quicker.
Okay, it's the court audio that's quiet. I keep waiting for them, but it's them that's, they've got the sound off. I think they're doing it anytime the clerk is up there speaking at the bench. We do have all 4 screens back. Where's Julie Horn? Julie, are you here in the chat? Julie, the cameras are up. I don't see Julie. Maybe she's listening. But you can see all 4 panels on the screen are lit up again. And I think unless I wasn't paying attention to certain parts, that the 2 grids of the screen were blacked out the whole day so far today until now. Hey, Nick. Miss Love is placed furthest away from the defense since nobody wants to talk to her. Guys, I do think they strategically they knew talking about all these statements, it's really a Shard and Hilton thing because Hilton was questioning Copeland and Shard, a lot of these statements really pertain to his client, Shannon Stillwell. So you see the other attorneys making an assist here and there, but a lot of these are the biggest fight for Shard. Showing the love to Nick in the chat. And thanks, guys. I didn't want to talk earlier, but you guys said that I hit 15K. That's so cool. Shout out to you guys, because that's you. I'm just here existing, but you guys are the chat. You guys are the crowd. You guys are the party. Indira says, I'll be labeled elderly by the time this case ends. The other judge that sat over that plea hearing for the remaining co-defendants said something similar. Something about like to the end of time. I think it was like a biblical reference. Yeah, Moses, that's what I've gathered, unless I've missed it. Nick Starrow's in the chat. He'll know. Nick Starrow, is it just casings that we have for the Donovan Thomas shooting? Do we have any ballistics reports recovered from any individual's gun that says these shell casings were fired through this defendant's weapon? Because I don't think we have that at all. There you go. Only casings, no guns. I do appreciate Shard and Hilton trying to use this time wisely. I mean, while they're figuring out, I don't know, tech issues or something. Thank you, Owen, for the super sticker. Heck yeah.
So you're on the first time that we have, we're at issue is page 42, line 3 through page 44, line 8.
Think we're talking about January 28th. Those calls, that recording. So Plain Mary Jane says, I wonder if a lawyer has ever accidentally called a judge mom like little kids do in school. I called my 5th grade teacher mom once. It was definitely a guy teacher too, Mr. Brown. I think I felt like I died for that day. I like went back to my desk like, oh no. No, not Deputy Brown.
First segment, it's a dispute. It's a discussion about possible, quote unquote, beef between Buddy J, who is, his name, last name is Usher. And he is allegedly a member of IF, or an affiliated subset of IF, and he's a rapper. And I think the state's theory in some ways is that it was considering beef between Buddy J and Mr. Williams, because Buddy J said some things about Mr. Williams, Mr. Jeffrey Williams, I should say. And Mr. Copeland goes on to say, well, they say that Birdman Williams, Brian Williams, aka Birdman, wanted to sign Bloody J, but Jeffrey Williams didn't want Birdman to sign Bloody J because of the feud that they had between each other, and he was blocking Birdman from signing Bloody J. So that's the background. But the bottom line is Mr. Copeland saying they said that Birdman wanted to sign Bloody J. There's absolutely no indication. My understanding is that Mr. Brian Williams is a multi-millionaire who runs a big record label. There's absolutely no indication that Brian Williams is running his ideas of who's going to sign and not to Ken Copeland. And Ken Copeland's just kind of, and he says it. He says they say this, they say that. And so that's all hearsay from our perspective. It's all speculation. It's not based on understanding. And Brian Williams is on the state's witness list. So if they want to call Brian Williams and ask him about what his plans were to sign Bloody J, but Mr. Jeffrey Williams allegedly stopped it, they can certainly ask Brian Williams.
And Your Honor, the state has no objection to page 43, starting at line 4 through page 44, line 8. The only portion that the state wants in is page 42, line 3 to page 43, line 2. Mr. Copeland, it's either in this interview or one of the other interviews, talks about how he actually brought back, or he tried to get Bloody J and Mr. Williams to kind of at some point start working together again. So he has some familiarity, we believe, with the relationship between Mr. Williams and Mr. Ussery. So when he's on page 42, when investigator Dennis asked, so what happened with Buddy J? Weren't they cool? He explains his understanding of when they may have started to fall out. This transcript is not the best, but some of what I believe is in this transcript, if you go to line 12, when you said you was trying to hook them back up, what happened? Like, did they fall out? Was it a beef or something? His response, I think they did because Bloody J joined they gang. Whose gang? If gang is what it actually says.
That's not saying game.
No, it says,
It's gang, G-A-N-G.
and it's saying if gang, I-F gang. He says, and I guess he was down with YSL, and I'm at line 23, and then it says, you know what I'm saying? So he joined them. And so that's his understanding of where their beef started at some point between Bloody J and Mr. Williams. And this is corroborated, Your Honor, because we have video evidence that at least back in 2012, Mr. Williams and Mr. Ussery, they're releasing music videos together. At the time, it looks like it's a ABG or Atlanta Blood Gang music video, but they are friends. And we know that the friendship dissolved sometime after 2012, which will corroborate or lean into what Mr. Copeland knows about their relationship. So we that's the only portion we wanted in, which was page 42, line 2, up to page 43, line 1.
And so I understand the objection to that being this, for all we know, is hearsay about why they fell out.
I think it's the way that he speaks, and if you watch it, it doesn't seem like he's saying they, like this is something they told him, because he says, when you said you was trying to hook them back up, what happened? Because he was trying to bring them back together. So it seems the state understands that he has personal knowledge of how the relationship dissolved, not something that he overheard or, but something that he's.
Why don't we just maybe find that out?
Yes.
Additionally, Mr. Copeland, outside the jury's presence.
She wants foundation.
Has personal knowledge of it.
She needs to mic the judge. And thank you so much for the love. I don't want to cut them off. I'm going to get to you.
In disputes, Your Honor, is page 203. Excuse me. I need to find out from Mr. Shard if he looked at what we discussed of 80804 all the way through 81150.
Can I back up on one? My notes may be wrong. Did you agree to number 5? 750 to 750?
Yes, we're not going to contest that.
Okay, so the state agreed to keep something out that the defense wanted
So
out.
where are we now?
80804
And
to
those are
8.
the timestamps.
So roughly page 178.
This is a big one, Judge. We agree from 80804 to 809.
Right, and I don't have the
So-
timestamps, so.
Page 178, line 7 to page 180, line 8.
And the state wants to go beyond that. And what happens after 180, line 8 is very interesting. This is January 28, 2015, that this court was speaking. He spoke on January 11th, 2015, speaks on January 28, 2015. February 20th and 21st, 2015. And then on June 10th, 2015, is the first time he says that my client and other individuals are responsible for Donovan Thomas's murder. In this segment right here that the state's wishing to redact, they ask him about who he thinks or who's responsible for Donovan Thomas's murder. And he says, well, what my understanding is, or what I've heard, now mind you, his stance on June 10th is he knew that my client and others committed this murder that night. So he was in knowledge of it that night. On January 28, 2015, they're asking him, who's responsible for Donovan Thomas's murder? And he says, well, I believe, or I heard, and I'm not asking him to admit for the truth of the matter asserted, I'm asking to show that his story's changed and he didn't say it initially. He said, well, I heard that Kelvin Watts had robbed someone and then Donovan Thomas was murdered as a result of that. And I believe, I'm not going directly off the transcript, but he puts forth different theories on what happened to Donovan Thomas. And our stance is that's important for the defense because if he was a truthful person who was telling the truth, he would have said that then. Now, the other interesting thing is on all these other dates that he's given these statements, he's not facing arrest. It's not until he's facing arrest that he points his finger at my client and others. So to us, that's a very important fact. And it's not being offered for the truth of the matter asserted. It's being offered to show that what Mr. Copeland has said at different times, when common sense would dictate if he's being a truthful person, he would have said what the state's saying the truth is.
All right, are you sure this is 178, line 7 through 180, line 8? Because I don't see this being about any of.
So that's the part we agreed on. And then they want to go beyond that. And starting at 180, about 180 line 8. And we want to keep it in.
So 180 line 8 through what the state wants out.
Until 186, line 2.
Somebody just fall in the courtroom? And shout out to Army Nurse. I'm going to call you 15,001. That's awesome that you noticed what number you were. And thank you so much for your super chat. Then here, John Coleman, you've been a member for a month. That's how long the jury's been out. They're approaching 2 months. I think that's when you started, you came over to this channel. And then you gifted 5, so thank you so much for that. You guys, shout out John with no H, just Jon in the chat. I'm waiting for them to... We don't have an official transcript yet. So Don Allen 80. We don't have an official transcript yet of the June 7th. At least I didn't see it filed. We just have that rough copy that was attached as an affidavit on Doug Weinstein's supplement to his motion for a mistrial. And if not, do you think it's strange or suspicious to have taken this long, given how long ago the ex parte meeting took place? I don't know, because she had the rough ready, and she's still trying to transcribe other things that they're asking for. I think she probably has a huge workload on her personally. And she's probably transcribing Glanville's ongoing cases every day, busy 9 to 5. So I don't know if I think it's unusual. But I do know that I haven't seen an official version yet. But thank you for your 1999.
Could you just want to stop?
On page 186, line 1.
And the transcript doesn't really.
We can listen to it.
Are they going to play it finally? We get some action. And then Nick Starro. I now know what Swedish krona are. I know what the currency is because of Nick Starro. So thank you for the Swedish krona. I remember when you hovered around a few hundred views per stream and then you blew through the roof. So happy for you. Appreciate you, Nick. Now y'all need to go to my panel show at 6 p.m. Eastern and subscribe to me. And that's true. And I'm going to link that, but this is also going to redirect over here when court's over to his panel stream.
Because it's a lot of rumors, this is actually not him testifying from personal knowledge. When he first starts on page 180.
I would concede it's not personal. I would concede that's not personal knowledge.
So think that they can cross-examine him on whether or not, why didn't he tell the police early on, but all of his speculation about what the rumors are is that's putting in information in front of the jury that's based on speculation and rumors. If they want to cross him and say, on January 28th, you didn't disclose that any of these people did it, I think that's fair for cross-examination, but to actually introduce this statement of him speculating as to what may or may not have happened on the night of the murder, it's just that, it's rumors and speculation.
There's a fundamental difference between not coming forward with information and being asked about something and coming forward with other information.
Maybe I need to listen to it because I'm really sick in this transcript at least. Except for on page, the very end of 184 and beginning of 185, maybe? And I'm not even sure if that seems to be the only thing they're talking about, that getting killed.
The beginning part of what they want out, and so there's after the part with our agreement, they talk a little bit about an incident where Kelvin Watts shows up at Lucci's mother's house after it's been shot up with a gun.
Yeah.
That is a separate, so I don't want the court to be confused. That is not the nut,
Right.
the Donovan Thomas murder.
Okay, so do you want that part here?
I do want it in. If you ask me why it should be in, I want it in. But the reality is, I don't believe that Mr. Came to the court. I don't believe that Mr. Copeland has firsthand knowledge of that, and that doesn't really fall under my argument about the Donovan Thomas.
Or then you agree that we don't have to talk about that part, so point me to the part where we actually, that you, the defense for Mr. Stillwell, want in and think appropriately can come in under the.
I think, respectfully, I think we need to just play it because I can't, the transcript is so long.
Okay, yeah, no, I mean, I think so too, but.
So we finally get to watch and hear the statement.
All right, so can somebody?
Yes, so I'm gonna start around, I heard you were at 8:08:30, which should reasonably be somewhere on page 179, probably around line 7.
What she was, she can come out and then this like Rich on the corner thoroughhead show. And I was there. And Rich on the corner came, but Rich on the corner tried to play both sides. So he like the kind of like. Yeah, so he just like bro, man, I'm tell you how serious it is, bro. Kill try to kill anybody, bro. He told me to call Max and tell her, trick her down here so he can kill her. Just to get back into it. Yeah, he said like he wanna kill somebody that way gonna hurt. What the hell? Do what he's saying. Rich on the corner, you born out of jail. Lucci wasn't gonna pay his bond. They said he mad at Lucci because Lucci ain't paid his bond. Why? Why Lucci ain't paid his bond? But what don't make sense, let's say, okay, what word did we get, right? Somebody said that Kel was called over there to the house after he got shot up. So at Lucci Mama house? Yes. All we heard was Lucci Mama house got shot up. Kel pulled up with the guns. Then we come to the tree. Kel pulled up with the guns in the car. And police walked up, searched the car, found the gun, locked him up. But why
Why was he there? Who brought him there?
I don't know.
Lucci Mama house. Tell, come. Who brought him to Lucci Mama house? Like, how did he know he got shot up?
Like, do you just hang out in the driveway? I don't know. They probably, you know.
So if that's the case, and then he got locked up, why did Lucci want to pay his bond? You know what I'm saying? If I basically
called you and said, yo, my house got shot my town.
Check on.
And then the red Camaro Lucci got, the same color they ran around, they shot my girl mama house up. They Lucci color. You know what I'm saying? But I ain't get it. You know what I'm saying? They got my name on so much stuff. Like people that come and tell us, they tell us a little bit, then they start talking about it's me. You know what I'm saying? Like my girl, she get a lot of information from her friends. She got a lot of friends, so they get around with me.
Rumors.
Lucci and I was talking in the studio, and it was a girl in there. They missed one of them, and she my girlfriend. And she said that they nobody do that. Nothing. You know what I'm saying? They all like Kill and K robbed somebody. You know what I'm saying?
Kill and who?
K.
Who's K?
I sent you a picture of that too. Then I think I sent it to those details. They had chop on in the picture. Oh yeah. And the them was in the car. Yeah, them two robbed somebody, and they supposed to came back. They was talking about the studio. You know what I'm saying? They just put my name on it, covered it up. Make it seem like they ain't got beef in the streets, whatever. Yeah. So, and then they like, she be like, they know what they ain't do it. You know what I'm saying? But they gonna keep playing on him. And she be like, K, when the nigga got killed, K first one called everybody like, we killed Nut. Tell the mom there what did. He the first one started my name. And they like, Kill went along with it. So they just robbed somebody, then they did. Like, Nut died, then they started. That same day? I don't know when. They just robbed somebody. And niggas supposed to be coming back for them. You know what I'm saying? Like, Kill robbed Fly. He robbed one of them. Like, and then, like, they would have somebody broke in that car. And gave me the phone. And the jury.
Stopping at 8:11:50. So, Your Honor, and look at a lot of it is these just rumors about what he's hearing about what happened leading up to the murder.
I don't even know if they're rumors that he heard. He might be completely making it up and never even heard a rumor, but that's besides the point. They're asking what happened, how did Nut get killed, and he proffers a theory or a story that Kel and Kay robbed someone, and then those people came back and killed Nut. And that is, and the relevance of that is it's not for the truth of the matter asserted. I don't think anyone in this courtroom, at least on this side of the room, is going to get up in closing and argue that the real killers of Donovan Thomas were, I'm hearing the name Nick, and maybe I'm following the story correctly or not, that Nick, after being robbed by Kel and Kay, came back for revenge and killed Donovan Thomas. We're not arguing that that's true. What we're saying is simply that, according to the state's theory, Mr. Copeland had inside information on January 10th, 2015, and about our clients committing a crime, and then he's asked about it on January 28th, and not only does he not, it's one thing not to mention our clients, which is important, but it's a whole nother thing to put a different theory out there. And so we think that's very relevant, and that goes to his credibility. And I understand he's arguing to everyone that he has no credibility, but the state is arguing that there is credibility with his June 10th, 2015 statement, and we're saying there's no credibility to that either.
No, that's not saying, right. I don't think the two are not mutually exclusive. He can know the truth, the proper rumors, but what those rumors are is they're not competent evidence. Like what he's saying, they can cross him without this coming in about the fact that he told the rumors. You told the police rumors in January. What those rumors are is not competent evidence because it's all speculation, it's all rumors. But they can clearly ask him that on the stand without going into.
All right, and I assume that the only reason June 10th comes in anyway is because he takes the stand and says, I don't know anything about anything, I don't remember.
Right.
And so June 10th comes in as a prior inconsistent statement.
Yes, Your Honor. Because prior to everything, his response is everything in June 10th, again, the whole finessing, and then he's now changing the version of facts as to what happened back in January 2015. He's now changed some of those facts. I don't
These
know what he will do
captions.
when he comes back, but that's what he can do.
So the defense, if the state can stand up and go, all right, here's your prior inconsistent statement where you said X, Y, and Z, which was all these people over here on this side were in kill fight, then they want to be able to say, well, look, in January you said something different. Explain that. Why shouldn't they get to do that?
I think they could ask him about, in January, you said it was all rumors. You said that. You said that there were rumors. What those rumors are, I don't think it's relevant. They can definitely ask him. Now, whether or not he says, I never gave anyone a rumor, then maybe that might open the door for something else. But for the state to play it initially, if we even get to play the statement, all these rumors coming in, I think there would have to be some foundation about the substance of the rumors if they come in. But they can ask him simply on the stand, you told rumors, and if he says yes, then that's it. What the rumors are will be irrelevant.
Yeah, they can hammer him on the stand.
I've been doing this long enough to know that one of the things that makes stories ring true sometimes is the inclusion of detail. No, it'd be one thing if he just said, John, I heard John killed Donovan Thomas, but he didn't do that. In this story he gave, he gives details. He gives a story, a coherent story, and that matters. It's not just that he gave rumors; he gave a coherent, detailed theory. And the state, I'm sure, at some point is going to argue to this jury that, oh, well, he was telling the truth on June 10th because look at the details he gave. How would he ever come up with this story that it was these specific 4 gentlemen in the car? How would he ever, and we're seeing on January 28th, he is giving a detailed story with individuals and a motive and all the rest. And so I don't think that it does. I think something is lost if we were limited to just say, oh, well, you talked about rumors on January 28th. That really doesn't do it justice. We should be able to get into exactly what he said. And again, we're not going to argue that that's the truth. We're just going to argue that it's Mr. Copeland's ability to think on the fly and come up with detailed stories. And when he was given an opportunity to to explain what happened, he came with a detailed story that had nothing to do with our clients. We think that's fair game.
Well, I mean, you can certainly ask him about it. You can ask him in as much detail as possible as you want to. And I think it's going to depend what he says then.
Oh, well,
Whether.
Well, okay.
Oh, me? Yeah, sorry.
So maybe if you're saying, I'm not presuming that he's going to deny saying this. So yes, if we ask him on the stand and on cross-examination, leading questions, and he confirms that on January 28th, he told about,
This
all that
story
stuff,
about,
then
right.
I can see that we wouldn't
That's it.
necessarily
Yeah.
get the play.
Okay.
But I think, as I understand it, the state's saying that we don't even get to go there.
Oh, no, they're not saying that. You agree they can cross him as much as they want to on, hey, this was your theory or rumor or whatever that you told the police on January 28th. They can ask him about that, right? I mean, you agree to that.
He can say, this is what I told the police?
Can they say, do you have a dispute with them being able to cross Mr. Copeland and say, well, on January 28th, when you were talking to the police, you told them that you heard from the street that Kay and whomever robbed so-and-so, and it was those people that then killed Nutt.
Can they use inconsistent statements like you can, is the question.
So the state's concern is, even in the interview, he doesn't say it as fact. He doesn't say, this is what happened.
Well, sure.
He said, this is what I heard.
Yeah.
So to me, it's still speculative as to what he heard on the shoot. What
Everything else is what he heard.
To me, is still speculation. I think an inquiry could be, you didn't tell them on January 28th that Shannon, Stillwell, these people, did. You only proffered rumors, not the.
But they can, so you think they can ask, you told rumors, but they can't ask, what is the rumor you told them?
Correct.
All right, that is not correct. You can in fact ask them about the detail of the rumor that he told them.
-2 for the state.
I mean, obviously he is clearly saying this is a rumor I heard on the street. And I know your point's gonna be, well, that's an awfully detailed rumor. And you could argue that later. But yes, you can get into the detail of, didn't you tell them you heard X and Y and Z? And then if he says, yeah, I lied about that too, then that's the end of it. If he says, no, man, I never said a thing like that in my life, then we may be able to actually play that part.
Oops.
That's fine. We still believe that the rumor speculation, but we understand.
No, it is. I mean, he says it is. He says, this is what my girlfriend told me she heard from somebody else. It's clearly a rumor.
That's the same as
That is not
Darlington
their
telling
point.
you
Their
something.
point
So
is, you, at some earlier point, are telling the police some theory, albeit rumor, albeit street talk, that is some details. And I think they're going to argue whatever they're going to argue, but they can get into the substance of what that rumor is. They can't mislead that this is what you said as fact. It has to be still, this was the rumor you told them, but they can get into the detail. Mr. Steele.
Right, I think what you just said is what I wanted to ensure.
Yes. Okay.
I think we're good. And Your Honor,
He's just saying I'm standing up because I wanted to make sure that you already just explained what I was going to ask about.
But the one position is, you may know this, but Mr. Copeland didn't say, like, I never said anything. What he actually said was,
I said all of I don't remember exactly what I said, but everything I said was a lie, right?
exactly.
Yeah.
Because the police were making me the number one target. They told me I'm the subject of this
Yeah.
murder. And I wanted to push everything I could away from me and onto others.
Mm-hmm.
So that's why it's very important to show that he's just coming up with, Mr. Lamar is Rich Homie Kwan. He put a hit on another person to kill them. Ask Mr. Copeland. He has 17 people that he says put hits on other people.
Okay.
That's outside of people here.
Okay.
But what you said is exactly right. It doesn't matter. I'm not using it for truth. I'm using it for exactly what he's saying. That's what I was doing.
Okay.
And at trial, he said, and that's what I did for the people here on trial.
Okay.
Thank you.
All right. What's our next portion of this transcript at issue?
The next.
So
or
it's in.
statement.
Yes, the next part that's at issue potentially is page 203. line 11 through page 206, line 17.
Okay.
And more specifically, page 206, line 15.
She'd already let it in. So Steele is making a record, but she already ruled in the defense's favor. But that might also be true. But there, I think she was just trying to move on.
Mr. Shaw, are you okay with 821:31 through 8?
It really is a big win for the defense.
So that's 206, 15, and 17. Okay, so
Yeah, that's going to be page 203, line 1 through 16.
Your Honor, could I just inconvenience the court and ask that 15 seconds or whatever that is potentially in dispute be played? Because I don't think I have an objection, but
Okay.
I can't really tell from this.
Okay.
If I can just hear it.
Sure.
And Your Honor, I'll play with 821:31 to the whole section.
Okay.
And thank you, Moses. When the court stream is over, we're going to pull up a picture of Cat Not Williams. Cute, cute cat. We're going to see Cat Not Williams. The other Cat Not Williams. And Missy Elliott in the chat.
It's not one time me and D not together. Me and D together don't matter what. Just like DB. We was together. You know what I'm saying? We not doing that. Who killed DB? They don't even, man. They don't even. Y'all know. Fred. They don't even, man. They don't even.
I think you started right after
The portion.
yeah.
Man, besides Shannon and D, you ain't gonna see me hang with nobody. So is it a person that they want you? No, that's what I said. How the hell I be leaving y'all to turn everybody out to me? Like, it's not one man. It's not one time.
I'm fine. The state wanted to play that, and I don't have any problem.
Okay.
So right after that, we're in agreement from, I believe, 821:37 to 822:52, where the murder of a gentleman by the name of DB is discussed. I believe we agree that is coming out.
Okay.
And then if Ms. Hilton could just play the 7 seconds that on the other end of that she wants to include, I just want to make sure.
All right. So this is going to be somewhere on 206.
Yes.
Okay.
Somewhere, or starting at line 5 or line 6.
Okay.
It's gonna start a little early at 8:22:02.
Okay.
He did kill me. He's tough. I know, but just like you said, somebody that might put him on the team. That's all we can prove. Say, just like the little nigga, Lil Haiti. When he just got out of jail, he see me in the club. He walked right up on me. I'm murdering me. Yeah. Who? Little nigga, Lil Haiti. You know, who's supposed to have something to do with DB. Oh, okay. But then he walked up on me, well, nigga, who the hell is you? Yeah. I ain't know him. Yeah. What's up? Best friend, what's up? Why you looking at me like that? Yeah. And me by himself, like, I know my little brother, hey, he just got I like he booked like, man, shit up, nigga. What's up?
Hey, look, hey, you the one that got shot in the face?
Yeah,
On Boulevard, right?
yeah.
He out too?
They him. Like, I don't know.
So they-
Some corner got a video on his page. How they walking in the house. Same night they shot my grandmama's house. I know just all the nigga they did. You know what I'm saying? They pulled up into a house in 3 cars.
So you mean, after this, so it's Rich Homie and Thug beefing?
No. How is that not possible though? That's what I try to say. I feel like
He playing both sides.
I feel like everybody like I feel like when he needs. I feel like they came together and made an agreement to kill me and everything go away. I feel like it, but I'm not gonna run.
We're past it, and your honor, that portion we can keep out.
All right, so what is the portion that is at issue?
No, nothing there, now that.
All righty, I'm glad we all did that.
In 2259 is where we're gonna go back live on the state. It's political.
So the full redaction, 82137 through 82259. Sorry, the full redaction will be 82137 through 82259. And that's gonna be page 203, line 19 through page 206, line 17.
Okay.
We have a series of agreements, Your Honor, and I think there's only one more that we disagree. Is that correct? And it's all in apartments.
Okay. So where's that one?
Page 269, line 19 through page 270, line 14.
All right, and is this the part that the state wants in, defense wants out, or the other way around?
Right, if I can do one more time, this might not be.
We both agree that a certain part of this comes out. There's a portion of it where Mr. Copeland somehow talks about a rumor that Donovan Thomas in his dying breath said that Thug was responsible.
Okay.
A, that's not true, but B, that's hearsay. People that were next to Donovan Thomas said that's not true. So, but it's hearsay nonetheless. But I believe that the state wants to not take out a certain segment of this. And that was our disagreement.
We are fine taking out that part.
That part being,
Sorry, what Mr. Shar just mentioned that Thug did.
okay.
That part we will keep out. We didn't know if the defense has other objections to, and I'm sorry, Your Honor, we're on page 270, line 7. It actually says, he said Thug ass has something to do with it. It's unintelligible, but that is the line that we're referencing.
Okay, so y'all are by agreement taking that out.
So, but I guess at the bottom of 269, we have it written down as 269, 19, 270, 14. Is that correct?
That's what I wrote down, but what y'all might have an objection to, I don't know.
Well,
So (269:19 through 23), where he's saying some detail about what he heard about Nut getting shot. Is there any dispute about whether that is in or out? I mean, I don't know, y'all.
I agree that that is out. My understanding was the state viewed that those timestamps were, too large and that something within that time period can get in, but
Okay.
maybe not.
All right, Ms. Hilton, was that something y'all intend to put in?
Initially, yes, the coroner
How about now?
will not put it
All right, so then 269, line 19, all the way through 270, line 9 is, I'm sorry, 9 or 14 is out by agreement? Which one was it? The end, 9 or 14? No. Okay,
in. So, page 270, line 9.
line 9. Okay. Yeah. She is out by agreement. All right. So was that the last thing?
Yes.
Okay.
And Your Honor, our agreements for redactions, I guess they'll just, when we email them, they'll be made part of the record that way.
When you email them to whom? What I'd like y'all to do, I mean, for this, we actually, anything we didn't discuss that y'all have an agreement as to, like all of Mr. Adams' stuff, just make a little list and say, the state and the defense agree that XYZ is out. Okay?
Here, I already compiled it from the first time.
Super, just get together with your colleagues on the other side and make sure they agree and.
She's like,
get it filed.
please.
Okay, so that's that statement. That's the January 28th statement is taken care of.
Sheesh. A lot of this is becoming just, I think they're having trouble keeping up with the numbers and where they're aligning and what they're
January
talking about.
11th And February 20th. Figure out the couple of little things that might be in dispute and then bring those to me. And I doubt if y'all got a chance to do that already. So it seems like then the next statement is June 10th, right?
You wouldn't do that, that's what we did this morning.
That was,
You started with June 10.
We'll go in reverse.
You went over.
oh, right, okay, you're right. So if we done,
We've done all the 3 that we can do.
and, okay, and then the other 2, y'all are just gonna
Hilton's ready to go
figure
home.
out what the small little differences are. Okay, so then I think the next thing we have to sort out is with regard to the testimony of Mr. Copeland that occurred post recusal motion.
Logistics.
I don't know how many days of transcript of that y'all have yet. I think you have at least 2 or 3 days worth of that, but maybe not all of it from Ms. Weaver, Judge Glanville's court reporter. Some directly from her, some through Ms. Firstfield. Because, right? Have y'all discussed that at all yet?
So Mr. Shard and I discussed briefly that the defense needed to talk amongst themselves.
Okay.
And then they were going to come.
All right. Okay, so over the weekend, y'all figure out both amongst yourselves and then between the defense and the state, if there is anything, and if there is, what, of Mr. Copeland's post recusal motion testimony, there might be some agreement to. And then also, if y'all can think and propose to me on Monday, whatever y'all think might be appropriate in terms of explaining to the jury if they're going to have to sort of rehear any part of Mr. Copeland's testimony. You know, just what we're going to tell them about that. Okay. And then after Mr. Copeland testifies, What's next? And how long do y'all anticipate that taking? Y'all have no idea, do you? Because who knows what he's gonna do.
Oh my God, is Love gonna talk?
That's true.
She's alive.
Does the court mean like which witnesses?
Yeah.
Okay, so I anticipate there will be two other form, potentially Mr. Sledge,
Mm-hmm.
Mr. Zachary.
Okay.
Those two.
This is what you gave me. That's basically an order, right? Okay. So then, Mr. Sledge and Mr. Zachary, are there anything about their evidence that we need to hash out? And I can't remember, what did I give you as your deadline to give us all the details?
What was the
about
deadline?
The evidence.
You said the exhibits was Wednesday, but then the witnesses was Monday, and
I thought the first 30 might have been Monday.
the first 30 yeah,
Okay.
Monday.
All right. Okay. So I honestly did not think we would, I am really glad that we did. Congratulations to everybody. Get through as much as we got through today. But given the last couple of days, I'm pleasantly surprised that we did. So I actually, at this point, told the jury, don't come before Wednesday, because I figured we had enough work to do Monday and Tuesday. And I think that probably is true. But yeah, with everything that you're, and if y'all get finished early, you don't have to wait till Monday morning. You can go ahead and email whatever you get finished with as you're finishing it. All right. So yeah, we can start working on all of that. All right. So
They're gonna wrap it
this is
up.
a good time to adjourn for the day, or do we have other things we want or need to take up right now?
There may be one more thing that we can
Okay.
take up if the court would allow us one more.
Your Honor, we do have the 5 jail calls that we intend to get in
Oh,
through Mr.
perfect. Yeah,
Copeland.
we can do that. Okay. And I've already listened to the portions of,
And there were portions that we did not object to, Your Honor, so I can go through by call which one we didn't object to.
so
Right,
you're
Glanville
working
would have
off
been
of,
out.
so I know that Mr. Shart had provided kind of June 19th-ish, his proposed redactions, right? Is that what you're working from to tell me which ones you agree to?
Yes, is
Okay.
that what Mr. Steele sent? No, for the jail calls, I'm looking at Wednesday, June 26th. There was an email that Mr. Steele sent.
I don't know that I have that.
Okay.
What I've got is it may be the same list. Oh, it may be. I don't know. What I have is whatever Judge Glanville had made a court's exhibit when y'all were talking about them. And it says forward Stillwell proposed redactions. Anyway, it's a list of like 10 proposed redactions. Is that the same thing when we get down to it, or?
No, I
Okay,
have,
well, give me what it is that I need to be looking at.
I can find it. and forward it.
Well, while that's going on, finally, thanks to Missy Elliott, I'm not going into law at all. Missy Elliott says, are you going into law? You break things down
You know
so
what?
well.
What I'm looking at right now is not even about the jail calls, so never mind. But I don't have what it is that you're talking about.
And would make a great lawyer. Congrats on the 15K. Thank you so much. You deserve it. By the way, I love your voice. Oh, that's so funny because I'm like, oh, my voice is so grating. Thank you so much, Missy Elliott. Sorry it took me like 3 tries to get to your super chat. Gene Lander says, all I can hear in my head is Snoop Dogg saying, I know some people that know some people that robbed some people. Right? It's like really like rumors and rumors. And the state only wants the rumors that work for them to come in. It's hypocritical. And the judge didn't buy it. The judge told them that they're wrong on that. So thank you so much, Gene Lander. Ms. Kim's customizations. What do you customize? Do you make like cups and stuff, like team sport things? Let us know. But for $4.99, thank you so much. Says, love is the elephant in the room. She finally spoke as the judge was about to wrap up. And then Miss AB, thanks so much for all the support today. So for $4.99, Miss AB says,
So
this
there
is a...
I just.
5 jail calls and there are portions of the 5, is that right?
Yes.
Okay. And then you have agreement as to certain portions of those? Okay.
Yes, so the
All
state's
right.
intention was to play the entirety of the calls, but
All right.
then there were some objections, and so we
Sure.
don't have any objections.
Okay.
We don't have objections.
All right, so do you want to put on the record what portions?
As, if the court has the email, I can go through the areas where there was objection and.
I don't have the email. I do have the email. I just don't know where to find the email.
+1 for the court clerk.
Okay.
And Miss AB, I don't think you're alone to not have known the beginning of the case. I think that's the same for a lot of people. And I tuned in, I listened, I had it, and sometimes I'd be working, so I didn't catch everything. But as a flaw for myself, I was usually listening. I didn't get to always see what was happening on the screen.
All right. I'm
So
now looking
I'm missing a
at
lot of
the
context
email.
too.
So go ahead.
So for the first call, which is on March 11th, 2015, there's an objection from 10 minutes and 45 seconds to the call to 10:50. And the state has no objection to not playing that portion of the call.
Okay.
From 15:15 to 15:32, the state has no objection to stopping, to not playing that portion of the call. For the June 10th call, from 7 minutes to 7 minutes and 3 seconds, we have no objection to not playing that portion.
Okay.
From 8 minutes to 8 minutes and 12 seconds, we don't have an objection. And from
Okay.
9 minutes and 57 seconds to 10:15, we do not have an objection.
Okay.
For the June 13th call, we do object to that portion of 2:55 to 3:10.
Okay.
June 14th, we have no objection from 13:51 to 13:58. No objection from 14:11 to 14:13. And then for the June 15th call, we have objections to 4:53 to 5:11.
As in y'all want that in?
Yes. you're
Okay.
right. 6:01 to 6:12, we object, we want that part in.
Right.
6:42 to 6:49, we want that in.
Okay.
But I don't know if someone told me this, but I wrote in 13:10 to 13:17. And we don't have an objection to that part. I'm not sure if maybe someone called me, but I wrote in another portion of that call, and we do not object to. Oh, that's on the email as well? Okay. I wrote it, I have it handwritten,
Okay.
so, because it's on the back side.
All right.
So we have no objection to 1310 to 1317.
Okay, great. All right, so then our issues are with June 13th, 255 to 310. And then June 15th, 453 to 511, 601 to 612, and 642 to 649. Is that correct?
Yes, Your Honor. And so we're pulling those two calls up now, Your Honor.
Okay.
You hit me left.
Yeah, and guys, I heard that with the court reporter saying something about the chat. And then Nurse Jenny for the $4.99. I want to join the members, but my iPad says I have to open a browser. I don't know why Apple doesn't play nice with things. You can change to allow mobile devices. Can I? Thank you for your super chat. I'm going to play in my settings to see if that's like a thing. There you go. Thanks for becoming a member.
Mr. Box is here and Mr. Steele is handling this portion. May I step out?
Sure.
Did he say he's about to step out?
This is a free call from.
And I'm gonna start, Your Honor, around 2:25.
He booked the Brian. Meet me on University. On University where? That gas station we always. You know what that gas station? Chevron. That's Chevron. Meet me at Chevron. Hey, man. Okay. Yeah. Look, D ain't right, bro. What did D do? I'm gonna say too much, bro. The D told. You talking about rock crew, Lil D? Yeah. I told him. He told on Roscoe too. You think I'm fucking playing, bro? He told on Roscoe. He told on Roscoe just cause he Roscoe ain't no fucking blood. And he don't give a fuck. Roscoe ain't free. Hey, D trying to come up and come meet you.
And that concludes at 3:11, Your Honor. And to give some context, on this call, this is a call from June 13, 2015, which is 3 days after that June 10th interview. Mr. Copeland is now in custody. He calls his girlfriend, Miss Quarterman.
I believe this is his
who then
ex.
calls the person who you hear is Max, but it's also Dolly White, also known as Dolly White, but is Mr. Williams' sister.
Mm-hmm.
She is a person that the state alleges a number of the gang members will call to get in contact with Mr. Williams or for her to facilitate a number of different things throughout the trial.
Mm-hmm.
And while on the phone, there's first talking about money to help with his bond. That's
Mhm.
when you hear her talking about meeting the girlfriend at the gas station.
Right.
Then he says, little D ain't right. At that point, they jump to, because he snitched, because he told on Roscoe, and they're talking about him not doing what a gang member is supposed to do, which is then snitching, Your Honor. So we believe that that is relevant information for this jury to hear, that the gang members are talking about the failure of another gang member to be supportive of the gang, to actually tell or snitch on another gang member. And that's what's contained in that portion of the call.
Okay.
And the objection,
Your Honor, it is not, I don't know, I've listened to these so many times, I don't know if it's fair to you, but he never said about, oh, this is what gang members should act like, this is inappropriate for a gang member to snitch on someone. That's not in there. What he said is, something to the effect, I'm not quoting it, hear what little D did.
yeah, and then she says, D ain't right, D done told, blah, blah, blah.
Yeah, so how does he know that? Who did he hear it from?
Well, I don't know that that matters because they're not offering it for the truth of whether D ain't right.
I don't know.
We are not offering whether D is or ain't right. It's the fact that literally it was, everything they said about him, and overtly the fact that a YSL member, they believe told if he did or didn't, and their anger towards it.
I just don't see it like that. I see this is after Mr. Copeland. This is after Mr. Copeland has cooperated with the authorities. He is in contact with Detective Gaither on a daily basis.
Yeah.
And he is speaking now as a government agent.
Do you have proof of that? I mean, that's not an issue in this trial. This is him on the phone with his people, still thinking nobody knows he's said a word.
Of course, no one knows it. That's why he's an agent. The government.
She shot up so quick.
He is being told on June 10th, you need to work with us, otherwise you are going to get severe time. And he says, great, I will work with you.
And this is 3 days
That's
later,
the
this call.
recording that you didn't listen to that part, but it's in this 9-hour recording. So I don't see how this comes in. It is hearsay that he is just saying, did you hear with this other person? We have no idea the context. And it is being asked for the truth of the matter because that's why they are talking about it. This is not, oh, it doesn't matter if it's true or not. He's specifically saying this man said something. I don't see how that comes in. You know, we could ask him about it, but I don't see how the jail call comes in. I think the state has to lay a predicate or a foundation before you can take it.
Well, I mean, I would assume they're going to have to lay some kind of foundation for some reason to get it in.
If they lay a foundation, then
And I don't know what that's going to be, but assuming, I mean, I don't know, maybe you want to elaborate, Ms. Hilton.
We believe this is also evidence of the overarching gang conspiracy. Again, we have to prove that this is a conspiracy, that this is in furtherance of that conspiracy around. We believe that one YSL member telling another YSL member that one YSL member snitching is in furtherance of protecting the conspiracy, protecting the gang, Your Honor. And this would be evidence of that. So essentially it would be a co-conspirator statement between these co-conspirators talking about gang activity.
Same reasoning as always.
I mean, I think if the proper foundation is laid, that comes in over a hearsay objection. Okay, and then, excuse me, June 15th, a couple of different portions.
Your Honor, it's course I would just start at 450 and play through 649 because it's only about 2 minutes for those 3 sections.
I'm still sitting on the phone.
And tell me who I'm about to hear.
Yes, Your Honor. And this is again Mr. Copeland calling his girlfriend on 3-way, but at this point he has asked his girlfriend to call Detective Gaither. And so the portions that you're hearing is Mr. Copeland and Detective Gaither on the phone.
Okay.
Got it.
I'm going to start at 447.
Like, I'm not gonna sit here and promise you like you're gonna get out of jail next week or in 2 weeks. All that, like I told you, you gave us a lot of good information, but we gotta still do our job. We're not just taking your word for the gospel just because it's coming from you. We still gotta investigate shit. So all of that will be taken into consideration at the end of the day.
So my brother,
like I said, do your brother know what?
that federal put the feds put charge him.
I'm not talking to nobody about your case, but to you and who you got on the phone. That's up to y'all. Like we don't do that.
I'm saying, so is they trying to work with me though? Is they gonna try to work something out?
I can't say what they gonna do. Like I said, everything that you told us, we want to speak with you again. All of that will be taken into consideration. That's what she told what the ATF agent when we first came in, lady.
Yeah.
That's what we do in the beginning. A lot of what you say will kind of determine your future. That's why you need to be completely honest with stuff.
Yeah.
So at the same time, we still got to look into it. We're not just going to take your word for everything you say. We got to be able to, prove what you say is true.
So if I prove it, then y'all let me have it right.
Are you hearing anything that I'm saying? Because I feel like I'm talking in circles.
Nah, I hear you, but it's confusing.
If you provide us with some things that we can verify, it's not up to us to let you out of jail. That's totally up to the DA's office, all that stuff on what they want to do with you. They do take into consideration if you helped or not. And so far, it appears as if you've helped, but we still have to do our job and investigate.
Yeah. So I still got state judge and the.
And I conclude at 6:53.
Okay. And so what is at issue? What statements specifically are at issue?
Detective Gaither's statements bolstering so far. You've helped.
Credibility.
We still have to corroborate, but so far this was helpful. I don't know what the right word is. And I believe that that's bolstering his statements.
All right, and what does the state say to that?
Sure. Yeah, we don't know what he's going to say on the stand. But if he goes down the same line of, I was just lying to finesse investigation, I made it all up. This is in complete contradiction to that because she's telling him, just like she told him in the interview, we have to verify what you're telling us. So if he was telling lies, he wouldn't continue to say the same things over again because she keeps telling him, everything you told us, we appreciate you telling us, but we have to verify everything that you said. So there's nothing I can do for you until.
Well, he's not really saying anything.
We want you to tell more.
Saying, hey, I told y'all something. Can you let me out now?
Right. And so when he's saying everything I said is a lie. So
he is now. Yeah.
He is now. So what this shows is a contradiction because he wouldn't be calling the detective trying to continuously see if he can get out of jail if what he said was a lie. Especially when she's telling him.
All right. The objection is that Detective Gaither's statements, well, yeah, I mean, you seem to have helped us, but whatever.
Redact the truthfulness part.
Why do you want any of this?
Well,
how do you envision using that particular thing I just heard?
So there's a few things. So part of this trial, some of the defenses that have come out is that the police didn't fully investigate anything.
Okay.
That they took his version and just ran with it.
Okay.
So this supports that that's not what happened. That even back in 20.
Is Detective Gaither going to testify?
She has
All
testified.
right. Has she said
Oh my God.
already? Man,
Oh
we
boy.
didn't just take his word for it. We investigated.
She testified
Yes.
to that.
Okay. So
we don't need it. It's
necessary for
cumulative.
that.
But again, I think it gives context to, while Mr. Seals focused on Detective Gaither, we're focusing on Kenneth's actions, that if he lied, he would not continue to call the police to verify how they're gonna help him when he knows, listening to Detective Gaither, every time she speaks to him, she says, we can't do anything yet until we verify what you told us. So clearly what you told the police isn't a lie. Even though you're saying that today in 2024, what you told them back in 2015, you believe to be true because you wouldn't keep calling if you just wanted to tell them
Unless
one
you were in
lie
jail
that
and you
was
wanted to
it.
get out.
You wouldn't keep calling the detective.
All right. So let me ask you this. If what you want that in, or those portions in for is Mr. Copeland's, hey, y'all, come on, I gave you the truth. Let me out now. Is there some way that you could redact that where we don't hear big chunks of Detective Gaither saying something she's already said on the stand anyway, which is I gotta verify this stuff? See what you can do, okay?
We can see what
Okay.
He didn't really address Steele's objection.
We'll see.
I don't know.
Judge, if I may,
Yes.
again, putting everything in context and thinking back to some of the testimony that Mr. Copeland had put forth previously. You know, the state's position that he just put to the court as well. If he wasn't telling the truth, why would he call and try to follow up and see if they were checking on his truth or not? When he testified, one of the things that he said, it was probably the biggest thing that he said is, hey, they don't know that I'm lying. And he said, yeah, I lied to them. I'm trying to finesse my way out of this, but they don't know that I'm lying. And that was in response to a specific question that Madam Prosecutor, Ms. Hilton, asked Mr. Copeland. So I think that kind of, that goes against what they're saying as their rationale.
I mean, don't get me wrong. I'm not sure that what they're saying it's going to come in for is going to in any way show or be a convincing argument, but I mean, they can,
Yeah,
it's not inadmissible for them to try it.
no, I understand. But I think our objection, as Mrs. Steele stated a little while ago, is, why is any of what the detectives bolstering of Mr.
I understand, which is why I told her if she can come up with a way to get her part in without the objectionable part, she needs to try to do that.
I'm confident
So-
that she can.
Let's have it. All right. Okay, so that is all of the jail statements.
Yes.
Okay, super. All right, one thing I wanted to do is do some test run of this, and this doesn't need to be on the record, where I just don't have it. I've never used these before. So how is it
Okay,
that
they're
y'all
gonna
are
test
doing
audio.
this? Do I hand these out to all of y'all and then? All right, I don't need to, oh, y'all have them, so.
We need to pay some.
Okay, and I mean, everybody doesn't have to do it. If a couple of people want to.
And then no weapon formed against me. Thanks for the 5. Can Woody plead the 5th again and not say anything else? Yeah. I'm sure they could try to hold him in contempt again. But he might be fine with contempt now.
Is there some significance to the red ones? Hey, is there some significance to the red ones? Does anybody know whether there's some significance to the 2 that are red?
I don't think you've ever used those.
Oh. All right, so. And does the court reporter get one so she can also hear what's going on, I would imagine? Okay. And then what?
There's a push to talk.
Sorry, y'all. Yes.
I have
We're done with court for the day, so you do not need to video me trying to figure out the technology.
All right, we are out. I wish I could show the super chat because it's really cute. So Tony, I don't know if you're in the chat, but I got a super chat from Tony with an I. This is thanks for making the work week fly by. Let's go off the record.
Hey, that's a brilliant idea, because they don't take pitch conferences. Sounds good to me. All right, but
Alrighty. And you never know, love can be late and say, I have one more thing. So we'll linger for a little bit with the screen up. But thank you so much to Tony, especially if you're still in the chat. That was really sweet of you. And also, Ralph Grimaldi says, thanks for the great content. So you are welcome, Ralph Grimaldi, if you are still in the chat. Are you related to the Grimaldis that make chocolate candies? Because we have a Grimaldi near us, really close to me, and they make chocolate-covered potato chips. They make chocolate-covered potato chips, and they're super, super good. And then I think this is going to be done, and then there's a new motion. I'm seeing new motion in the chat. All right, here we go, you guys. So thank you so much to Ralph and Tony for the Cash App love. And let's pull up this motion. So here is the link to the motion. Let me pull it up and get a giant screen and we'll read it. It's a renewed motion for fair and constitutional trial. So this will be good. This will be good. I do still have the Law and Crime feed open. I'm sure it's going to end. I don't think they'll interrupt, but just in case. But we got this in today at 4:06 p.m. That might be why he ran out of the room. So let's see, you guys. And don't forget, if you're heading out now because you just wanted to watch the evidentiary hearing, don't forget that there is going to be a panel show tonight on Nick Staro's channel. You know, Kayla's going to be there. I'm going to be there. Infamous Sylvia is going to be there. There's a bunch of names on that panel. So it'll be a good time. And I got to make my screen smaller because I can't see the document on my own screen. Let me make this bigger. There we go. So comes now Mr. Shannon Stillwell by and through undersigned counsel and hereby files this renewed motion for fair and constitutional trial in the above styled case. In support of this motion, Mr. Stillwell shows as follows. Mr. Stillwell is accused of multiple felonies, including conspiracy to violate the Georgia RICO law and, you know, this is the word that beats me up, you guys. I say substantive, but it's substantive, as U.S. English. Substantive felonies. Mr. Stillwell is an innocent man. Like all citizens, Mr. Stillwell is guaranteed a fair trial and due process by the federal and state constitutions, the Confrontation Clause, the Due Process Clause, and all other constitutional protections. The 6th and 14th Amendments of the United States Constitution guarantee criminal defendants the right to a fair trial in front of a fair and impartial judge. That's Poole v. State. The Due Process Clause guarantees a defendant a trial free of prosecutorial misconduct. Whitmore v. State. Mr. Stillwell and his co-defendants have been in trial for approximately 19 months. Approximately 75 witnesses have testified so far. Mr. Stillwell has remained in jail for the duration of this trial. Judge Earl Glanville was the original trial judge in this case. Judge Glanville was recused from this case via an order signed by the Honorable Judge Krause on July 15, 2024. Mr. Stillwell's rights. The state is seeking a life without parole sentence for Mr. Stillwell if he is wrongly convicted. Mr. Stillwell demands that his trial be conducted in a fair and constitutional manner. Prosecutorial misconduct implicates a criminal defendant's due process rights when it renders a trial unfair and violates the defendant's right to a fair trial. Whitmore v. State, 2005. Due process also requires that Mr. Stillwell receive a fair trial in front of a fair tribunal. That's Poole v. State, Serdula v. State. Judicial integrity is a state interest of the highest order because the power and prerogative of a court is to resolve disputes, rest upon the respect accorded by citizens to a court's judgments, which in turn depend on the issuing court's absolute probity. And that's Mayor and Alderman of Savannah versus Batson and Cook. To the extent this trial has failed to meet these constitutional requirements in the past, Mr. Stillwell demands that this court take appropriate actions. While Mr. Stillwell is confident that the court will endeavor to ensure him a fair trial moving forward from the current trial judge, this does not cure, this is important, this does not cure the constitutional errors and the resulting harm to Mr. Stillwell, which has already occurred. Readily apparent examples of error, impropriety, prosecutorial misconduct, and judicial partiality. This case has been plagued by discovery violations, lost and missing police reports, and Brady violations. As detailed in depth in Co-Defendant Williams' July 10th motion for a fair trial, the prosecutors of this case have repeatedly failed to follow the orders of the court, have made specious allegations against defense counsel, and have lacked candor to the court. Hey, we have that on the record. We have Judge Whitaker acknowledging as much. So, this case, we got a little reference there. This case has been plagued by improper rulings, including but not limited to an overly liberal and unconstitutional application of OCGA 801D2E. Defense counsel has routinely been cut off by the prior trial judge when arguing these matters, and rulings have been made with little or no analysis. This case has also been exceptional in the mistreatment, that's in the transcript, in the document, of defendants and defense counsel. Examples include, but are not limited to, A, an incident which occurred on or about October 2nd, 2023, when Judge Glanville initiated a contempt hearing against undersigned counsel, Max Shart, attorney for Mr. Stillwell. Footnote here says that counsel is solely concerned with his client, Mr. Stillwell, and not himself. Nonetheless, the treatment of defense counsel in this case is evidence of Judge Glanville's lack of impartiality throughout this case, which violates Mr. Stillwell's constitutional rights. On this date, Judge Glanville sent deputies to find undersigned counsel during the court's lunch break and summoned undersigned counsel to chambers. A courtroom deputy informed undersigned counsel that Judge Glanville was expecting an apology from counsel for calling him some bullshit. We have a footnote here in open court. So this footnote says, as defense counsel never uttered these words, undersigned counsel is relying on his memory as to what specifically the specific alleged uttered words were. The press was not filming that day, and the transcript was not available to counsel at this time. While in chambers, undersigned counsel was advised that he should not deny the accusations, as it was all captured on video. Footnote 3 says, obviously, this was not an effective interrogation technique, as undersigned counsel knew that he did not commit said act and would not be shown on courtroom video doing so. When undersigned counsel refused to apologize for something he did not do, Judge Glanville tersely instructed counsel to leave his chambers. Later in the day, Judge Glanville initiated a contempt hearing against undersigned counsel. Judge Glanville berated counsel and threatened incarceration. Judge Glanville accused undersigned counsel of violating bar rules and putting his law license in jeopardy for lying to the tribunal and not confessing his sins. Footnote 4 says, the reality is that the court was demanding that undersigned counsel lie to the tribunal by falsely confessing to something he did not do. Okay. Tell him, Stu. Shard. In the end, the attorney David Botts, who was seated within feet of undersigned counsel at the time, spoke up and stated that undersigned counsel never made such a statement. Of course, the video that, quote, captured the event was never produced and no apology was made. B. Judge Glanville has repeatedly demanded that certain defense counsels, including but not limited to undersigned counsel, attorney Brian Steele, and attorney Carrington Matthews, to sit down in a terse and abrupt manner when overruling valid objections, all in front of the jury. These incidents have been too numerous to document individually. C. Judge Glanville has sustained specious and frivolous vagueness and facts not in evidence arguments from the state that has effectively cut off the defense's ability to conduct a thorough and sifting cross-examination. Just one example of this can be found by viewing undersigned counsel's attempts to effectively cross-examine Investigator Tyrone Dennis. So Investigator Dennis. D. Judge Glanville, on 2 different occasions, baselessly called attorney Brian Steele unprofessional and unprepared in front of the sitting jury. When it was shown that Judge Glanville's comments were completely off base, Judge Glanville refused a defense request to issue an instruction that the jurors should disregard his comments about attorney Steele. Judge Glanville has monitored the movements of defense counsel, including undersigned counsel, throughout the courthouse, and we heard this. Glanville made a judicial record of this when he talked about Kayla Bumpus in the hallway. Monitoring, tracking, we see that tracking language used in the June 7th transcript. If you haven't seen that, we did a read-through of it. I clipped it, and it's separate on a video in the channel. But this point E, Judge Glanville has monitored. He stated this in that transcript. He's monitored the movements of defense counsel, including undersigned counsel, throughout the courthouse through security cameras for no permissible purpose and without cause. F. The state has repeatedly demanded reciprocal discovery from the defense without any legal basis and has repeatedly misstated the law covering reciprocal discovery. Something that we saw Judge Whitaker kind of schooled the defense on Wednesday. I think it was Wednesday. All to obtain an unfair advantage from Judge Glanville. Judig Glanville, we have a typo there. The state has gone so far as to contact non-attorney members of the defense team and demand that they provide certain items to the state, without consulting defense counsel first. These actions were taken without any legal basis and were an attempt to unconstitutionally invade the attorney-client privilege and the duty of confidentiality of the defense. Yeah. The state intentionally and erroneously accused Attorney Steele of tampering with and altering jail calls made by Kenneth Copeland, which were served in reciprocal discovery. Of course, these heavy accusations were entirely false and without merit. There were no consequences for making these wild, false claims. On June 10th, 2024, this is a separate point. On June 10th, Judge Glanville held an illegal contempt hearing against Attorney Brian Steele. Judge Glanville briefly incarcerated Mr. Steele and attempted to sentence him to 20 days in jail. Judge Glanville deprived Attorney Steele of due process and the assistance of counsel. The defense, after repeated requests, has finally been provided with the state's June 7th, 2024, here we go, ex parte motion for order to compel testimony necessary to the public interest. This motion, submitted by elected District Attorney Fonnie Willis and Chief Deputy District Attorney Adrian Love, contains, upon information and belief, a glaring misrepresentation. In paragraph 11 of this motion, so if we get to see this, we're going to look at paragraph 11. Is it attached? We'll see. The state asserts that after an encounter with the defense team members, Copeland informed representatives of the district attorney's office that he may attempt to plead the Fifth in order to avoid testifying against members of YSL. The motion does not provide any information regarding the specifics of this alleged encounter or which defense team members were allegedly involved. But we hear in that meeting, we're tracking in the courtroom, something seems off about Melnick, about Caleb Bumpus. Think about that, you guys. This is what Fonnie and Love tried to put in their order for this immunity. This is their reasoning. We've been saying we want to see it. Shard saw it, has a problem with it. Upon information and belief, after reaching out to defense counsels involved in this case, that information is completely false. Upon information and belief, no members of any defense team had any contact with Kenneth Copeland on or about June 6, 2024, so the Thursday. It goes without saying, upon information and belief, no defense counsel or members of any defense team ever interacted with Kenneth Copeland in any way that would dissuade him from testifying. This false and disparaging information about defense counsel was provided to Judge Glanville in an ex parte motion. So the defense only just got to hear about or look at this motion and hear about what's being alleged was in that motion this week. Because it was filed ex parte. The June 10th ex parte meeting. And we're going to cite the same thing we've seen a lot. Except as authorized by law or by rule. Judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. That's Rule 4.1. Ex parte hearings are only authorized in the case of extraordinary matters, such as restraining orders and temporary injunctions. In other judicial hearings, both parties should be notified of the hearing with an opportunity of any objection that may be properly registered. So City of Pendergrass v. Skelton, citing to Anderson v. Fulton National Bank, ex parte communications are presumed to have been in error. Additionally, the Georgia Code of Judicial Conduct Rule 2.9 instructs judges to generally avert ex parte communications to assure fair hearings. Rule 2.9 generally permits ex parte communications, subject to a narrow exception, for scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits, provided that A, the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication, and B, the judge makes provisions promptly to notify all other parties of the substance of the ex parte communication, and gives the parties an opportunity to respond. On June 10th, 2024, while the defendants and defense attorneys were all in the trial courtroom, waiting for trial to start, Judge Glanville, Love, and or Fulton County Deputy District Attorney Simone Hilton, as well as witness Kenneth Copeland and his attorney Caleb Bumpus, all met ex parte. Upon information and belief, this ex parte meeting was initiated by Love. Neither Copeland nor his attorney requested this meeting. In fact, neither Copeland nor Bumpus ever expressed any concerns which would have prompted anyone to consider such a meeting at all appropriate. When the state falsely characterizes this meeting as merely a discussion about Copeland's grant of immunity, the reality is that Copeland had already been granted derivative use immunity on June 7th, 2024. There was nothing else for the parties to discuss regarding the grant of immunity. Copeland never requested to meet with the prosecutors and the trial judge to discuss these matters. Additionally, the ex parte communications were about more than Copeland's previously granted immunity. Judge Glanville and the prosecutors discussed Copeland's proposed testimony and provided legal advice, albeit incorrect legal advice, and strategy to Copeland. Throughout this process, Judge Glanville was clearly working in concert with the state and abandoned any semblance of impartiality. Neither Judge Glanville nor the state revealed that these ex parte communications had occurred to the defendants or defense counsel, who were waiting for hours in the courtroom, completely oblivious to what was occurring behind closed doors. Judge Glanville's silence violated Georgia Code of Judicial Conduct 2.9A1B. The defense would likely not know of these communications and their substance if not for attorney Brian Steele, who learned of the meeting by happenstance and confronted the court, bringing sunlight to darkness. When attorney Brian Steele inquired about the secret June 10th meeting, Judge Glanville immediately sought to hold attorney Brian Steele in contempt of court. And that's kind of why so many eyes got on this case, you guys. Judge Glanville attempted to incarcerate attorney Steele for 20 days for refusing to reveal how he learned about these illegal ex parte communications. Judge Glanville had deputies take attorney Steele into custody and attempted to incarcerate attorney Steele without notice or legal counsel. As the existence of the ex parte meeting became known, Judge Glanville frustrated undersigned counsel's attempts to learn more about this meeting, including undersigned counsel's repeated requests for a transcript. Judge Glanville claimed that what occurred in the secret meeting in his chambers was privileged. This claim of privilege was without merit. Judge Glanville, it appears, instigated some sort of investigation into this incident. The focus of this investigation was not on the impropriety of the illegal meeting, but rather on how attorney Steele and other members of the defense learned about it. This investigation included Judge Glanville utilizing law enforcement resources to access courthouse cameras to track the movements. Tracking. He said in the transcript on June 7th, "I'm tracking. I've been tracking since the beginning." This investigation included Judge Glanville utilizing law enforcement resources to access courthouse cameras to track the movements of attorney Steele and undersigned counsel. Law enforcement is an arm of the state, of the prosecution. This is an example when you think of how the bodies are supposed to be distinct. This is the tribunal acting with the state. This is the court acting with the state if they're using law enforcement resources to look at this on their own accord. To track the movements of attorney Steele and undersigned counsel through the courthouse. And remember, Glanville put that on the record himself. He's saying that the deputy brought it to his attention. But he said in the June 7th hearing, "I'm tracking." As public pressure mounted, a transcript of the meeting was eventually provided to the defense. The transcript of the meeting speaks for itself and is shocking. The transcript reveals that A, neither Love, Hilton, or Glanville had a legitimate basis to engage in ex parte communications. B, the ex parte meeting was not requested by Copeland or his attorney. C, the prosecutors, specifically Love, misrepresented facts and made specious allegations against attorney John Melnick, undersigned counsel, and attorney Steele to Judge Glanville. The details of these misrepresentations are discussed more fully in motions filed by attorneys Shard, Steele, and Weinstein in motions filed on July 23rd. The prosecutors and Judge Glanville incorrectly advised Copeland about the law of derivative use immunity and applicable statute of limitations. Footnote says that the state claimed, and Judge Glanville ratified, that Copeland faces no legal jeopardy in this case by advising Copeland that the statute of limitations has run. It is unclear how the state and the trial judge came to this conclusion. First, this conclusion ignores the tolling provisions of the statute of limitations in Georgia. This is like counting time. Second, even for older incidents, their legal analysis interesting in light of the case. Their legal analysis is interesting. It's probably a typo. Their legal analysis is interesting in light of the case that they are currently prosecuting and would be interesting to the 6 defendants at trial. Those individuals who have entered pleas to this indictment and those who continue to languish in jail waiting trial for this indictment, as they are charged under a RICO count that includes cases dating back to January 25th, 2013. So we got to go back up. So basically, we were at this paragraph here where the prosecutors and Judge Glanville incorrectly advised Copeland about the law of derivative use of immunity and applicable statute of limitations, all in an attempt to coerce Copeland to testify. That's their purpose. Am I boomerang? Oh, I'm sorry. We're here. Did they make a new live feed? I'm going. Of course they're back. It's because it's a new feed, you guys. There we go.
Converse, and if there's anything that either team member is aware of that we need to provide, we'll provide.
Okay, thank you.
1.25 okay with you guys?
All right, see y'all at 8:45 on Monday, 9 on Monday. Yes, Mr. Sharp? Let's say 9. Y'all did such a good job today. I'm going to give y'all 15 extra minutes to sleep. 9 o'clock on Monday. Yes, sir.
Your Honor, I just wanted to bring it to the court's attention that I know that Mr. Weinstein has an outstanding motion that
This is
he
the
renewed,
beginning. This is all the way at the beginning,
maybe
you guys.
48 hours ago.
Which was,
Yes.
oh, no, I know. He has a supplement to that. And I thought I said this morning, that's what I'm going to be working on this weekend.
And I have some bad news for you.
What's that? You
As
have
we
more
head
to
into the
add?
week. Yes, Mr. Weinstein's a faster writer than I am, but
He is a good writer.
he is.
Very kind of you.
Welcome.
So I recently filed while we were in court, a motion, for a fair trial seeking remedies. Oh, and I will email, it was just filed. And I will email it over. Mr. Steele brought up the desire to have an evidentiary hearing on these matters. I know that
On which matters?
the ex parte communications and the impropriety.
Yeah, like wanting to cross-examine yes,
Calling
wanting
John
to
Melnick.
put Mr. Melnick's testimony. And yes, I had said that you could give me a proffer, and if you're ready to do that, we can do that.
Well,
Y'all don't want to do just a proffer.
Mr. Steele was spoke to Mr. Melnick, but yeah.
Okay, all right. So with regard to the motion, Mr. Sharp, that you filed within the last few hours, if you could email that to Ms. Persifield, I'll take a look at that over the weekend as well. Mr. Steele, if you want to be heard on I'm glad. Thanks for the reminder to circle back on that. I had said, talk to Mr. Melnick and you can put a proffer on the record. So if you're ready to do that, we can do that now.
I need more time because I did speak with Mr. Melnick. I told him what your honorable court said. He stated that it was very nice. He said that I does not give you permission for him. He'd like to address the court himself. Okay. That's what he told me. So I can't make a proffer because I don't have the information. I have him under subpoena, like I told you.
Okay. What do you have him under subpoena for? When?
2-hour call. 2-hour call.
Okay. Well, can you proffer to me? I know you can't say, here's what he would say, but how about tell me why it is that you think this is something relevant to this trial at this stage, considering that Judge Glanville has already been recused. And maybe y'all want me to, I have not finished reading all of the material and all of the case law. So I don't know what my decision is going to be on the supplemented motion for mistrial that Mr. Weinstein filed on behalf of Mr. Kendrick. Do y'all want, I will rule this weekend. Do you want to wait and see what that is? Or do you want to just tell me why is it that anything Mr. Melnick might have to say in defense of himself matters for the trial? It might matter for everybody's, what they feel about their professional reputation. I get that. But for this trial, why does that matter?
So under CAR, C-A-R-R versus state, it's a 19, I think, I don't know, 97 case, 98. It was the case that gentleman owned Heights Nursery, I think, the house burned down.
Yeah.
There's great language in there about prosecutorial duties.
All right.
And it talks about that the prosecutors need to, they carry the burden of, they can charge people, they can ruin people's lives just by the charge. And they have a duty to the public to be open and candid.
Sure.
So, and all lawyers do, but especially prosecutors. And Mr. Melnick, I know this because he did say this, and that's why he wants to address you, because he was not mad at me. He said he needs to have it on the record himself, because he said that what the state was saying is not accurate.
Okay.
And I think that that goes into your analysis of why there was a meeting in the first place. I don't think that it was appropriate, like, and I'm not picking on anybody, but like the Honorable Judge Krause said, if I was going to ask this Honorable Court for an ex parte meeting, I believe that the way I always have it is there's a buffer. You have somebody say, what is it about?
Yeah.
I tell you, and I have to be candid. And if I'm not, in hindsight, you would probably, I assume, or any court would tell me, you had no right to do that because you got it with false pretense.
Okay.
Mr. Melnick is going to say that what Adrian Love said to the judge is just patently not true. Via emails, her description of the emails is untrue. And there's no way to say that's inadvertent, because she said that on Friday the 7th versus Monday the 10th, she kept talking about these emails and she changes her statement. So anyway, I believe that it's.
All right, the best evidence of that would be, I'm sorry, I didn't mean to interrupt you, but just somebody give me the emails.
I did. I put it in my motion that I filed when I found out this Honorable Court was the court. And I forget what I titled, I can find out for you, but.
Okay, I'll go back and look at those.
It was a motion, it had two parts to it, and it said, I really don't want, and I told you, I don't want a mistrial. I just want to make it right, and I want the record to be good. So anyway, Mr. Melnick is going to take to task, and you'd make a credibility determination, Adrian Love, John Melnick's statements. He also adds that he states that he and his client, and he did not tell me, I said I don't want to know because it's attorney-client privilege, but he's going to work on it. He said, I assume that's a waiver. I'm assuming that with his client. He's saying that what Ms. Hilton said to the court and by both courts is not accurate also.
All right.
Then I have information that there's off, so it's not in the transcript. So Mr. Weaver is either not there or definitely not recording it, that Mr. Copeland did talk about the killing of Donovan Thomas, said it's not on the transcript. And that would be either Brady, if it's an inconsistency.
So wait, so that I understand what you mean, you are saying that you have reason to believe that in the June 10th ex parte meeting, once Mr. Copeland was a part of that he talked about the killing of Nutt at a time when Judge Glanville was in the room? Because there were definitely two different portions where at one point he and Ms. Bumpus talked privately, which obviously nobody recorded because the court, at least the record reflects the court reporter and the court and whomever left the chambers so that they could talk privately. So it's entirely possible he talked to her about that. That wouldn't be on the record and it shouldn't be on the record. Nobody else heard it. And then there was another portion where I believe the court left so that I don't know if it was you, Miss Hilton, or I think Miss Hilton, Miss Bumpus, and Mr. Copeland could talk together.
This has to be a mistrial.
Not privilege.
Okay, all right.
That there was substantive conversation about the.
Look at her ear. What is she doing with her ear?
Okay, so
And Ms. Hilton,
hang on. I'm jotting some notes for myself. Give me just a second. All right, and you have reason to believe that whatever Mr. Copeland said at that point in time in front of the prosecution is something that is Brady material.
impeachment.
Okay, impeachment, okay,
Which is.
and therefore Brady. Okay,
So that's why I wanted to put.
all right, thank you.
And call the prosecutors. Now, they may say that didn't happen, and I assume that's what they're going to say, because they would have a Brady obligation to run out and say, June, this happened, this man said this, but they didn't say that with anything, so I don't trust that the Brady was being complied. That's why I asked you again today, please, can you put some teeth into Brady, because Mr. Copeland did say on the record, I'm a liar. That is Brady. That's like the greatest Brady.
Well, you got that, so.
But I got that because.
I know, but you have it now, so it's not Brady, just like you just said.
But my point is, it was hidden on the 10th. How about that? By Judge Glanville and the prosecutor. They knew about it because they were in the room when that was discussed. That's objectively true. So anyway, I'm just telling the court, I was not there. I don't want to make specious allegations against anyone. That's why I want to get it right. And that's why I asked you to have an evidentiary hearing.
Okay.
I believe that there's Brady evidence. I have a good faith belief. I'm telling you everything I know. I'm told that it's not privileged, that Miss Bumpus, Miss Hilton, Mr. Copeland spoke, and it's not in the transcript. And Mr. Copeland was talking about his information on the killing of Donovan Thomas. Because you have to remember, in the statements, he has himself not involved. He has himself learning about from another person.
Right.
And my understanding is that is not what he said. That's inconsistent on June 10th. And I did not get that from Ms. Hilton. If that's wrong, but I can't ignore what I'm being told.
Okay, well, that's new information for this court, so.
That's what I wanted to call the witnesses, because.
All right, well, you didn't tell me that before.
Okay, well, I didn't mean not to tell you that, but I'm trying to be open, but that's the reason I wanted to call witnesses.
Okay, I mean, that's, okay.
Additionally, Your Honor,
Yes.
at some point, I believe, you're going to have to make a finding of fact on the propriety of these ex parte communications.
Oh, I know, that's a
And-
part of Mr.
Right.
Weinstein's motion for mistrial, yeah.
And I don't want to be a witness. I mean, I could say that there was absolutely no reason for it, and there was no cause for the state to even have these concerns, but Mr. Melnick can explain, if he was conspiring with me and Mr. Steele to obstruct justice, I doubt he'd want to come in here and talk about it, but the state can ask him about it and get to the bottom of it. But I don't think that's what the testimony is going to be.
Okay,
And I think that's important for the court to know.
Okay, well, I don't know that whether it's true or not is what matters. It's what it looked like at the time to the state to give them a reason to say to Judge Glanville, we have some concerns. We might like to talk to you about it. Just heads up, we're going to do some research. We'll get back to you.
And they said they didn't think that Woody was in
and by
fear.
the way, y'all, I know that everybody, whenever we were here last,
come on,
was that yesterday or the day before? Wednesday. So Tuesday, I gave y'all the transcript from the 7th. And Wednesday, a couple of people made some statements about, oh my gosh, now lo and behold, we find out there's been yet another ex parte we never ever knew about. And actually, when you go back to the transcript of the June 7th, 2024 court proceedings, on page 95, on the record, before court adjourns for the day, is when the prosecution says, hey, by the way, we might need an ex parte, or we need an ex parte. And then it is definitely still on the record in court where y'all all heard not the content of the ex parte, but that the state wanted an ex parte because people from the defense
say other things on the record after that. So in open court, y'all were notified that they wanted one. So, I mean, it's
Barely.
not quite the
We had to replay it to hear
salacious
it.
revelation that y'all made it out to be.
Can I respond to that?
Yes.
So as in the King case that the state is relying on, the state has to make a showing of necessity for public, the necessity for the public interest for the for immunity to be granted by the court.
Okay.
And I was under the impression, I think a very reasonable deduction was that they were simply going back there. And I agree, they did announce an open court and we didn't know the substance, but I think a fair, reasonable deduction would be that they were going back there to present the basis for granting
Okay.
immunity. Little did we know that they had already done that and they were going back there to have that other
Something
conversation.
else.
So
Okay.
that's.
Okay. Yeah, I mean, I know y'all didn't know the substance of it, but
And wrapping back around to that.
yeah.
I don't know if there was, but I'm assuming that under the King case, since it wasn't, I guess, that afternoon of the 7th, maybe it was prior to that, maybe it was in the morning, maybe it was the afternoon of the 6th, but at some point under King, there would have been some type of an ex parte meeting where the state presented the reason that they needed that immunity. I don't know if that was done on the record, if there was a transcript of that, but if there was, we have not received that either.
Well, there better not be anything else that
Well, how did they
Occurred
get?
as a meeting, because I told everybody on Tuesday, stand up and tell me anything there is. Did y'all do anything beyond the motion to get the immunity order for Mr. Copeland?
No.
Okay,
So we submitted a motion.
right. And they have a copy of that, and that's it. All right.
Right.
Okay.
That was,
Okay.
and Judge, I also state that at the time, I'm not certain why it would be believed that we were trying to get the warrant or the immunity agreement because Mr. Copeland was under arrest at the time that we stood up and made that announcement in court on the 7th. I think he had already been arrested, I
Well,
think.
you could be arrested and not have immunity for your testimony.
The judge had already told him he had immunity on the record.
Okay, well, I don't know. I mean, they're probably just trying to remember it themselves too, but. All right, well, Mr. Shard, I'll take a look at your new motion. And obviously I'll be looking at Mr. Weinstein's motion. And why don't, Mr. Steele, you plan to have Mr. Melnick here at 9-ish. I don't know whether I will hear from him or not, but, okay.
And Your Honor, so that we are, I'm understanding is on Monday, we're having the matter that Mr. Steele wants to present Mr. Melnick for.
Maybe.
Would that be a collateral issue of?
Maybe.
Okay. So,
So if I end up hearing from the two of you on that, I'm not gonna make you not be prosecutors in the case anymore. We can hear that separately if I even hear it.
And, okay, and so would Mr. Steele be allowed to introduce extrinsic evidence of a collateral issue that he's raising about the emails and things of that nature?
I mean, the emails are already in the record. I think he's complaining that at one point, I mean, the emails are what they are. And at one point you said, this was an email to me. And at another point you maybe said, I accidentally got copied on this email, but I think it's actually different parts of the email. I think there's actually an explanation for why that might sound inconsistent, but I'll go back and look at all of the transcripts. But beyond that, I mean, no, I don't think so. I don't know what he's got planned. Maybe you want to ask him, but I don't know if he's talking to you yet. So I don't know. We'll take it up Monday. All right,
One last thing, Your Honor. On Tuesday, I believe I brought to the court's attention whether or not the court would allow, if we get to Mr. Copeland next week, I know you said the jurors might not come back until Wednesday.
right.
Substitution of counsel. And
Uh-huh.
wanted to see if the court had made a decision or a ruling.
Oh,
There was one
so-
objection.
Yeah, I
People
never got any
questioning
kind of
Copeland.
written anything or further objection from anybody. So I think there's just the one objection that I didn't get a real good reason for. Okay, yes, there may be a substitution if we end up examining him while you were gone. Thank you, Mr. Weinstein. All right, we're actually in recess now.
Are we? Are we for sure? Guys, oh my God. So Melnick wants to call Love a liar. Steele says that on June 10th, in that June 10th meeting in Chambers, whether it was captured on the record or not, in the presence of somebody else, because he said it was not attorney-client privilege. Someone else had to be in that room while this was happening. Woody said, Kenneth Copeland said, he killed Nut, Donovan Thomas. Shout out to the lawyer you know.
What's up, everybody?
What's up, everybody?
We have some
We'll go
answers.
over. Shout out to the lawyer you know. I hang out over there sometimes, a lot of the time actually. Well, technically I did log out. The Law and Crime stream had ended, you guys. That was a new feed. They had to create a whole new feed to go back live on the record for that. And thanks to the chat for blowing me up for like, what, that was like 11 minutes. You guys were like, they're back, they're back. I'm just over here reading this motion, stopped on letter E. I'm going to clip this motion reading too. I might leave the 15-minute Law and Crime, 30-minute Law and Crime clip in there too in the middle so you guys can see me, boomer. But yeah, I wouldn't have known without you guys. Like, this is crazy stuff. Yeah, totally love Big George, the lawyer you know's dad. So the lawyer you know brings his dad on once in a while. They're both in law. And Big George used to be a prosecutor, I think, right? For many years. And now they have their private practice. And really insightful. And they don't always see eye to eye. So they get to disagree in a very, like, mature, loving, insightful way. Really, really cool. Yeah, I guys, come on. If Deputy Brown was in there, it could be coming from Deputy Brown. So Kayla Bumpus did say she's not exactly sure about certain things that were said when nobody else was in the room or somebody was in there or what would have been on the record or not. She said she would have to double check. And again, if she's the one that would have been in the room the whole time, out of anybody, she would be the one that might not be the most sure about who was there at a certain time when someone was trying to talk to her. Because there's a lot going on. There's a lot of movement. So she did qualify that, you know, she thinks they were complete because there may have been other things that might not have been recorded. And then let's see. Thank you so much earlier, Jose Guzman. Great streams today. I mean, technically it is great streams now. We've had 2 long crime streams on here because they had to cut back up. Miss AB says these lawyers are earning their fees, especially after that. And then she's like, get the heck out of my court. She almost tried, was that about like 3:45-ish? She thought they were going to be done. It looked like she was ready to wrap up. And then Love said she had one more thing to address. And then something while they were dealing with the headphones, trying out the headphones, somehow we get back on the record. Maybe Shart mentioned that motion was filed or whatever. Thank God Law and Crime, the media pool, didn't rush out of the courtroom. And then also, take all my money. I'm the non-lawyer earning my fee, Miss AB. I appreciate you so much. And what do you guys think? What do you guys think about Judge Whitaker's reasoning that because Love said we want to have an ex parte, that kind of makes it okay? Because the standard is the state is supposed to provide their basis for requesting an ex parte and why it should be ex parte. So is it sufficient for someone to just say we're requesting an ex parte and then not state your reason while you're making that request? Because that reason isn't on the record in that moment when Whitaker is asking for them to have objected at that moment in time. So them hearing it is a problem, right? Did they actually hear it? But two, shouldn't they have put their reason on the record? Why would the judge have allowed that at all without a reason being given? So I don't know. And then, the whole prompt disclosure issue just stacks onto that. Thank you so much, you guys, for saying it over and over that they were live again. We could finish out this motion. I do want to scroll and peek. We are on page 10. Is there an exhibit? Okay, so this looks like all motion. So he didn't attach the actual motion that was drafted and eventually signed to get this immunity in place. So I don't see that as an exhibit. So I'm still interested in what that says. But we did see a little bit of hinting from Shard about what was in that motion for the immunity order. And yeah, Monday's going to be wild. By the way, you guys, on Monday, I will have to do 2 halves. I will break at noon Eastern time, which is usually when they're doing their lunch, and come back. So we'll do a morning and afternoon type of stream on Monday. Because I have a meeting that I booked for Monday about this. The same thing I talked about earlier in the stream. These DNS records that aren't properly set up, and they're sending a business's email to spam every time they're trying to contact clients. Not good. Definitely an emergency issue. So we're going to sort that out between morning and afternoon sessions on Monday. I think that'll be good too, because it'll make the sessions more digestible. But let's go on with this motion here. We left off at E as a new item, where the prosecutors and Judge Glanville incorrectly advised Copeland that he could be held in civil contempt indefinitely if he failed to testify, all in an attempt to coerce Mr. Copeland to testify. Judge Glanville abandoned any semblance of neutrality and worked in concert with the prosecution by advising Mr. Copeland and Copeland's attorney about legal matters, all to cause Copeland to testify. G. Judge Glanville assisted the prosecution in the preparation of Mr. Copeland as a state's witness, instructing that a list of questions prepared by the state be provided to him. We have a footnote here. As the prosecutors and Judge Glanville have claimed that this transcript captures the entirety of the ex parte communications between the state and Judge Glanville that day, it is entirely unclear how Judge Glanville even had knowledge of the state's list of questions for Mr. Copeland, as the discussion of this is not found earlier in the transcript. Boom! Add this in with what we just watched. And H. A significant amount of Brady material poured out in this meeting, but the same was hidden from defense. Neither the existence of this meeting nor this Brady material was revealed to the defense until the transcript was finally released. The June 7th, 2024 ex parte meeting. On July 30th, 2024, the Honorable Judge Whitaker presided over substantive matters of this case for the first time. The Honorable Judge Whitaker provided much needed clarity to the defense by releasing the rough draft of a transcript of additional ex parte communications between the prosecution and Judge Glanville. This ex parte meeting occurred on June 7th, 2024, and included Love, Hilton, and Judge Glanville. These communications, and the substance thereof, had never been disclosed to the defense until the Honorable Judge Whitaker released the transcript. Neither Judge Glanville nor the state ever made any disclosures regarding these communications, even as Attorney Steele pulled the curtain on the July 10th, 2024 meeting. Instead, Judge Glanville and the state remained silent on this topic. Additionally, while the parties were well aware that the Honorable Judge Krause was considering the advisability and potential implications of June 10th, 2017, as part of her consideration of motions filed to recuse Judge Glanville, upon information and belief, neither the prosecutors nor Judge Glanville ever revealed to Judge Krause that there was, in fact, another ex parte meeting that occurred 3 days prior. This was their secret. So I said earlier in the chat, and you guys caught it too, Judge Krause, in finding that the meeting was pretty much proper, although maybe it should have happened in open court. She wasn't aware of this context when she made that finding. The transcript of the June 7th, 2024 communications is shocking. It also sheds light on how this case has become irretrievably broken. As an initial matter, there is no stated justification for the ex parte communications. The meeting was initiated by the state. Neither Copeland nor his counsel had requested that the state meet in private with Judge Glanville. The meeting itself was illegal. The state, in this meeting, intentionally and wrongly attacked the character of Copeland's attorney, Melnick, claiming that Melnick was not representing Copeland's interests. The prosecutors besmirched Melnick to Judge Glanville without cause, all because Copeland was not interacting with the prosecutors in a manner they would have preferred. The prosecutors claimed to be the only ones who were truly representing the interests of our witness. The prosecutors complained that they had been having productive communications with Copeland outside the presence of Melnick, and the footnote says, while the state has maintained, at least at times, they did not realize that Mr. Copeland was represented by attorney Melnick when speaking to him, this excuse is difficult to accept. Their story also has changed. At times, they didn't know. At times, Melnick told them he didn't represent Copeland. At times, Copeland told them that Melnick was not his attorney. At times, Copeland never asked to speak with Melnick. The explanations are all hard to accept. Love has prosecuted Mr. Copeland in case, and he gives the case number, which was resolved on June 29th, 2023. Melnick represented Copeland on this case. Melnick's representation of Copeland is also openly discussed in interviews, which were provided in discovery. Additionally, the fact that Melnick also represented Copeland's interests as a witness in this case was always fully understood by undersigned counsel, as Copeland faces legal exposure in this case. The defense has always acted appropriately and has refused to initiate any conversations with Copeland, who was known to be represented with Melnick without Melnick's knowledge and approval. Melnick's representation of Copeland was no secret. That was a long footnote. If we go back up here, talking about they had productive communications with Copeland outside the presence of Melnick before Melnick had, quote, inserted himself in his client's legal affairs. The prosecutor's claims that Melnick was not representing Copeland's interests is rich, as they were communicating with the person behind Melnick's back. The state had intended to call Mr. Copeland as a witness without granting him any sort of legal protection as a witness. It was only after Melnick inserted, in quotes, himself and advocated for his client that the state sought to grant Copeland derivative use immunity. The irony doesn't end there. The state, in this meeting, claimed to be concerned about the possibility of Copeland suffering an unjust jail sentence due to Melnick's interference in his client's affairs. At no time, however, did the state ever seek any non-custodial alternatives for Copeland, should Judge Glanville hold him in contempt. And you guys called that all the way out. They were the ones that wanted to put him in jail, but in that entire June 7th transcript, they're acting like, we don't want him to go to jail. Everybody else is the one that's out to get him. Instead, these prosecutors insisted on an indefinite incarceration for civil contempt, which would have been illegal. The state also questioned Melnick's devotion to his client, as Mr. Melnick was planning to leave the state on vacation while his client was incarcerated for contempt. The state complained to Judge Glanville that Melnick had not planned his vacation around Copeland's testimony. This is a ridiculous accusation, as the state intentionally failed to communicate with Melnick and had not given Melnick any notice that they were planning to call his client to testify on June 7th. We have a footnote here that upon information and belief, Melnick had already purchased non-refundable tickets for a trip to Alaska, which was to commence that coming weekend. Perhaps if the state had not cut out Melnick from their communications with his client, he would have been able to schedule his trip accordingly. So, okay. The state was clearly only concerned with Copeland's interests as long as they were directly aligned with their own interests. The state feigned interest in Copeland's well-being to get a foot in the door to Judge Glanville's chambers, all in an attempt to initiate improper ex parte communications. Melnick was not the only attorney who was disparaged by the state and Judge Glanville in the secret June 7th meeting. Love claimed that she was in receipt of an email from Melnick sent to her and Hilton, but also that other individuals had been, quote, blind copied on the communication. The clear insinuation from the conversation is that it was Attorney Steele and undersigned counsel who were blind copied. We get a footnote about these emails. Love goes on to say that her immediate response to this email was to ask Melnick, whose interests are you concerned about, your clients or Mr. Steele's and Mr. Shard's? Undersigned counsel does not make blind accusations, but neither undersigned counsel nor Attorney Steele were blind copied on any email between Love and Melnick. Later in the ex parte meeting, Love again brings up Attorney Steele and undersigned counsel, noting that we were included on a June 6th, 2024 email from Mr. Melnick, so Thursday. Love and Hilton were also included on this email, in which Melnick expressed his client's decision to exercise his Fifth Amendment rights if called to testify by the state. This footnote here says, undersigned counsel confirms that this email was sent to Hilton, Love, undersigned counsel, and Steele, and asserts there was nothing improper about this email. There's absolutely no requirement that Melnick limit his communications to the state, the very same people who excluded him from communications regarding his client. It is unknown why Love feels that she should have a monopoly on information. or why she feels that defense attorneys should not be included on discussions concerning these matters. Undersigned counsel would like to inquire about these matters with Love, sworn in as a witness, so Shard wants Love on the stand. Ooh. Do you think Love already read this? And this is why they made the court go live? Judge Glanville abandons any impartiality and echoes Love's thought, asking, quote, why would he, Melnick, have done that? Given, and then before ADA Hilton responds, and that's the state's concern. Love then affirms, that's the point. As Judge Glanville had questions, so do I. Undersigned counsel asks why my inclusion in the simple email communication was of concern to the court. Love then assures Judge Glanville that she is looking for a remedy for this materially false and made-up situation, as if one exists, and tells Judge Glanville that she will contact him when she finds a solution, either over the weekend or on the coming Monday, presumably through additional ex parte communications. And then footnote 12 says, it is unknown to undersigned counsel if the state and Judge Glanville had any further ex parte communications over that weekend, but we are now aware that an additional ex parte meeting occurred on the next Monday, June 10th, 2024. So is there more that took place this weekend? What about the questions we plan to ask? So, where was this footnote? Up here. Before wrapping up the illegal and unethical meeting, Judge Glanville refers to outside agitators affecting the trial, stating, I mean, but I see it from just being in the courtroom and tracking. Judge Glanville's concern and inherent skepticism of email communications between Melnick, Attorney Steele, and undersigned counsel exemplifies Judge Glanville's bias and partiality towards the state. The transcripts of both the June 7th and June 10th ex parte meetings show Judge Glanville's clear bias against Attorney Steele and undersigned counsel, and finally provide an explanation, albeit an unacceptable one, for Judge Glanville's treatment of the defendants and their counsel throughout the trial. The illegality of the ex parte meetings now known to the defense, and we have a footnote in this header. The defense is not aware of any additional ex parte meetings that have occurred at this time. That being said, the defense is not all that confident that these are the only two illegal ex parte meetings that occurred between the state and Judge Glanville. We now know that 2 ex parte meetings have occurred. These ex parte meetings were clearly illegal and improper. The state relies on King v. State, 2000, in a specious attempt to argue that these ex parte meetings were proper. The state's reliance on King is misplaced for several reasons. First, in King, the state met with the court to provide information that would allow the court to make a judicial determination as to whether the anticipated testimony of the witness was, quote, necessary to the public interest, as is required under law. In this case, Judge Glanville had already conveyed derivative use immunity to Copeland earlier on June 7th, presumably in a third, albeit first time, ex parte meeting. There is no indication that the witness was present for the meeting. In King. So, in King, this is why King is different. There's no indication that the witness was present for the meeting in King. While the actual forthcoming testimony expected of Copeland was openly discussed in Copeland's presence in the Star Chamber June 10th meeting. Second, in King, the defense never alleged that they were not informed of the substance of the ex parte meeting in a timely manner. In our case, purposely hid this information, this illegal and unethical conference, from the defense. So, distinction. The fact that these meetings occurred, much less their substance, was only revealed due to the doggedness of the defense and sheer happenstance. Third, while the subject matter was limited to, quote, the necessary to the public interest requirement of OCGA 24-5 of 507 in King, the subject matter of the June 7th and June 10th ex parte meetings included much more, including specious and knowingly false allegations made against defense counsel and by relations the defendants themselves. These improper ex parte meetings are the result of both grave prosecutorial and judicial misconduct. These meetings were never requested by Copeland, Bumpus, or Melnick. Instead, they were all initiated by the state and welcomed by Judge Glanville. These meetings, when considered with other previously discussed actions of the prosecutors, and Judge Glanville in this case, violated Mr. Stillwell's constitutional rights to due process and a fair trial. These meetings, especially when considered in addition to Judge Glanville's other actions throughout this trial, have also violated Mr. Stillwell's right to a fair trial. There's a bunch of typos in this, guys. He ran out of this court to get this filed, for sure. We saw him run out. In front of an impartial judge. The transcripts of these meetings reveal that Judge Glanville, perhaps based on inaccurate and misleading information provided to him by the prosecutors through ex parte communications, always looked at Attorney Steele and undersigned counsel, as well as our respective clients, with suspicion. Judge Glanville, in meeting with, consulting with, working with, and planning with the prosecutors clearly abandoned any semblance of impartiality. Both of these meetings occurred during critical stages in this trial. Mr. Stillwell had a constitutional right to be present. So, and here we have Article 1, Section 1, Paragraph 12 of the Georgia Constitution and the corresponding section in the U.S. Constitution. And then Scudder v. State. As Mr. Stillwell nor his counsel were permitted to attend these meetings, Mr. Stillwell's 6th and 14th Amendment rights of the United States Constitution and Georgia Constitution were violated. This is a structural error which will demand reversal, should Mr. Stillwell be wrongly convicted of any counts in this indictment. Remedies. So what do we want? Mr. Stillwell has been harmed by judicial misconduct, prosecutorial misconduct, and other error in this case. Focusing solely on the ex parte communications, the prosecutors and the trial judge teamed up to coerce and intimidate Copeland to change his mind and testify for the state. Copeland's testimony was harmful in itself, but does so much more than that. As a result of this coercion and intimidation, the state has, and plans to continue to impeach Copeland with his prior inconsistent statements, essentially playing several videos of Copeland's out-of-court statements, which are harmful and prejudicial to Mr. Stillwell and others. These out-of-court statements involve several of the charged events and counts in this indictment and are central to count 2 of this indictment, which alleges that Mr. Stillwell committed the murder of Donovan Thomas. Guys, this is great going hand in hand with that afternoon jumping back into court we just watched. Mr. Stillwell does not wish to demand a mistrial, absent a finding of goading, and thus jeopardy attaching. So we only want this mistrial if there's no retrial. Mr. Stillwell has been incarcerated throughout the duration of this case. He has been viciously attacked while incarcerated. He almost lost his life. Starting trial all over again is not a viable option for Mr. Stillwell. Despite the persistent legal errors, the illegal actions taken by prosecutors and the previous trial judge, and the damage inflicted by the presentation of Copeland's prior untruthful out-of-court statements, the defense is winning. Additionally, this trial is already tainted by structural errors. Mr. Stillwell does not wish to submit to the desires of the state and Judge Glanville, who have attempted to goad Mr. Stillwell into moving for a mistrial. Mr. Stillwell does not want this case to start all over. Nonetheless, serious errors have tainted this trial. It is unacceptable that Mr. Stillwell must accept that the first several months of this trial have been tainted by prosecutorial and judicial misconduct, illegal ex parte meetings, and a partial judge. It is unacceptable that Copeland's out-of-court statements, which are arguably admissible as a result of the previously discussed illegal ex parte meetings, should continue to guide this case. Judge Glanville's hostility towards and suspicion of undersigned counsel has likely created a lasting impression on the jury, who surely view a trial judge as a person of authority. Carrying on with this trial as if nothing improper has occurred is not an acceptable option. The structural errors and other legal reversible errors in this case must be considered in the context of how they occurred. All of these errors have been caused by the prosecution and Judge Glanville. Neither Mr. Stillwell, undersigned counsel, nor any co-defendants or their counsel have caused or invited any of these issues. Hilton is a seasoned prosecutor of nearly 15 years who holds the title of Deputy District Attorney in the Fulton County DA's office. Per the District Attorney's website, she helps lead the Special Victims Division. She has received many awards with the District Attorney's Office and also has taught trial technique classes at Emory University School of Law. Love is an attorney with almost 20 years of litigation experience, almost exclusively as a prosecutor. Attorney Love is a Chief Deputy District Attorney of the high-profile cases and difficult witnesses division within the Fulton County DA's office, and is part of that office's executive team. She leads a division in the largest district attorney's office in the state, one that is dedicated to cases involving difficult witnesses. The Georgia Court of Appeals has noted that state prosecutors are generally knowledgeable and well-trained, too knowledgeable and well-trained not to know the consequences of basic rules of prosecutorial procedure and conduct. That's Wilson v. State. Prosecutors, as recognized and experienced as Hilton and Love, should certainly be held to this minimal bar, if not much higher. Surely Hilton and Love, with their knowledge and experience, knew the impropriety of these ex parte communications. Their experience told them something else, however. Based on their knowledge of the law of impeachment and prior inconsistent statements, the prosecutors knew that if Copeland did not testify and remained in jail, even a partial judge would be hard-pressed to allow the jurors to hear the multiple hours of Copeland's recorded statements. Here's the why. The ex parte meeting was a calculated risk for the prosecutors. Either Copeland would be intimidated and coerced into testifying, or the illegal ex parte communications would be grounds for a mistrial, and the state would have time to regroup and begin anew. So they have a win-win if you think about it for the state. So the risk is worth it. Judge Glanville currently serves as the chief judge in Fulton County Superior Court. Per the Fulton County Superior Court website, he has been a lawyer for 37 years and has served as a judge for 29 years, 19 of which as a Superior Court judge in Fulton County. Judge Glanville knows the rules concerning ex parte communications, both in the Uniform Rules of Superior Court of Georgia and the Georgia Code of Judicial Conduct. Based on the experiences of prosecutors Hilton and Love, as well as the experience of Judge Glanville, the notion that the decisions to hold these repeated, secret, illegal, and unethical ex parte meetings were due to inexperience or simple lapse in judgment does not pass any test. He used the language, you guys. Doesn't pass any test. These were conscious decisions. Shout out to yesterday's court moment with Kayla Bumpus with the stare down of prosecutors Love and Hilton. These were conscious decisions to secretly violate the most basic of Mr. Stillwell's constitutional rights. Several factors in this case, including the prosecutor's and trial judge's wealth of experience, the egregiousness of the prosecutorial and judicial misconduct, the facts that the evidence presented so far have been far from overwhelming, the structural and reversible error already baked into this case, and the repeated violations of these rules all clearly support a finding that their actions were intentional and designed to go to mistrial. So we have State v. Jackson, Anderson v. State, and Wilson v. State. Conclusion. This case is constitutionally and legally broken at this time. Mr. Stillwell is not requesting a mistrial absent a finding of goading, but appropriate remedies must exist. Possible remedies include, but are not limited to, disqualification of the prosecutors involved in this misconduct, as Glanville's already been recused, the dismissal of this indictment with prejudice, instructions to the sitting jury that explaining the situation in full candor and or a mistrial, with the finding that a mistrial caused by judicial and prosecutorial misconduct, and the defense was goaded into any such request. Wait, judge is back. Don't do that. I'll flip back over. Wherefore, undersigned counsel respectfully requests this court considers Mr. Stillwell's arguments and issue an order which will fully and adequately protect Mr. Stillwell's constitutional rights. Respectfully submitted, Max Shart, in the middle of the court day, running out of there to submit this document. What do you think, you guys? I mean, this is some heat, some energy if we're considering what we just heard on that part 2 of today's court hearing. This is a lot of stuff. And don't make me double check. Do we really have the court back? But yeah. So, we have Brian Steele saying Kenneth Copeland did in fact say in the Star Chambers meeting at some point that he killed Nutt on June 10th. We also have Melnick saying that Love is a liar. And we have Max Shard. This new, well, was it a renewed motion? Yeah, his renewed motion for a fair and constitutional trial and appropriate remedies. Laying it all out. It's possible we'll get more motions than just this. So maybe some weekend streams, you guys. But what do you think about this? We're all caught up with everything I see today. This is a lot of stuff. I love Doug Weinstein's argument too during that court part 2. And then thank you, Garrett S. Garrett S. for the 2 said before, if Melnick testify, he should go public. Yeah, and he jumped on a stream with Kayla Bumpus, spoke for like a minute or 2 and jumped off. He didn't try to say anything, talk about it. But get him on the stand, see what he's got to say. What do you think, you guys? Can we in the chat show some love to the mods? Jason's been in here, Drea's been in here, Casper the Ghost has been in here. I love all 3 of them. You know, I'm so grateful that they're mods here on this channel, but I love all 3 of them in different channels and I get to hang out with them in the chats. They've been here all day hanging out and that's crazy to think about. So big mod scream in the chat. And I'm not saying mods because mods, we need you. Something's happening. The mods are like the bailiff of YouTube chats. Yeah, and oh my God, Sapphire Ridge, good to see you. That's a great point. Remember that Judge Glanville said he will make any redactions as necessary. Did he? Did he? Yeah, look at all the love there. There we go. Shout out to the mods. Shout out to the mods. Yeah, it's so great in here. Look at that. Oh, we got gifted memberships. We're going to shout out Jen too. Shout out Jen and the mods. Jen, thank you so much. And guys, you know the story by now. If you are now a member, obviously say thank you, but now you have Mario Kart emojis. You can pick a member emoji and race in the chat. Yeah, we love the mods here. I love the mods in other places too. Yeah, look at all the love. Oh, thank you so much, you guys. And then love for Jen also. Look at that. Mod squad. There we go. Jen and the mods. And I do also, we can close out. We were all caught up, but we can close out. Have you guys met kattnotwilliams? This is kattnotwilliams. The other kattnotwilliams. Probably the better and more lovable Cat Williams. This is Moses Dupree's cat, named kattnotwilliams. Look at what a handsome guy. So the real Cat Williams has two of us to compete with. So there you go. I think we're all caught up. We are ending on an adorable note, if you ask me. Oh, we've got another one. Toothless Tiger. Thank you so much. Toothless Tiger says, Judge Biasville gave use immunity the morning of 6/7. They had to speak between the email on 6/6 and before court on 6/7, which caused the problem. Which means, this is so true, so thank you for the reminder. Guys, that means all of that mess we saw on Friday, when Melnick's in the courtroom, and Love is up there huffing and puffing up to the podium. Like, think about that now in the sandwich of all of this context. It never gets any better, and I'm excited to see if Judge Whitaker even concedes that it's even this much improper. But thank you so much, Toothless Tiger. Thank you so much, Miss AB. Thank you so much to the whole chat, Julie, Ghost, Kay Baker, Lil Meat Sack with the fire cards, Drea, of course. Ghost, if you're out there, there you are, Ghost. And everybody in the chat, thanks for making this a 9 hours, but a great time all around. Thank you so much. Nick Starrow's stream starts in 20 minutes. This will redirect you there. You can hit the notify button. I'm going to get something to eat, catch up on some stuff, and I'll see you over there on the panel show. You guys all have a good one. Take care.